Launched in 2019, BW Legal World is a community of BW Businessworld, a 4-decade-old publication that has since consistently ranked amongst India's largest and most respected business magazines. If I may request everyone's kind attention towards the big, beautiful screen once again, I'd like to play the BW Legal World Community AV. BW Businessworld, led by Dr. Anurag Batra, Chairman and Editor-in-Chief, BW Businessworld, an Exchange for Media Group, is the fastest growing business media house in India. With a network spanning across 23 niche business communities and magazines, BW Businessworld is proud to be entrenched in various verticals in the domestic as well as global business ecosystem. With changing times, BW now has a massive readership in the digital space as well. BW in its portfolio has 23 niche B2B communities that organize conferences and forums to facilitate interaction between sectoral business leaders and create a conducive environment for collaboration. I request everyone to join the online conversation by using the hashtag BWLegalWorldGLLS. You can also watch us live on www.bwlegalworld.com and all Businessworld social media platforms. Ladies and gentlemen, we appreciate everyone's presence here today. We are delighted to seize this moment to inform you all about our upcoming significant event, the GC Conclave. Scheduled for July 9, you will find the QR code for registration placed on your tabletops. Without further ado, let's quickly take a look at the GC AV. Before starting the day, we would like to extend our deepest gratitude to our partners, knowledge partner, Lexorbis Law Firm, our event partners, joytravels.com, Pandrum, Beanley Coffee, Just Bath AI, The Thick Shake Factory, Reality, Exchange for Media, IWMBuzz.com, Impact, and Pitch. And now, ladies and gentlemen, without any further ado, to deliver the opening address, please welcome Dr. Anurag Batra, Chairman and Editor-in-Chief of BW Business World and Exchange for Media Group.
Morning, it's my honor and privilege to be at the 4th edition of the BW Legal World Global Legal Leaders Summit. On 12th December 2019, we did the first one, so we've traveled some distance, but we have a long way to go. First of all, my gratitude to Shri Lalit Bhasin ji for always making time. And he just shared with me that he came at 10 p.m. or 10:30 p.m. in the night from Goa. And we know that whatever he gets involved with, gives his best. He was also our jury chair for our GLLS, cohort 4. So please give Dr. Lalit Bhasin a big round of applause for constantly giving his time, commitment, his wisdom to us and to the community. I remember when about 12 weeks back, the government announced a decision to allow foreign law firms into India. I talked to Garima and I said, we must introduce Dr. Lalit Bhasin, and I normally don't don a BW Legal World hat, but I did the interview and it was a pleasure for I enjoyed doing that and I learned something. And I can only say that we are grateful, and I'm sure everyone in the fraternity appreciates and is grateful for the introductions that you make. You are a stalwart in this industry. You spent more than almost 6 decades in this. I don't know what I'll tell the practitioners of legal services, the future of legal services, but I'm an entrepreneur, I'm part of Businessworld, so I have a point of view on what's happening in business. And BW Legal World is a community that is at the confluence of legal services and business. So let me, from my own understanding of being part of the legal community for the last 4 years, being an entrepreneur for the last 22 and a half years, let me share my quick view on what is happening in the legal services domain, what is the future of legal services. When we talk of future of legal services, we cannot talk about future of legal services in isolation. I also see my friend Alishan, who has been my lawyer for a long time, maybe 16, 17 years, and won a very critical litigation for us, better than what we expected and better than what we hoped for. And I can only say that I started my entrepreneurial journey because a lawyer gave me 70 lakhs 22 and a half years back to start my first company. A friend of mine, Alishan, knows who I'm referring to. So I'll tell you from the vantage point where I am in business. If if business is changing, if business environment is changing, every service or every component of the business needs to change. My first trend that I see happening with what's happening in technology, AI, in business, then when it comes to law firms in the next 3 to 5 years, I'm not an astrologer, I'm not a futurist, but in the near future, it could be 3 years, 2 years, 5 years, that when we talk of law firms, half of the people or more than half of the people at law firms will not necessarily be lawyers. It's already started to happen. There'll be domain experts because our theme is solutions. Our theme is how do we catalyst to business. So in the new reality, the composition of legal teams is getting transformed alongside the business. As processes are improved and standardized, and as technology enables new strategies for sourcing legal services, and as demands intensify to do more with less, the traditional legal function hierarchy will likely morph into a more agile and cost-effective structure. So, use of automated solutions, chatbots, and other forms of productized legal services will increase. And these will need support from lawyers as well as more multidisciplinary workforce with different skill sets will be a large part of the front-facing team of law firms. In fact, the proportion of legal work done by paralegals, data analysts, operational experts, and other specialists in the legal function might rise to the point of where legal professionals may almost become a minority in a law firm. It is a possibility, The possibility of my growing here is almost zero, but this one is strong. Second, over the last 4 years, I've heard this word at our conferences, is contract life cycle management. Now in large firms, small firms, we talk of ERM, we talk of CRM, but I think CLM will be as ubiquitous as ERM and CRM. By 2025, every organization can rely on their contract lifecycle management to be the central source of truth for all contracts. Many organizations today already have done the work to centralize their finance and resource-related activities within single systems, as well as their customer relation and sales. Centralizing how they manage contracts from negotiation to execution and after termination will similarly boost the organization's ability to reduce costs, manage risk, and improve performance. And some of what I'm saying is also applicable to the in-house legal functions, while I'm primarily talking of law firms. Now, no service can be complete without tech. In future, while human beings and professionals in the advice that you get from the wisdom of having practiced the craft and understanding the culture cannot be replicated through technology. But then, so my third theme is there'll be no line between what is a legal and legal tech. There'll be no line. Enterprise technology continues to broaden out into legal functions, blurring the line between legal tech providers and just tech. As 2025 gets closer and digitalization of legal functions continues, organizations may increasingly eschew high-cost standalone technology that serve specific legal niches. Instead, they look to larger providers for solutions to mesh holistically with the broader technology ecosystem. Like medical tech and fintech providers, legal tech providers will either cease to exist or be subsumed by bigger players with broader offerings. I can go on. Fourth, legal teams will be measured. They already are. I'm not saying they're not, but I think it will get accentuated. Legal teams will be measured. The law firms will be measured. The in-house counsels will be measured on strict KPIs such as the money they make from the business. I have some general counsel friends who already tell me, oh, I made 6,000 crores for my company. It's a very large company. It's a 1 lakh crore company. So, 6,000 crores is not an exaggeration because they saved that money in a litigation. If the award had gone in the other way, they would have need to pay that, right? So legal functions are transforming from defenders of the business to drivers of financial results. They value the value. So as in-house legal functions become, profit centers. I mean, not everything in life has to be a profit, but as you create financial value, the law firms will also need to morph. Um, Now, you come to a restaurant in Imperial, whatever. In any service business, the word experience is used a lot. Any, you take any service. I think in the legal services, client experience will become even more important and will again come back to the heart of legal delivery. The more personalized, more user-centric experience. And again, I'm talking corporate law. Of course, individual, you know, litigation is another issue. But in this room, BW legal world, so client experience will be at the heart of. Um, I want to. We already running late, so I'm not going into detail. All the 6 point that I want to make is all standardized legal work will be permanently subsumed in the businesses. This is more on the legal function in the corporate. Pressure to reduce costs and growing comfort with automated solutions will likely combine to see routine legal work move out of the legal team side and into businesses. Any legal processes that are not bespoke will be automated and self-service enabled. And again, these are trends. Some of them are already visible. Law firms are doing it. The in-house counsels are doing. The contracting process will go completely online. Slashing time to complete deals. Right now, the time that is taken to do deals is a little longer, and the contracting process will go completely online, and it will slash time to complete deals faster. Uh, Now, in any, law firms are large. Some have 600 people, 200 people. I meet 100 people, law firms every now and then. I meet a partner or a founder who has 80, 100 people. They started 2 years back, 3. As with legal operating models undergoing tremendous change, it's important to recognize the amount of potential effort that's needed for success. Hence, managing culture and shifting mindsets will be essential. So the law firm of the future will be a lot like what it has been in the past, but how you manage the culture at the law firm, how do you change the mindsets of young lawyers, and more importantly, people who are in the firm for a longer time will become. My last point. These days, even when we do our how we define our editorial products, we are very clear. BW Legal World is the homepage of GC. GC's law firms are our core. We're not about what happens in lower courts, that we leave to other people, right? We're about what happened in the law firm, what happened. However, so the journal counsels are at the top of the food chain, if I have to say. Law firms are equally important. But the legal, in future, you'll see in large organizations, the legal chief operations officer will be as important as general counsel. General counsels operate on wisdom, relationships, perspective, and that will be important. But operations of how the legal process is done, and they're already in the US, in Europe, the legal chief operation officers will be just important as general counsel. So I just want to say that, and I don't want to overemphasize the fact that in almost every kind of sourcing, there is a sourcing head, there is a commercial head who negotiates. We are in the media business. We believe what we have is unique, it's not comparable. But still, when we sometimes do businesses, some of the evolved organizations, they have a buying head. So a certain person commissions us for a project, but the commercial negotiations are done by someone who may or may not understand the unique, personalized, specific, differentiated nature of what we bring to the table. And that's applicable to legal. Hence, the role of the legal chief operations officers. Operations will become very, very important, especially for law firms that are very large, that service very large clients. Even mid-sized law firms, it will become very important. This is what is happening, in my view, in the legal services domain. Dr. Lalit Bhasin, with almost 6 years, decades of experience. And, one thing I admire about him is when he says, yes, he shows up, he's fully in. These are things that I admire, many other things that I admire, but these are top of my mind, and I'm really grateful to you, sir. If I said something that doesn't agree with you. Please understand that I'm not as wise as you. But when I'm coming to my own forum, I try and think about what's happening in this domain. And I've only given it to you as somebody who's a little outside the domain and not really inside the domain. You already saw that on 9 July at the Meridian, we have our General Council 100. We have almost 60 speakers, 60 General Councils already confirmed, and hopefully more being added. These are the top-notch General Councils. Uh, Tomorrow we have the second edition of the law school rankings. It's the Imperial, and in the evening we have our law school rankings. Again, it's done through a jury process, and whatever our jury has done is what we've accepted. There are minor changes in the ranking at the top. Uh, they've swapped 1 and 2 of the last year, and there are some other ranking changes. One or two have come up, one or two have gone down. But broadly, the top 20, except 2 or 3 changes, are the same. There are some changes between the 20 and 50. So these are baby steps for us in the legal services domain. We intend to do much more, and my gratitude to Garima and the Business World team for doing what they do day in, day out. We on Tuesday, Wednesday did a 2-day sustainability world conference, which was at the park, and the Honorable Environment Minister was at the conference. And 2 days we had full house. Uh, Today we have a little sluggish start, but I'm sure as the day progresses, you will meet more and more colleagues of yours. And in the evening, we have Justice Madan Lokurji, who's our chief guest, and we have Mr. S. Lakshmi Narayan, who's a former law secretary, former home secretary, as our guest of honor. I'm missing when we started this 4 years back, sir. Justice Sikri was our jury chair, he was our chief guest. It was 12th December. It was his wife's birthday because after 1.5 hours on stage, he said, "Aaj meri बीवी का birthday है, मुझे जाने दो." So we had to let him go. But there's one more person who we are missing. When we did our BW Legal World 40 under 40, he was on the jury, and with him there was never a dull moment. In fact, apart from you giving me samosas, the only other person who's given me more samosas was Mr. Rajiv Luthra. So I'm definitely missing him. And I remember my birthday party last year, Garima and he came to the party and he said, "Where is my blue label?" And he sat down outside in Garima and they were having a conversation and whatever else. So I really missing him. And in the evening, there was small AV to celebrate him. We have had moments with him, and really, he was a stalwart in our industry. And he suddenly went away. So look after your health. That's what I'd say. That's what I tell myself every evening. Luckily, I don't smoke, I don't drink. But yes, I need to do more exercise. I need to do more movement. But I want to say that it would be nice if we can stand up for 30 seconds and bless his family and bless his soul for Mr. Rajiv Luthra. If we can do it, just remember it and say an honest prayer for him. Uh, Thank you so much. But
Thank you, Dr. Batra. And now, to deliver the keynote address, please welcome Dr. Lalit Bhasin, Managing Partner, Bhasin and Company.
Good morning to everyone. I bring to you greetings from, besides my firm Basin and Company, also from the Society of Indian Law Firms, and the Bar Association of India, and the Chartered Institute of Arbitrators, and CII National Committee on Legal Services. Since I happen to chair these very important institutions connected with the legal profession. This is a historic event in the sense. I'm very impressed by the world, the legal world. So it is not just the legal profession. What you see Dr. Anurag Batra and Garima and others, they have been achieving year after year is to bring the different stakeholders for the economic development of this country through the profession of law. We have the general counsel here, the in-house counsel, we have the external counsel, the law firms, we have lawyers who appear in the courts, and judges, whether sitting or retired judges. So this is an occasion which brings together, a very rare occasion these days, all these stakeholders which help in promoting and strengthening the support which the legal profession gives to the economic development of this country. People don't realize what is the role of lawyers, the legal profession, whether in-house or external, for the economic development of the country. Without the lawyers, you can't have international, multinational agreements, mergers and acquisitions, protocols, conventions, treaties, even between the governments. That is the significant role which this profession plays. And that is where the role, you see, of legal world as set up by Dr. Anurag Batra comes in. So my compliments to Dr. Batra and for bringing in this institution of legal world. Dr. Batra referred to the future of law firms. I don't think we need to discuss what is the future of law firms. Because if we discuss future of law firm, we are discussing also the future of the legal profession of this country. I don't think there is any inherent risk, any impediments in the growth of the legal profession, because the Indian legal profession as it stands today is second to none in the world. And that I say with some daring certainty. I have put in 61 years of law practice, and I've seen the evolution of this profession. And I say it with great pride that our profession has not only brought glory to the country, it had also brought independence to our country. You see, our father of nation, our first prime minister, our first president, the first Governor General, Sardar Patel, Dr. Ambedkar, everyone, they all belong to this profession. But I have also seen the transition post-independence and post-1950 when our constitution came into force, how the profession has developed. When I started my practice, I used to take, you see, sometimes the DT, that time it was called DTS bus service, go to the libraries, to study the case law because no tools of research were available. Mobile was far cry. Even the other telephones, the black ones, even those were not easily available. We used to borrow the books from the libraries to study and prepare for the cases next day. And we were all general practitioners, except for few exceptions. You see, we are all general practitioners. We used to handle civil labor, some criminal matters, whatever comes our way, because that was the bread and butter at that point of time. Whatever comes, you see, our way, that is, that was the law practice. That was in early 1960s. Then I had seen the growth gradually of some law firms coming up in Bombay. Established law firms were there, like Crawford Bailey, Little and Co., Gagrak and Company, and so many others. Similarly, King and Partridge in Chennai, and a few law firms, I don't remember the name, in Kolkata also. They were there. But those law firms were generally also doing general practice, mainly into conveyancing, or under the 1913 Companies Act, formation of companies and Indian, that's all. That was the scope of the law firms at that time. 70s started to see change in the profession, and 1980s brought in further changes, with slowly and gradually Indian economy being liberalized gradually. But the revolutionary change came in 90s, early 1990s, when the Indian economy fully opened up. We saw the growth of good law firms in the country, young emerging law firms with good resources, with good knowledge of technology, and those came up in a big way in most of our cities like Bombay, Kolkata, Bangalore, Chennai, Hyderabad, Ahmedabad, everywhere. This brought strength to the legal profession. So much so that foreign law firms started looking at expanding in India. That is when, on behalf of the Bar Association of India, even in 1990s, 1994, I remember, we had our conference, which was presided over by Pali Nariman. I was the General Secretary at that time. We said that we are not opposed to the entry of foreign lawyers because we can face, but please create a level playing field. Let there be reciprocity and all that. But in the year 2000, when the Society of Indian Law Firms was set up, we categorically and strongly and vehemently opposed the entry of foreign law firms in this country, because we were conscious of the fact that the Indian law firms, you see, have not been given a good deal in the sense of, if you have a comparison with the foreign law firms. Foreign law firms can advertise even in electronic media. Go to US in any state, they'll say, if you want a divorce, come to me. I'm you see, a specialist in this. That is advertised on electronic media. If you're met with an accident, I am the ambulance chaser. Come to me. I will get you the maximum compensation. So that sort of advertisement publicity in India, following the British system, we did not allow such, and rightly so, this sort of publicity. We don't want that publicity. We only want certain rights to be given to Indian legal profession to disseminate information about our law firms, about the activities that we undertake, about our specialization, about our partners, about the big deals that we have done. That is not allowed. It is not allowed under the existing Bar Council. They call it advertising. This is not advertising. This is dissemination of information. Someone sitting in Cape Town wants a lawyer in Kanpur. He should be able to access and get the requisite information, whatever he is looking for. Those sort of things, and then reciprocity only in the name. How can you have reciprocity when a firm like, say, Baker and McKenzie, having about more than 100 offices all over the world? Now, what sort of reciprocity would that mean with each country where Baker and McKenzie have an office, there should be reciprocity. So certain practical problems have arisen. Dr. Batra referred to the Bar Council rules and regulation and the interview which I gave, you see, to him. I clearly pointed out that it is a good step. You open up the legal services sector, but first open the domestic sector in the sense, create that level playing field. We don't, we are not averse to any competition. We can face the competition because we are sure that will be a healthy competition in the spirit of co-opetition, that is cooperation and competition together. That is the need of the hour, of mutual coordination, not to take over, you see, the work of anyone where you want to go. Someone said it is just like the East India Company again coming back to India to take over and all that. I don't know. I don't want to go into that aspect, whether it would amount to that. But when someone comes here, what is the reason? What is the rationale if they are coming here? It is definitely to take away some pie of our work which we are doing here. But also see the mutual cooperation which exists today. If I want a lawyer in London, if my client wants to see some advice, I will go to the competent law firm in London which specializes in that. And if they want some advice from India, we always share, you see that. That sort of mutual cooperation, coordination, I think that is much more important than having your offices being set up here. The result will be the same. The client will stand benefited, but it may not stand benefited if you have law firms setting up their offices with unfair advantages over the Indian legal professionals and particularly the law firms. That will not be acceptable. That is what we have conveyed to the Bar Council of India in a representation made about a month ago. Soon after, you see, their rules came in. And I'm happy to note that the Bar Council of India has realized, and that is reflected in their official statement issued in London by Mr. Manan Kumar Mishra, that there are serious concerns and issues with regard to these rules, which will be addressed in consultation with the law firms and other stakeholders in the profession. So that is the dialogue which is going on at the moment. And he has also made a statement that till these critical, important issues are discussed, the rules will be kept in abeyance. So there will be no registration of foreign law firms till this issue is decided. So that's a very important beginning. And that is what we had been highlighting for the last 2 decades. That create that sort of a level playing field. And we will face the competition. Fortunately, the Bar Council of India has appreciated at least some of the issues which we have raised. And hopefully there will be a proper resolution of this without anyone taking recourse to the courts of law. Because our fundamental legal objection, constitutional objection is that you cannot have these rules without amendment of the Advocates Act. The Supreme Court in 2018 in Balaji's case has very clearly, categorically said that only Indian citizens can practice law in India. And further and more importantly, the Supreme Court has elaborated what is practice of law. It is, they say, not just the litigation part. It is also the corporate work, the conveyancing work, you see, the transactional work, that is also practice of law. And lastly, they say that even practice of a foreign law in India is prohibited. Because the Bar Council of India will say that first they will come and practice only law of their own home jurisdiction. Supreme Court had said you cannot do it. Therefore, what we had been suggesting to the government, both the Ministry of Commerce, which is the nodal ministry under WTO, and GATS and everywhere, not the law ministry, that amend the Advocates Act. Otherwise, it will bring, you see, a bad name to our country, bad name to the law ministry, bad name to the Bar Council of India, that you have introduced something which on the face of it is illegal, inoperative in view of what the Supreme Court has said. Therefore, amend the Advocates Act first. That should be the first step. Then create that level playing field, opening of the domestic sector first, which is done in Singapore, which was done. And we said, follow the Singapore. Phased sequential entry of foreign law firms. That has been, you see, our motto. So I wanted to share these thoughts with you because most of us are aware that the rules have come into existence, but what will be the fate of the rules, that is still very uncertain. But a dialogue has started. Therefore, hopefully there will be a happy ending to this. So thank you very much. Thanks again, Dr. Batra, for your opportunity you have given me to speak to my colleagues here, whether they are in-house counsel or they are the external lawyers like me or representatives, eminent representatives of the law firms. Thank you very much.
Thank you very much, Dr. Basin, for sharing your wisdom with us. Moving on, ladies and gentlemen, it is now time for the first panel discussion of the day. The topic at hand is IPC laws and strategy for businesses simplified. Join me as I welcome our panelists. Please welcome Mr. Amya Gokhale, partner Shardul Amarchand Mangaldas. A louder round of applause, perhaps. Please give it up for Mr. Amrish Singh, partner HSA Advocate. Please welcome Mr. Hardeep Sachdeva, senior partner AZB and Partners. Please give it up for Ms. Manisha Chaudhary, managing partner UKCA and Partners. Please welcome Mr. Ramakrishnan Veeraraghavan, barrister and senior advocate. And completing the session, please welcome the session chair, Mr. Alishan Naqvi, partner, Lex Counsel.
When I'm standing as a lawyer and people say, please sit down, I say, I aspire to be a standing counsel. Very good afternoon to all of you. And when I say very good afternoon, this is to all the people who are physically and mentally here and the people who are physically here, but in the virtual world. All of them. I have a great panel here, and we are going to discuss about IBC laws and the strategy for business. But before that, thanks a lot to the BW Legal World, Dr. Anurag Batra, for providing this fantastic platform where we meet regularly and interact and discuss the ideas as well as the laws. Thanks to Dr. Bhasin also for giving us the insight. And he has been one person who has stood with various associations for the cause of the practice of lawyers in India and the legal profession. So we are all the lawyers of his era, and the lawyers who are younger to him are thankful to him because somebody needed to take that stance and he took it. Well, moving on to my session, our discussion, we have a fantastic panel here, and I'll request my panelists to introduce themselves. And I, as you know, am Alishan Naqvi. I am partner with the law firm of Lex Counsel Law Offices. Over to you, sir. Do you have mics with you?
Ramkrishnan. I'm a barrister and senior advocate, practice at the Supreme Court based in Delhi. Over to you.
Good morning, everyone. My name is Ameya Gokhale. I'm a partner in the Bombay office of Shardul Merchant Mangalas. I'm primarily a litigator, litigating across most forums, and a large amount of my practice is, of course, the IBC and insolvency practice. It's great to be here today, this morning. Thank you to BW Businessworld for the invitation and an opportunity to put forth my views. I hope that this session will be very engaging and as informative for us as it will be for all of you all.
Thank you. Good morning. I'm Hardeep Sachdeva. I'm a senior partner at AZB and Partners, and I'm a corporate M&A lawyer, but I call myself a business lawyer more than a corporate M&A lawyer. Thank you.
Hi, everyone. I'm Manisha Chaudhary. I'm the managing partner at UKC and Partners. I practice mostly corporate commercial litigation with a bit of transactional law as well.
Hi, I'm Amrish Singh. I'm a senior partner at HSA Advocates. I do real estate and disputes. Basically, my focus is that home is integral to everybody. That's a very emotional and sensitive aspect. And, how does a home buyer get affected under various regimes? Notably the IBC is what is very, very relevant today.
Thanks a lot. Thank you very much. And just as a refresher, we will be discussing and we have a very unique experience among us on the panel. Just as a refresher, the insolvency and bankruptcy code came into being in 2016 and got implemented. It brought in within the recommendation of bankruptcy law reform committee, which provided that the businesses should be permitted not only to succeed but also to fail and fail on it. That was the first parameter. Second also was that the rehabilitation of the companies was required because in the earlier regime of companies that you had an option. If there is a default, then there was a winding up. So what we introduced is a new concept in India, which was CIR, Corporate Insolvency Resolution Process, within which the company would be put up, and along with the creditors list and all those in play, if the company is suited for anybody else's business case, they can bid and take the company. So the company continues the economic activity, continues, and the employment continues, which is in the interest of the economy itself and in the interest of the nation. It also brought in a few new concepts like this resolution professionals. Earlier, anybody could be a liquidator, and liquidation was the only option in case of recording of fees. Now we have resolution professionals who are qualified, who have gone through examination with the Insolvency and Bankruptcy Board of India, and then they qualify and they take charge with the support of the suspended board of directors if the corporate insolvency resolution process commences. And they run the company till the time either somebody takes it over through a process and get the approval of NCLT, or it goes into liquidation, then also proceeds forward. So few new things is brought in. The law brought in, of course, as every new law, it had very good intentions. It faced certain roadblocks, which came both from the interpretation of law, from the practicality of implementing, from lack of infrastructure, and also for better owners, which is Some of these aspects we will cover in the discussions. Before I move on with the questions, some of these statistics which I want to share, and this is as per the IPA report, which is published annually. And this is the IPA report which is published in March of this year, says that till March of 2023, total of 6,571 CRPCs have commenced. From the inception, when it came into operation, people file applications, and you file an application earlier because of the background. If the default was more than 1 lakh rupee, which was just around the time of the registration, you could file an application, and if the NCLT found it to be meeting with the criteria, then CIRP would commence for the information process will commence. In March 2023, 6,571 CIRPs commenced, out of which 4,515 have been closed, means they have reached some result, whereas 2,000 cases are still there, 2,056 cases. Now, out of this 4,515 CIRPs, 2,030 have gone into liquidation, which is 45% of the total number of the CIRPs which commenced. 45% went into liquidation. So it is the same as the previous Companies Act, CIRP period notwithstanding, they went into liquidation. 848 was withdrawn or settled, which is again 19%. So when somebody has a default, you file a case, the person settles, doesn't want to go to CIRP, that is a 19%. 959 closed on appeal or review or settled, which means CIRP admitted, somebody appealed, either the decision was reversed or it was settled or it was sent back to NCLT for reconsideration. Out of that, 678 now have approved resolution plan, which is a percentage of 15%, 15. So out of 100 cases instituted, only 15 saw closure of CIRP successfully within the objectives of IBC. That is one way of looking at it, and we'll discuss that. Just a piece of data. The IBC also came in with a legislation which has strict timelines. Of course, the courts interpreted that the timelines are mandatory for the applicants and the companies, corporate debtors, but discretionary for the tribunals and the judges. Now, 73% of these CIRPs take more than 180 days. And this is the collective data of all these years. CIRP ideally should finish within 180 days, extendable to 270 days, and in certain cases to 330 days. The idea of IBC was to shorten the time period. 73% now take more than 180 days, and 64% more than 270 days. Now, with that data, I move on to my panelists. And first question is to Mr. Ramakrishnan. Sir, thanks for being here. And as a senior advocate, I wanted to start with you. You have, sir, seen the time of winding up company courts in the high courts and the IBC. I understand. What broadly do you see from a bird's eye perspective has changed over these years? What have we achieved? And how do you think the two eras are different or they are similar?
Short answer is there's progress in the right direction. Now, let's talk of two objectives of IBC as per the statement of objects and reasons. One is timeliness, and second is maximum realization of value. If you start with timeliness, the timelines under the 1956 Act, the triggering of the liquidation process used to take about 2 to 3 years. File a petition, notice ordered, adjourn, and these were additional difficulties in the non-metropolitan courts, the chartered high courts. You go to the others. Some of these high courts, the total number of company petitions filed in a year was 5. So when you go there to argue a company petition, you start off the barrack saying, please look at this is the Companies Act, and then you start from there. Those challenges are now. Now, when you talk of triggering the CIRP process, we are in a matter of months. Then the second, the end process, the statistics that you said are concerning, but are of concern. But when you look at the liquidation process under the 1956 Act, We measured by the calendar, not a single year's calendar, 10-year calendars together. Liquidation process, minimum 10 years, 15 years. So we are in the right direction. But a lot of things to do, lot of improvement to be made, but the direction is right. This is on timelines. Then you go on to realization of value, maximization of value. Sale of property, company property. By the time the liquidator went over to get the permission for sale, property, all the machinery, everything, stocks, everything would have been junk.
Right.
The only place where value was realized was real estate. There you had huge value because the process took 20 years. So both ways, I think this is a step in the right direction.
Thanks a lot, sir. Thank you very much. Yes, I agree. The concept of it being given away as a going concern and being kept as a going concern is a vital thing. My next question related to this is to Ameya. What happened when the new law came in? 1 lakh rupee was the threshold. And unlike the Companies Act, you did not have to prove the solvency of the company. You only had to prove debt and default. Now, I remember an instance when I was in a court, and it was before NCLT. And there was this guy who filed for his clients, the lawyer who filed for his clients a case where the default was 1,05,000 rupees. So the judges looked at him, the tribunal members looked at him and said that you have filed this case for 1,05,000 rupees. He said, yes. And audaciously, they said, but haven't you advised your client? He said, yes, I advised. What did you advise? That you need for IBC, you need 3 things. Debt more than 1 lakh, default, and application should be complete. And he's perfectly right. And the members looked at one another. Thankfully, they raised the limit. But I think a lot of lawyers had a very good time sending notices for their clients on all the defaults when they were above 1 lakh rupees. Thankfully, that changed. Ameya, my question to you is that when you go through the realization schedule and you see what Mr. Ramakrishnan also said, maximization of assets is there, but the secured creditor, unsecured creditor, operational creditor, financial creditor, we'll touch those aspects. How do companies now decide as to when to trigger IBC against any of their debtors? And whether at the end of the tunnel, they will have anything, it's just a pressure tactic to send a notice and then see if they are operational creditor, or to just file a petition and see for settlement? Do they understand the procedures?
Honestly, in today's time and age, even the threshold limit of 1 crore is very less, frankly. With businesses becoming really big, 1 crore is really a small amount. And partly because the threshold is so small, earlier, of course, it was 1 lakh, now it's 1 crore. We find that clients tend to be very trigger happy. It's a cliche, so as to say that insolvency is not a recovery mechanism. And a lot of clients forget that, or as you rightly put it, a lot of clients feel it could be a pressure tactic. Personally, I feel it's a very wrong way to start off on both counts, because frankly, I mean, ultimately, even if you do recover your money from this process, the cost benefit analysis is really something that the clients need to look at. Now, look at the case of, say, a financial creditor, and look at the case of an operational creditor. An operational creditor in a company which has number of services, but has an outstanding which is more than 1 crore, may land up getting an admission. But what is he achieving at the end of the day? He is last in the food chain. He's perhaps not going to be getting a single rupee. Most plans, as you're aware, don't have provisions or don't have large provisions for operational creditors. He's going to land up spending time, money, costs. He's going to land up spending the initial costs of the CIRP, because now courts have started awarding the initial cost of the CIRP to the applicant. They have to bear those costs. So ultimately, after a 4 or 5 year process, he has nothing but ego, really, in that sense, that he's earned, but nothing really in the pocket. So a lot of clients need to really evaluate where they stand in the food chain before really deciding or before really opting to invoke provisions of Section 7 or Section 9 of the CRP, of the IBC. I don't find a lot of clients do that. And then somewhere down the line, when the applications are pending or applications are admitted, clients lose interest, and the process is irreversible. So a company which would have been able to perfectly repay an amount owed to your client in a regular litigation process, in a regular recovery process, now is stuck with this entire insolvency process, and nothing is achieved out of it. So really, I think clients need to be conscious of what they're trying to achieve, and whether they're really interested in looking at getting their money back, or whether it's just a mechanical process that they're following. And I truly believe that IBC is not a process that is to be followed for just the mechanics. It's really a process where consciously all stakeholders need to be aware that there's a company, and if the company can be revived, I think IBC should be your resort only as your last resort if a company is really revivable, and not just out of not just as a matter of ego, or not just as a recovery proceeding.
Thanks a lot. Thanks, Amir, for that. In fact, I am privy to some of the instances where the operational creditors filed their applications and the petition got admitted. In the earlier time, even now, 1 crore rupee, as you say, is very less. And then the RP is appointed and they have to pay the RP. And then they realize that they have committed a mistake because the bill of RP may be more than the amount of recovery that they had to make. Even the amount of claim, recovery is a small thing. Coming back to Mr. Ramakrishnan, to you. Now, there are companies at an exposure. You may have debtors. You may not raise dispute all the time, And so what can the debtors do if they have, what can they do if they have creditors more than 1 crore rupee? Can there be some strategies wherein they can avoid IBC? I agree with Amaya, it should be the last of the priority for the persons who are invoking IBC, but as a debtor, you still need to protect yourself. Well, any functional company will have creditors, and they are likely to be above 1 crore rupee.
Now, starting from where he had left, let's say there's a trigger happy creditor coming over. 3 things, as legal counsel or advisors to a debtor firm, 3 things you need to remember. 1 is liquidity. 2nd is solvency, and the 3rd is valuation. Insolvency, IBC is all about liquidity. You might have a great solvency, valuation may be good, but liquidity is all that matters. And there is the disconnect. If you have a petition against you, the strategy is to first find out who's the creditor. If it's a financial creditor, that's like James Bond with a gun. Don't fight him. You're bound to be killed. Now, if it's so if you have something against coming from a financial creditor, your best strategy is to raise the money, make sure the default doesn't happen, or settle when it comes. If it's against an operational creditor filing against you, that's more like Inspector Clouseau. Chances are great, in a Pink Panther, you might win. There, your strategy would be, if you have a liquidity crisis, you will use the money from the operational creditor to pay your financial creditor and keep yourself alive. How do you do that? You do that by not paying your operational creditor. If you have some event coming on, payment is due to your operational creditor, you raise a dispute. You raise a dispute for the heck of it, file an arbitration notice, appoint your arbitrator, file a civil suit. Doesn't matter if it's going to be dismissed. It will be dismissed after a couple of years. You have that breathing space for 2 years, and then you take it on. That's the way you handle liquidity. But then these are events that you must anticipate right from the beginning. You can't come there a week before and then expect to handle this. I think there, what Dr. Batra said, that the legal counsel and the law firms must be more integrated with the business to make these strategies work. Thank you.
Thanks a lot, sir, for that insight. Now, related to that also, when we talk about from both the sides, from the creditors and from the lenders, my next question is to Hardeep. Lenders, usually you have various options. You had earlier to IBC also, you had Safasi, you had other options. Today, from the perspective of the lenders, if we were to understand for the debtors, or generally as a lawyers also, from the perspective of the lenders, what are the criteria which make them decide whether to go for IBC or for any alternative option They may have arbitration also. They have still have recovery proceedings. They have surfacing. How do they decide?
Yeah, thank you. So if we see this whole law from the perspective of the financial institutions, see, end of the day, this law was promulgated keeping in mind, amongst others, the interest of the secured financial creditors. If we look at the financial creditors, means those financial institutions like banks or any other financial institution which is lending money to the corporate world, if we still look at their apathy under IBC, then I must say that it's a dream too far to come true till now. If you look at your data once again and just answer a simple question as to how long will it take for a financial institution, including a bank in India, to get your insolvency petition admitted? It is not going to be less than 6 months. It can easily take it 12 months. And between 6 to 12 months, a financial institution which has lent money to that errant borrower who is not paying, and to the corporate guarantor or to the personal guarantor who are not even aligning to the servicing of interest or even holding the security tight for the benefit of the financial institution, you will have to explore other options which are available to you as financial institution or financial creditor. So what happens is that people like us who are business lawyers, even before you lend the money as a financial institution, that question is usually asked to you: what should be your strategy in this lending transaction here? Are we dependent on IBC to get the money back? I agree. It's a cliche that IBC is not the tool to recover money, not the tool to seek enforcement of your security. But the question is always asked back to the business lawyers that, or the corporate lawyers, that is this your first strategy to get the money back? That can't be the case. That can't be your answer, because fully well it will take you more than 6 to 12 months. And I'm sure very soon Amresh will tell you, if you have money lent to real estate sector which has 5,000, 2,000 home buyers, you can forget about your admission of your insolvency, and then of course the different nuisance will come into play. Therefore, we have to find out the other options which are available to the financial institution as part of the strategy when you are lending the money. And the choice is again dependent on what are your securities. If you are that secured financial creditor where you have security of a real estate asset or a land or a building, okay, where you do not have third-party rights created like a real estate development asset, then your first choice to seek an enforcement of your security could be SARFAESI. Why SARFAESI? Because the moment you give a SARFAESI notice to the borrower is bound not to deal with the asset. Means without going to the court, which could have been the case for you to seek a stay against a disposition of asset against a borrower. In SARFAESI, the moment notice is issued, asset is not to be disposed of. There's a law here. You might have that choice better available with you when you are planning to make a lending to any borrower here. But sometimes that may not be the choice that you have. Sometimes you may have multiple lenders involved in a single borrower or to a group of companies here. You might only have a choice to go back to IBC and be at the mercy of the NCLT to grant you admission of your petition and or let you be in the queue there. And at the same time, when you make a decision here, we always do a calculation. If push come to shove, if we are amongst many lenders in a company, what would be my threshold percentage if I happen to be sitting on a COC here? You always want to cross that magic number of 35%, if not, let's say, in a super majority. Why? So that even if you can't drive the whole process of insolvency, you can at least not let something happen which is so prejudicial to your interest.
You can block something.
Yeah, you can still block something which is not the best way, but yes, still a tool to make sure that you're not getting deprived of what you should be getting here. You still have the tools of recovery suits. Why would you take recovery suit in some situations when you in recovery suits when you have to pay such high court fees?
Yes.
The court processes can take 5, 10, 15, 20 years. I mean, all said and done, the data or the recovery data or the time efficiency data of IBC will be far better than the similar data for the civil suits. Civil suits in this country are still 5, 10, 15, 20 years, or maybe
That's
more.
true.
It doesn't matter. But end of the day, in the court procedures or in the civil suits as well, one can file for interim interlocutory orders, which are so quick to come in the country, which I'm sure sir will speak here. They are the fastest orders one can get is getting interim stay, getting interlocutory order against not to dispose of something, getting order for a declaration of suit, which are far cost efficient, and you can get that. Therefore, you still have that choice there. The choice needs to be made, in my view, especially for people like us, at the time when you are doing that transaction here first, so that your strategy is clear as to which way you will go, and then choice will have to be made when the time has come for you to make the choice.
Thanks a lot. Thanks a lot, Hardeep. That was really insightful. In fact, as you referred real estate sector, I think it's time to move to Amresh and ask him, how is IBC working out for the real estate sector from the perspective of not from the home buyers, but generally for the developers and the resolution applicants? It's a complex,
very
it's a
interesting
complex
question.
domain.
Yeah, very interesting question and very relevant also.
Yeah.
You see, what is happening now is that there have been various judgments which have kind of defined the interplay between IBC, RERA, and the consumer disputes redressal forums and all of that. But, obviously predominance has been given to IBC as a method which the home buyers have to really initiate so as to get their, grievances redressed. Now, I will talk with examples. Let's look at some of the important insolvency proceedings which are going against the developers. They have clearly been going on for a very, very long time, and that does not really help the situation. There are certain insolvencies which have gone well beyond 5 years. I have personally been involved in some of the matters. So in one case, when the claim has been admitted, there has been a stay granted by NCLAT, and that took 4 months to vacate the stay, and for the NCLAT proceedings to commence and recontinue. So that definitely is not going to be in accordance with the time prescribed under the law. Yes, it has been made directory, but the delay has got to be reasonable. It cannot be going on for 5 years and 6 years and so on. We look at the JP insolvency. There's no conclusion in sight.
Never.
So, these problems are always there. We do have home buyers who are financial creditors. But the real hope that I see is that the home buyers resorting to IBC is till the time it is all related to projects which have been done in the past in the pre-RERA regime.
Yeah.
Moment we come under the RERA regime, then there are safeguards which are built, notwithstanding all the criticisms that we can level against RERA for non-implementation, slowness, and so on and so forth. The fact remains that there are well-regimented procedures prescribed under RERA, like, how you deposit the amount, 70% has to be in a separate account. That amount is to go into the cost of land and cost of construction, and so that, and, well-defined timelines with corresponding penalties and so on and so forth. It's going to tantamount to all the developers which are not defaulters to stay in the picture. As Supreme Court rightly said, that the good time of the defaulters are now gone, and the economy is on its right path. So with regard to the IBC. So therefore, and with all these, some of the novel items being introduced, such as the reversed insolvency or project-wise insolvency, the incorporation of home buyers as a financial creditor, so on and so forth, and regular amendments which are going to happen by the regulator and all that. We could look into a positive direction, but the fact remains that IBC has to work in conjunction with RERA.
Yeah, that's true. In fact, RERA perhaps is one a very good step, though I think like the NCLT tribunals, RERA also has some challenges. But moving on to Manisha. Manisha, out of the so many apartments that you have booked over the years as a home buyer, how many have been delivered and how many have not been? And what are you doing about it?
How
Just
many
from
do
the
you
perspective
have?
of home
I
buyers.
have none, none. I live with my parents at their whims and fancies. Can be thrown out anytime, so I might come to one of you all. So I think when it comes to the home buyers, more or less, they have the right under the IBC in Section 7 to come before the NCLT and get their rights triggered and have it done. But what is happening in some of them is that there is no resolution in sight at all. Only because there is that process is not put into the IB code yet. One of them is the reverse mechanism, which which has been discussed. In reverse mechanism has no place in the IB code at all.
Correct.
However, it is needed in the IB code. There are real estate projects where certain projects are already done. There are towers which are just lands. There are half-built towers as well. And all of that cannot be done in one process. It's impossible for home buyers to sit on a COC and see eye to eye on such a situation. And that is where I believe the IBC is failing them. And I believe that it is already in discussion now and an amendment is coming through for that. So hopefully they'll be able to recognize that loophole and sort of club that there. Another issue that home buyers are facing, in my opinion, are whether they're secured or unsecured creditors. And that itself is a topic of discussion in many of the cases before the NCLT as well. But till date, there is no solid ground on whether they are secured or unsecured. In my very humble opinion, it is a secured debt, but then in the books, it's not treated as such. So if it's not treated in the books as such, who am I to say that they're secured? So from a very pragmatic view, yeah, they're secured, but from a very technical financial view, they're not. So that is what I believe needs to be discussed in the IB code and soon to be plugged right there.
It's very interesting under the IBC code, Manisha, as the criteria changes from operational creditor, financial creditor to secured and then unsecured creditor. And at different stages, different things become relevant. Again, touching with you, another aspect of IBC from the point of view of resolution applicants. Now, a lot of companies which have defaulted are under the CARP process. We also know that there is a whole industry out there which manages the acquisition of these companies for good purposes, mostly. Do you think that IBC is also working in parallel as a good acquisition strategy for the businesses who are viable and with respect to their competitors, with respect to other companies in the same sector which are in distress?
Right.
Or for diversification?
Right, Alishan, I really do think that IBC can be a great acquisition takeover sort of a mechanism to be taken care of. In terms of acquisitions, there are companies, and we've seen it in the top 10, 12, which have been resolved, that it is sort of a merger of the big entities or takeover by the big entities. Say, for example, SR being taken over by ArcelorMittal. Ruchi Soya for its own sector, FMCG was taken over by Patanjali. We have to see how Jet goes. What is right now happening in Jet? I mean, it's taken over, but not yet the resolution being put into place. And same with Go Air. I do think that it's a great tool for acquisitions. You wait till your competitor goes into IB code, or you might even sort of induce certain things and play your corporate espionage, or however you want to say it in a nicer way. But these things are tools that have to be used. It helps you acquire assets at a much lower rate. There is much favorable valuations. Your balance sheet comes out better. The amount that you spend or would have ideally spent in an acquisition is drastically reduced. Banks give you much favorable like rate of interests and how they would like you to pay, and that helps you in your liquidity and in your cost optimization and all of those things as well. And the biggest is absolutely sometimes annihilating your competition. take over as much as you can during the IB code. Of course, you need the Competition Commission's approval on it, but those are not approvals which I believe can be held back when you're in the IB code. So as a mechanism for acquisition, as a business strategy, IB code and looking into companies who are in IB code could be the best mechanism for bigger entities to take over. We have to keep competition in mind at all times for the general public as well, but that's something which the government has anyways looked into. Introducing that section into the IB code to say that the CCI approval is needed is also sort of diluted by the appellate and by the NCLT themselves in their judgments that, you have the time, if it's okay, if you can get it done, let them give it to you, things like that. So yeah, I think it's something that businesses should actively look into, apart from the fact that ARCs are obviously sharks out there looking for this, but businesses themselves are also now looking for, if nothing else, just land, if nothing else, plant and machinery, if nothing else, technology, R&D, killing competition, things like that. I mean, just a strategic decision that let's look into this company and see what we can do best. So yeah, I think it's a great tool.
I just want to add one thing. Is that maybe two things. One is that not just the companies under insolvency have been bought by large corporates. We all know about, the big cement or steel and all these plants which are, bought by big boys. We have been able to buy the companies under liquidation. Companies under liquidations means a company which started the CIRP process, failed, started liquidation, bid started. Yes. We have been able to buy companies under liquidation on a going concern basis. Because we got a landmark judgment of selling biotech, which we advise the bidder. We have actually bought the
preferences to keep it as a going concern.
Yeah, and it was a challenging thing for us also to make NCLT agree to this concept here, which was missing from the rule book, to let the liquidation companies under liquidation be also bought on going concern basis. So that has actually changed the paradigm, means that the companies which failed the CIRP got a second life, eventually got second life. Correct. And we bought not one, we bought two companies, two judgments, which are truly the jurisprudence on this matter. That's one part. So of course, the role of M&A or role of corporates to buy these companies will not end for so long as the company is there. So even for the data of the companies which are going under liquidation, they are, in my view, not yet dead. They have a second life available. If they have something available in them, some value has to be there, And the companies that I'm speaking about are the one which were bought for their manufacturing plants, for their business, which are still going on. I mean, Sterling Biotech was a big business here, and one of our client bought it. It's all public knowledge. The client bought it, and because of the plant which was still in existence, and then Provoke Retail, which was again, bought recently because of the brands that they had here by not somebody else. That's one part of it, which means that, you still have some life left there. Second, I think there is a big anomaly when we speak about secured creditors versus unsecured creditors, especially in terms of, let's say, home buyers. So if you look at the way the law is written, a secured creditor is somebody who has security over or a security given for its loan. That's what you call secured creditor. Even if I have given a loan of 100 rupees and I got a security of 1 rupee from the company, I'm a secured creditor. I think there I have all the apathy for all the home buyers who actually have a right on the asset of the company and not classified as a secured financial creditors. How can they not be when somebody who has even 1% of his loan value given as security is classified as secured financial creditor? Somebody who has his 100% of the loan fully covered by the asset of the company is not classified as a secured financial creditor. Correct. I mean, anomalies are endless, but yeah.
I mean, in fact, in the RERA itself, it says that there no mortgage can be created on such an asset. And if created, it should not be dealt with. Making the home buyers a secured, and I think much secured than anybody else when it comes to these entities, real estate entities. But then here we are.
As we see, there are.
Just to add to this, sorry to intervene, just to add to this, even decree holders, financial this thing. Correct. Now they are placed under other creditors. So they are neither secured nor unsecured, but they are other creditors. And that's the anomalous situation because there are decree holders. And at the time of determination of the claim by the IRP, they're already suffering haircuts at that very instance.
Decree holder is somebody we all know who can attach the assets.
Correct.
And here you are, yeah.
So there are various interpretations, possibilities. I remember during the early days, one of the seniors jokingly mentioned that, you know why IBC has come? I said, why? He said, it is to legitimate the write-offs by the bank, because earlier than IBC, write-offs would happen and then there would be a CBI inquiry. So we have seen various things happening. New interpretations will come in and improve. Amrish, I have one question from you, Amrish. Is that we talked about projects. Manisha also mentioned that some of the projects are half built, and I have seen home buyers come to us for advice sometimes, wherein they actually want to avoid other home buyers from approaching the NCLT, because they know that we have a hope with this real estate builder of completing the project. If you go to NCLT, nothing will happen. Now, not only related to home buyers, but generally, do you see deterioration of assets during the SARP process? Is a serious concern?
No, absolutely. That's a very serious concern because, these structures which are unbuilt and they have not been fabricated and things like that, they would always suffer deterioration in quality. And, we have seen instances where, floors have caved in. There is general deterioration. Institute of Engineers have filed reports saying that there is a deterioration in the quality and so on and so forth. I agree with you. The home buyers have caught in that crossfire and quagmire that as to where exactly they should go. They go to the National Commission, they get a degree, the degree cannot be enforced for various complexities. In one instance, the collector could not recover it as arrears of land revenue because the property belonged to the Maharashtra government, MATA. So, when you face with those complications where the builder does not have ownership rights, then what do you recover? So therefore, that's why I again reiterate and come back to that point that IBC, if it can work along in a symbiotic relationship with RERA, it's really going to help the cause of the home buyers. And it is very, very important that the timely constructions of projects have to be attained. We cannot get caught in the quagmire of these litigations and let the structures just stand there, get deteriorated by rain, water, erosion, and so on and so forth.
Correct. And do you think, Hardeep, on that point, that RPs, who are supported by the suspended board of directors now, are they discharging their duties? We have had instances wherein we have got complaints against RPs, EOW complaints against RPs, all kind of allegations, complaints to IBBI, actions have been taken against RPs. Do you think broadly, not each and every IP like saying that all lawyers are good or all lawyers are bad. Do you think this RP whole ecosystem is doing what it needs?
First, I hope that there is no RP sitting here.
Even if they are sitting,
I don't want X and tomatoes to come to us.
We lawyers criticize lawyers all the time in front of other lawyers and the judges also. It's fine.
I fully agree with you. So if you ask me, it is still glass half empty. I mean, only, it may be a little political answer, but yes, end of the day, only half of them are doing their job seriously. And those half who are doing the job seriously, and I must say that their fees is enormous. I don't know if you've seen the latest fee schedules which are given. The fees is linked to a percentile of the amount recovered in the insolvency. Whereas if you look at the statement of object, we need to always, keep that in mind, that IBC is not supposed to be your recovery action.
Yes.
Nonetheless, your RPs, who are supposed to be custodian of your resurrecting the company from being, insolvent, they are saying that if you recover money, you have to pay me X percentage of the total recovery, which is made by all financial creditors put together as of now. So yeah, I think somewhere, we need to marry this whole thing, align it. Also, somewhere we need to keep in mind the statement of objects, which I think has a reason, which may not have been followed, in that true spirit. And therefore, I think there is a room for a huge paradigm change in RPs, try and get some more regulations for them. Try and some more, maybe self-regulated norms needs to be there in place as to how they should be conducting, these companies here.
Thanks a lot, Hardeep. We have little time left, so I'll be moving a little faster, but a broad question from you, from your experience of seeing how the tribunals work, the timelines, etc. And we see multiplicity of applications. We have seen the judges also, the members also expressing their displeasure. Because every time the hearing comes up in a complex multi-party NCLT case, there are new applications which they must hear before they get into the matter. And then the time goes away. We have members sitting in different benches. What is it that is required to be done? Because clearly the CRP timelines which I narrated earlier are not acceptable. There is a deterioration of assets. What is it that we need to do? Because ultimately this law has many benefits, as we see, broadly.
So let me start with an anecdote. Among the first dirty dozen companies mentioned SR, when this concept of timelines being just directory was not there, there were multiple parties in court and multiple parties were making multiple submissions. But the judge kept telling us that, look, whatever I have to do in 14 days. So let's hurry up this process. Whatever submissions are to be made, I have to decide this matter in 14 days. He was very clear about it. And he did it. I mean, if you see the admission order, it's among the quickest that you will find now in hindsight, as far as the dirty dozen is concerned. So therefore, looking at these directory timelines from the perspective that whatever you have to do in 330 days.
Yes.
And really work backwards from there will help. Everyone needs to plan from that perspective that 330 days is the maximum time limit that you have, and everything has to be planned backwards from there. Now, frankly, that's easier said than done, because the buck doesn't really stop only with the tribunals.
Correct.
I genuinely believe that this legislation is a very well-meaning legislation on paper, but a lot needs to be done in order to monitor how it is really functioning. So the stakeholders, the major stakeholders in how this functions are one, the tribunal, the RP on the other side, the RP firms that are backing the RP and sort of, helping the RP in the larger mandates. There is nothing institutional about monitoring these stakeholders, because the minute the performance is monitored, the minute people are held accountable, and I'm not just saying this from the point of view of tribunals. Hardeep mentioned even the RPs. I genuinely feel that there will be enough incentive for this process to be sped up, and then the sort of the end result that you're looking at today, where there is deterioration of company assets, where matters are not getting decided, where resolution plans are not getting approved for 2 years, where resolution applicants then become jittery as to what they're really going to get after their plan is approved versus what they had bid for 2 years ago. There's a marked difference between the two. There's a marked difference in quality. There's a marked difference in value of that asset. So once you have tightened the processes, and a lot needs to be done. It's very simple for someone to put it that way, but a lot needs to be done at the institutional level. Once we are able to achieve that, I think we will be able to take care of what's really going on and these sort of negative results that we're getting today from the IBC process. So it's really a reverse mechanism. I mean, there are a lot of problems that you can't deal with as of now, and pinning the blame on just tribunals and timelines is, I think, being a little unfair.
Correct. No, completely agree. Completely agree. The reverse mechanism has to be there. And once the mindset is there, 330 days is the maximum time, including litigation. I think that will lead to results. That brings me to another aspect. Manisha, this question is to you. We have data points, the statistics that I read, around successful CIRPs. That's 15%. And of course, out of those successful, also some would have gone in appeal. Maybe stay is rare, but still some directions would have been passed. Is CIRP, considering the aspects that we have discussed of acquisitions, of various benefits, benefits to home buyers, it being read in conjunction with RERA, is the data point of CIRP, successful CIRP, so relevant? Because 15% may be disappointing, but is this 15% to be seen disjoint from the IBC and the objective? And still we can conclude that IPC largely is a success, and this 15% is not a crucial data point.
Right, Alisha, and I have mixed views on that. One being that I think 15% is brilliant, seeing how a CIRP is conducted. 15% is also brilliant considering who sits on the COC. And 15% is brilliant considering that I do not believe that the COC has commercial wisdom. I genuinely believe that the way the process is being done in India is not comparative to anywhere else. And it's not really functioning the way we want it to. There are massive improvements which are needed in the process itself. You may admit the CIRP within 14 days, but I highly doubt that the kind of people sitting on the COC trying to resolve a company, they do not have the mechanism or the bandwidth or even the approvals to do what they need to do on the COC. Coming to that, in a discussion between RPs, which I was part of, they very categorically and very candidly have said that the banks have now come to the COC with the mindset of saying, send this company into liquidation. It's much easier for us. So hence a CIRP will not be successful if you sit on the COC with that mindset. Correct. And hence I see 15% as very good. Now, whether that 15% is relevant or irrelevant, in my humble opinion, like I said, it is, because that 15% as against what all is going on is a good number. But CIRP being what it is, it needs massive improvements. It needs to come to a 50%, 60%, 70% success rate, so that the amount which is involved of the banks, which is an amount of the general public, has to be recovered. It can't be that 83% haircuts are being given as per the reports and only 17% is being recovered. That is ridiculous when it comes to thinking that so much public money is being involved and not being taken care of. So I believe in an all essence thing, it needs to increase its processes, the way it is conducted. It needs definite improvements. But then CRP itself as a tool is great because it provides a lot of, lot of safeguards to those who are inside it and those who are trying to acquire. So yeah, it needs improvement for sure. Like I said, I have mixed views, but my views are more based on who's conducting the CRP and how it is done. Better laws, RPs being given more power, but restricted power. They can't go blind with power. Like with great responsibility, great power comes great responsibilities, kind of a thing. They need more, a guideline of how they work, especially their ethics. The ethics in the RPs has really to be discussed as to how they're conducting themselves. And I say it with humility that there are lawyers who are RPs and RPs who are lawyers just working on different cases just like that. And that's not how a professional should be working, either a lawyer or an RP. So those things have to be looked into. But nonetheless, it's an evolving law. I think it'll take another 3, 4, 5 years for us to get there, get to the international level of it. But
Correct.
Slow and steady.
Thanks, Manisha. Amrish, I'll come to you. Though you mentioned that both of the RERA and IBC can work in conjunction. In your experience, because home buyers is usually crucial. A lot of us also, maybe perturbed home buyers. Do you think that the exits which are being given is also a result of IBC process? Because sometimes we hear that the home buyers can surrender the homes, take the return, go away. I mean, is it that the developers have a fear of IBC, if not RERA, and therefore the home buyers, if they don't get a house ultimately, they get a refund or they get an exit or some property in alternative project of the home buyer? Do you see there is an ancillary benefit, a fringe benefit of this whole process for the home buyer somewhere?
See, I think, developers today are more fearful of RERA, because RERA kind of gets triggered moment, they register a project.
Yes.
And once they register a project, there are a string of compliances which they have to comply with, including financial deposits and so on and so forth.
The RERA account.
They come on the wrong side of law so far as IBC is concerned once they are branded or declared as defaulters, and that's when their paradise is lost. They are ousted from the management of the company and they sit outside and watch the proceedings. Now, as historically the evolution has taken place, we know where some of the promoters are, and they're all some of them are in jails and so on and so forth, facing a whole lot of prosecutions and so forth. And that's why that interplay is very, very important, that, RERA. So, as I said, that with the kind of safety mechanisms RERA is built for the home buyers, it will be a foregone conclusion in future that a lot of these real estate companies would actually be going to IBC, because RERA, suitably empowered, would have those powers of oust the defaulting developers and replace them, But of course, for that, we need to strengthen the RERA. For that, we need active home buyers. And so that, those positions are not attained, because, the people at large have experienced this, that 333 or 330 days is not making any sense today. These are all spreading and stretching out 2 years beyond 5 and 6 and 7 years and so on. Now, why RERA is also very, very important. I was doing one of the matters where the audit clearly said that there are no straight lines in the building. Now that is, you can do all kinds of solutions, but at the end of the day, you're not going to be dismantling those huge, buildings. But with RERA active and with all those criticisms being levied under the, statutory bodies under which these developments are taking place, these things are not going to happen in future. So as I said, the future looks brighter. It's just that all the projects which are pre-RERA times, are suffering this infirmity today. So therefore, we need to focus, and those things are already in the pipeline, to strengthen RERA so that they work in symbiotic relationship with IBC to make the life of home buyers easy.
At least going forward, we will see better times.
Yes.
Okay. Hardeep, I keep coming to you with sensitive issues. Another one for you. I do believe that retirement age has a purpose. And now, do you think that the tribunals, not only NCLT and CLAT, the tribunals do suffer somehow because of the judicial members being retired? It's experience versus energy. And it's a sensitive issue, and I've kept it for you purposefully. I'm joking.
I'm okay. I'm absolutely fine, But tell you two things. I think we all know that, and there cannot be any disagreement on the fact that our NCLTs across the country are flooded. They're just so flooded with these IBC petitions, cross applications, and all sort of IBC work here. So they are overworked, overburdened, whatever you want to call it, And therefore, there are humongous delays in getting the smallest thing done here. Delays are also on account of, let's say, the delay in the natural justice sort of a system where when you file an application, somebody will file a response, there has to be a rejoinder, time given for arguments, one day, one lawyer not there, second day, second lawyer not there, or judge not there, or, some vacation happens. Beyond that, the dates are not given on time because they have excessive amount of work here. I mean, that I think is certainly because of two reasons. There should be some conviction on every member. Conviction means that a statutory code of conduct that you will have to pass an order within n number of days. I mean, we ourselves are privy to situations where orders were reserved and not passed by NCLT for six months.
Yes.
And then the member retired.
Yes.
The member retired, and what are you supposed to do? You spent your 2 years, get the whole process in place here, order got reserved, and the member retired here. I think those things should be seen and should be taken very strictly, Until we have the conviction given to a judge as well, I do not think they'll keep passing the orders the way it should have been passed here. Although in the recent past, Chief Justice of India has been voicing very clearly to all the lower judiciary and all the high courts to ensure that they're passing their orders within certain number of days here. Now, having said that, one of course, that's one part of it. Second, I do believe that that NCLT cannot be a forum for retired members. Like if you today, I think I was talking to sir only. He also teaches judges. He's a teacher of judges, and I was telling how there is a young blood in the high courts which has reached there.
Correct.
We need to get the same thing somehow, or maybe we need to have these young lawyers who should be aspire to become the members at NCLT here. get that young talent to these tribunals to ensure that you are getting both speed and, in my view, efficient system in place here. I'm not judging on the quality of each member here, but yes, in terms of efficiency, we need to get some more young members into this forum here.
No, I agree. Sometimes they also have to do because of, see, it's a new law. A lot of jurisprudence is still to be developed.
But how do you do that? You develop jurisprudence by deciding upon the matters.
Correct.
You do not
Correct,
develop jurisprudence by
correct.
waiting for somebody else to decide upon the matter.
Sometimes the time taken is because it's a new point of law, but so many times there is an avoidance also to decide a crucial matter. But I agree with you there.
Can I just add
Yes, please.
one point very quickly? I think the appointment criteria of judges on the NCLT needs to have a very, very serious relook. Because some of the criteria is just downright weird. And the second problem that I find day to day is that the function of the judicial member and the function of the technical member is not very clearly defined. Now, the technical member is on the bench for a certain reason, because he or she adds expertise to the tribunal and the matters that are at hand before the tribunal. But we must remember that the technical member has never been a lawyer, or in most cases has never been a judicial member before any other forum. Therefore, basic things like writing a judgment, appreciating arguments, sometimes could be a challenge for them. And I'm not blaming them, but it's like putting a lawyer and asking him to do the job of a CA. We'll be at sea.
Correct.
But practically we find that in a lot of benches, the judicial member is silent and the technical member takes over. And then there are problems that follow with it. There are problems with judgments written, the reasoning of judgments, which are susceptible ultimately in challenges before the higher forums. I mean, this is just symptomatic. My larger point is that we really need to look at, not just in terms of retired High Court judges or retired Supreme Court judges being on the tribunals, but we need to look at the criteria of appointments to these tribunals as a whole. And very seriously, that needs to be looked at.
Correct. I agree.
With the permission of the panel, if I may just intervene.
Yes, we are short of time. But
just a very brief sentence that, what we also need to do is discipline the entities which are involved in this entire matter. As I understand the original side practice, there are elaborate laws relating to impediment and intervention. In one of the IBC matters recently, Income Tax Department was not a party to the proceedings before the NCLT, but has now tried to intervene at the NCLT appellate stage. Now that needs to be disciplined.
Correct.
Just a good thought on that is that when it comes to merger proceedings before the NCLT, they have to pass the first motion order within 30 days of reserving the order.
Right.
So something like that can easily be put into the IB code. If they can discipline themselves for mergers, they can discipline themselves for the IB code, and hopefully then company law matters can be heard because they get no chance for that.
That can be done. Coming to Ramakrishnan sir, this is the end of the session. In my practice, I have had very few instances where I have been asking questions from the senior advocates. Otherwise, they have been asking questions from me as a briefing counsel. So I'm enjoying this opportunity. But no more, sir. I have nothing to ask you. Any closing remarks for you, for us, for all of us, with your experience, are most welcome.
You have heard the opportunities and the challenges of IBC. I want you to carry two images in your mind. Now, we have read about celebrity deaths. Celebrities with huge biceps, abs to die for, that kind of celebrities working out in a gym. Cardiac arrest, sudden death. This is one image. Second image is tomorrow you have a huge opportunity. Somebody says there's a marathon in your neighborhood. You don't have to win the marathon. Just participate. You'll have crores of rupees coming in. This is an opportunity. There you must remember the first man who ran the marathon in Greece, he died at the end of it. So what is the takeaway for you as law firms and general counsel is you need to prepare your client for these pitfalls, challenges and opportunities. Now, the businessman typically looks at turnover, looks at bottom line, and he looks at valuation. So he gets onto this biceps, abs, and then you have a sudden death of liquidity, insolvency coming in. Similarly, you have, as Manisha pointed out, huge opportunities for purchase, but you don't have the wherewithal. That goes into debt again. So you need to, I think, as general counsel and law firms, you need to start living with your clients, more closer interaction. You can't be a surgeon in the emergency ward anymore. You need to be a life coach. You need to be a general practitioner, warn them ahead, have a 2-year horizon, which you are qualified to give them. The businessman won't have that kind of a horizon because he's had today's opportunities and today's problem. That, I think, is the takeaway from this discussion. Your role as counsel is much more modulated and much more challenging, evolving.
Thanks a lot, sir. That was an excellent summation. Any questions if we have? Otherwise, we'll take your leave and leave you for the other panels. Thank you very much. Thanks a lot.
Could I please request everyone to kindly come up front for a group picture? Yes, thank you.
Dear delegates and panelists, to keep yourself abreast of development, please subscribe to Businessworld Group magazines. It will add to your professional quest for knowledge and insight. There are exciting offers for attendees. For more information, please contact Vinod Kumar at registration counter. And with this very exciting first panel discussion for the day, we are now a step closer towards the awards ceremony. Prior to that, ladies and gentlemen, it is time for the next panel discussion. The topic at hand is arbitration, mediation, and online mediation, pros and cons. Join me as I welcome our panelists. Please give it up for Krishnayan Sen, partner, Luthra and Luthra Law Offices. Please welcome Ms. Radhika Bishwajit Dubey, advocate. A round of applause for the lady. Thank you. Please welcome Mr. Sameer Malik, partner, TSK Legal. Please give it up for Ms. Shweta Bharti, partner, Amarabi and Solomon. And joining us shortly will be the final panelist, as he's running a little bit late. He'd be joining us straight up from the airport. That would be Mr. Karan Singh Chandeok, Practice Head, Competition and Dispute Resolution, Chandeok and Mahajan. And completing this session, this panel, please welcome the session chair, Ms. Petal Chandok, partner, Trust Legal.
So thank you very much for this introduction, and thank you so much for allowing us to be this part of this really esteemed panel. So welcome all of you firstly, and I won't go into introductions because we've already done that. We'll straight away hit at the session because we're already behind schedule. So we are now today discussing about arbitration, mediation and online mediation, and what are the pros and cons that goes around these three alternate dispute resolutions. And of course, as lawyers, we all understand that including litigation and these three aspects, there are a number of pros and cons that we see every day, while we are dealing with the matters, right? So understanding about arbitration first, I'll go to Mr. Sen to begin with. Mr. Sen, we have experienced, I'm sure you also must have experienced that sometimes people or companies, especially individuals, do not prefer arbitration as a mechanism to resolve disputes. Do you think, and also somewhere when we go through an arbitration proceeding, it results into an even lengthier process. So do you think that the purpose of an arbitration proceeding is actually defeated?
Thanks, Peter. So essentially, arbitration was meant to be the silver bullet, which will be the panacea of all woes of litigation. And that was the original intent, right? And so whichever were the advantages, in effect has become, in a way, you could say, a disadvantage as well. So for example, first it was meant to be a fast procedure, or rather faster procedure. Certainly it is not. It's become quite a lengthy proceeding in itself. And this is despite the statutory correction that was made a few years earlier. Simply because of the point you mentioned, is that it has just become a pre-litigation proceeding. Because the other advantage of arbitration was it was final and binding. As practitioners, we all see that it's certainly not final. All our clients, invariably, the moment the award comes, whether if you are winning, if you have won the matter, you file the caveat. If you have lost the award, you file the challenge. That's the simple, the simple standard operating procedure. So therefore, the challenge mechanism is also a lengthy procedure. You have all the way to the Supreme Court. It's usually again a 3-tier process. So the benefits of arbitration as a fast procedure is certainly not there. Cost-wise, again, it's a very expensive mechanism. And as you said, individuals, I don't think individuals prefer arbitration at all. For individuals, mediation would certainly make sense. Business disputes, usually arbitration is the main step, the main redressal mechanism, simply because the courts can take even longer.
Right.
So that's my take on it.
So I think more particularly, we do see that the purpose of arbitration is somewhere being defeated, right, in some way or the other. So Ms. Bharti, I'd like to understand when we talk about arbitration, of course, like Mr. Sen also mentioned. Welcome, Mr. Chandyok. So Mr. Sen also mentioned that mediation, of course, is something which individuals as well as I think many companies also really prefer. How do you feel that online mediation, especially now with the tech being so prominent, how is that going to be a game changer going forward?
So why only online mediation? I think if we are talking about the online version of the dispute resolution, that is called the ODR, I think it is an idea whose time has definitely come. And COVID has accelerated the entire process. After COVID, we have seen there to be a surge in terms of e-ADR also happening. We have also seen e-mediation happening. And there are various reasons, why it has now taken prominence. I remember in 2013 or 2014, I had spoken in one of such conferences about ODR. And since then, I have seen there to be a huge kind of a revolution in that sense. From 2015 onwards, there are organizations who have been set up in this regard, and they are doing a brilliant job. Sama and all has come since 2015. And, the only reason why e-mediation or online mediation has not become as successful as it should be was because there was a lack of awareness. When we start talking about it in these conferences, I think the awareness will also come, and that will also add on to the success of these processes. And so far as the online mediation is concerned, just look at the advantages that it carries. You can do mediation from wherever you're sitting. You don't have to come to the place and do the mediation. Then that in itself is a huge kind of a challenge. I mean, Karan is coming directly from the airport. He could have attended the session from wherever he was. That kind of availability of the whole idea is something which is a game changer. Then the cost aspect of it, because if you are traveling, commuting, those kind of issues are also going to make a lot of difference. So why only online mediation? I mean, for online dispute resolution also, I think it is going to be a game changer so far as the cost is concerned. Time also, because you are able to attend to these hearings wherever you are sitting. I think in terms of timeliness also, you are able to save a lot of time. So I think this is definitely is a development in the right direction. And after, I'm sure Karan is going to talk about it a little bit more, but then after the Singapore Convention that India has ratified, the mediation agreements have also now, or the settlement agreements have also now can be enforced. So that is something which is, paving the way for mediation, and online dispute resolution is the way forward in that direction. And if you look at the history of ODR in that sense, I think from 2006 onwards, when Nixie had come the first time, when the domain disputes could be decided in that sense, I think that was the genesis of the online dispute resolution. And since then, if you look at globally, the kind of trends that is there, most of the consumer disputes are now being shifted to online mechanism. So if the world can actually do it, India can definitely do it. And I think there are, amendments which are also being brought in so far as the e-commerce regulations are concerned, the Consumer Act is concerned, to include the process of online mediation or online dispute resolution in that sense. So consumer disputes can definitely be taken up in that sense. I also feel that IP disputes can also be taken up through, online dispute resolution mechanism, because IP disputes also are not a very complicated set of facts and law. So for those kind of matters which are not very complicated in terms of set of facts and law, those are the kind of matters which can definitely be taken up through online dispute resolution. Then there are section 138. I mean, our courts are clogged with the amount of matters which are pending at the moment before the metropolitan magistrates. So I think if we are able to take those 138 matters which are not very disputed, the ones which have a straight set of, you can identify the signature, you can identify the person who has signed, then you do not really need to clog the courts of India. You can actually shift all of those through ODR mechanisms. E-Lok Adalats have become very, very common. So I think it is an idea definitely whose time has come and has evolved.
And I think with the Chief Justice really emphasizing on online proceedings and having hybrid mode of proceedings, I think it's very important that the infrastructure also should be such that all the lower courts and all the other authorities are able to actually do
So
this.
that I think is the only reason why it has not picked up so
Right.
well. One is of course the lack of awareness, and second is because there is a lack of digital infrastructure that
It
is
is,
required.
yes.
Although I think the government has done some bit of it by having those common service centers,
Absolutely.
which are at least taking the internet now available to the villages also of our country. And with smartphones, I think most people now have the entire this thing in our hand. But awareness is something which still needs to be created. So once we have the digital literacy and we have the digital infrastructure, I think ODR will definitely pick up.
Right, right. So Mr. Malik, just to, yes.
In fact, the Chief Justice has specifically asked these senior counsels, most of them, that you will only use your iPads and no paper would be allowed for the purpose of argument. Yes, paperless arguments. So that is a step towards it.
Absolutely.
In fact, just to add value to it, to add that much of credence to mediation in the country, this new mediation bill, which was introduced in 2021 rather, the standing committee report has come on that. The problem with mediation that existed was always this, that how do you enforce those settlement agreements? Now those settlement agreements, unless those are coming out of as a certificate or as an incorporation into a judgment or a decree or into an award under section 30, they are not enforceable. So the problem that existed in mediation, I think and I hope will soon get resolved because of
the
that.
Singapore Convention, that issue has also been taken care of to that extent. Now
To
it
that
can be
extent.
enforced as a decree.
It has, but I
It is
think
to that extent, but it needs a local enactment to that effect.
I think the only issue will be implementation, how fast we are able to implement, because we also face the issue of, at the end of the day, the agreements that we are executing, they are not enforceable. So somewhere I think the time for implementation is something that we have to wait for. So
the bill which is proposed, the act which is proposed, makes a specific provision to the effect that mediation settlement agreement, they'll be equivalent to a judgment or a decree.
Correct, correct.
Like a settlement agreement arrived in the conciliation proceedings under section 74 of the Arbitration Act.
Which is very important,
yes.
because otherwise we will have to again go back into a litigation claiming that, this has not been complied with. Nonetheless, so Mr. Malik, going forward and understanding from you, what are the very important ingredients and aspects that we should bear in mind while we are drafting let's say a dispute resolution arbitration clause? What are those aspects that we should actually bear in mind while doing that?
So I think the most important aspect that we always tend to forget is that we need to keep drafting very simple, and particularly the arbitration clauses. What I've seen, and those are very convoluted arbitration clauses where you can't really understand what is the intent of the person who has drafted it. If you're talking about an arbitration, it has to be either you are talking about an institutional arbitration, then adopt the arbitration clause that exists in their rules. Otherwise, don't. Rather, being innovative creates a problem. As my friend just pointed out, the problem is that once you initiate arbitration proceedings, then what happens? 34 is there, then thereafter appeal is there, then SLP is there. So the entire process becomes convoluted. And the problem is that if your arbitration clause is not drafted properly, you are stuck at the constitution itself, the first step itself. So you need to understand what you want to do. You want to an institutional arbitration, you want an ad hoc arbitration, you want particular rules to govern it, you don't want them, but don't confuse that you have an ad hoc arbitration, but you still want certain rules to apply. You are mixing the two things. You are placing jurisdiction somewhere else, you are placing the law somewhere else.
Right.
All of these creates problems. All of these creates problems, and they all lead to fantastic judgments that the Supreme Court has delivered on these issues.
Absolutely.
It is good for us, but not for the clients.
Right.
In fact, I feel just to add and supplement to what Mr. Malik mentioned, the problem is that, these are considered as those boilerplate clauses.
Yeah.
We don't have to apply our minds to this. This
Exactly.
is something which is like right
Yes.
there. You have to just cut, copy, paste.
Right.
Unfortunately, the case be. But the problem then arises, and we dispute lawyers are very happy with that. Mind
Yeah,
you.
yeah, of course.
We love these clauses because that's where the interpretation and the dispute sets in,
Right.
and they come to us.
Right.
But I feel personally, you need to spend time on these clauses. Like Mr. Malik mentioned, you need to understand what is the kind of contract, right? Number two, would you want to, layer it up? Would you want it to be a multi-tier dispute resolution clause? Would you also want to, like he mentioned, the seat venue? You'll have to be absolutely clear and unambiguous when drafting your arbitration clause. Additionally, what people don't spend time on is the arbitrability aspect. You would also want to maybe spend time on certain disputes going to, let's say, an arbitration, certain disputes wanting to be referred to court. We don't spend that kind of time on, clauses such as this. If we do that, I think, and get into a little bit of more specifics, it can really add value.
Help us into avoiding
And
Most definitely.
and a very quick point to add there is, especially for international arbitration, foreign seated arbitration, Singapore seated arbitrations, for shareholder disputes after the Anupam Mittal judgment, it's very important that please specify that your law of the arbitration agreement also should be specified to be Indian law. Right. Otherwise, you are running into a complete quicksand there. Yeah.
Right. So Radhika,
No, actually, my only point, especially on arbitration clauses, is a lot of times, especially when corporate lawyers and excuse all of those in the room who are, is the fact that the question is, do you want to arbitrate? Right. And or is arbitration the better forum? I mean, for example, the way courts look at India for choice of jurisdiction clauses, exclusive jurisdiction clauses, suppose you have a foreign jurisdiction clause, I'm talking about court jurisdiction, vesting a court elsewhere with jurisdiction. Those are looked very differently rather than when you're looking at an arbitration agreement, which may say there's a seat for arbitration in Singapore. Singapore would reply because there is a more pro-arbitration focus. Whereas when you look at courts, they maybe say, is this forum non-convenience? What rules of private international law will apply, and so on and so forth. So the question is, do you want to arbitrate? Is it beneficial to arbitrate? And to Radhika's point, is it even arbitrable?
Yes.
So those are, and of course the cost.
Very important.
The cost involved, and especially whether you want to write whether the schedule applies to the clause or not. So the drafting of the clause has to be very intentional.
Right.
And practically anything less than 10 crores, at least my experience is, I don't think it's worth going to arbitration in India.
I agree.
It will not be viable.
Right.
That's a great point. In fact, one of the things which we completely miss out is, when we add 3-member tribunal.
Right. Very costly.
It's when the dispute happens, that's when you realize, how do we get to a sole arbitrator?
Yes.
How do we reduce costs?
Most of the clients, in their zeal, I don't know, they think that the arbitration is very fancy and they should actually put that clause somewhere. Some corporate lawyers do that. So they come back and they say, but why do we need 3? Because it is that point they realize that the cost is going to be so high. And then there are other issues which crops in. When the arbitral tribunal is telling you, this is the fee that I want, not of the standing schedule 4, you can't say no.
My favorite.
I have seen, to start, before these amendments came, there was a matter they were rising out of Chandigarh. 3 arbitrators spent almost half of the claim on arbitral fee, hotels, etc., etc. Supreme Court, I was appearing for a public utility. I requested the court, please change this tribunal. I want only 1. And then 1 judge was appointed. and he concluded it within next 3 months.
These are certain
So,
handicaps.
This is before the amendments came. It was so difficult then to even to persuade and talk about arbitral fee. It was a non-starter.
Right. So Radhika, just to understand from you, when we talk about drafting of the arbitration clause also, and specifically the seat and the venue, etc., how to tackle with a issue where sometimes the parties are not even, let's say the seat of Delhi has been mentioned in the arbitration clause, and the parties itself are not from, let's say, Delhi, or they don't have offices in Delhi. And the jurisdiction, while let's say at the stage of section 34, how do we determine, and if the pecuniary jurisdiction is of a lower court, how do we determine the jurisdiction at that point in time when we are going for a section 34?
See, the moment the clause has seat as Delhi courts will, have jurisdiction.
So which district of Delhi will have the jurisdiction?
No, depends on then, the value of the matter.
Right.
So, it depends on the matter concern.
Right. So this is a concern which I think is, so let's understand from a perspective why, because when I also feel when parties are not from a certain jurisdiction, we should avoid having that jurisdiction.
I
in the
totally
first
agree.
place.
So therefore, spending time on drafting of the clause itself is very important.
Yes, yes.
The basic concepts as to, what is a seat, what is a venue, what is the difference between,
right.
Sometimes you're using these terms interchangeably, though, pretty
Yes.
much the law is settled after BG Soma.
Yes.
But there's still gaps. In fact,
Absolutely.
I have done a matter very recently, and the DB judgment should be out in that, where the question is, if there is a jurisdictional clause, like courts of so and so will have jurisdiction, right? Say, let's say it's Gurgaon, right? And your arbitration clause mentions venue, right? Then you know where to go, what to do,
Right.
and what will take over, because BG Soma says venue has to be read as seat, right? But then you have a jurisdictional clause, and then it says the contra indicia, so we have single judges, having opined on it divergently,
Right.
but we don't have a DB judgment yet as far as Delhi High Court is concerned.
concerned.
And let's see what will Justice Sanjeev Sachdeva do.
This
So,
is
Mr.
one of those
Chandiok-
examples of convoluted arbitration clauses.
Right,
And-
exactly.
And as you rightly asked that question, and is very pertinent.
Yes.
As to what happens, she rightly said that wherever is the seat, venue
Yes.
has to be read as seat.
Seat, right.
So you specify that, the problem is solved. But the problem is that when you have non-exclusive jurisdiction clauses in the arbitration
Right.
agreement, what do you do?
Right.
Because section 2 of the Arbitration Act says that then the jurisdiction will be decided
Right.
as if it was a civil suit.
Civil suit, right.
And then what happens is section 42 kicks in, which would
Absolutely.
say that wherever you first invoke the jurisdiction of whichever court, that court will have jurisdiction for all purposes, section 9, section 11, then section 34, and later
Absolutely.
whatever proceedings.
Absolutely.
So that's how the jurisdictional part is taken care of.
Right, right. So, Mr. Chandiok, just to also understand, when we talk about dispute resolution in terms of arbitration, do you feel that mediation should also be one of the prerequisites? Of course, we know in the commercial courts that it is a prerequisite that we have to. But do you feel that while we draft an arbitration clause, let's say in a contract, should mediation actually be a prerequisite before arbitration is even invoked? And how effective is that?
Okay, sorry, before I answer that, first, let me apologize for being late. I asked for a Passover, but it's an ADR panel, so speed is important. So this, so coming to your question, I think mediation is always a great process because it helps restore relationships. And of course, if you're getting into a contractual relationship with an opposite party, a counterparty, you want to be able to preserve that relationship before it goes to dispute. I don't think so anybody goes into a contract thinking that that I'm here to dispute it later. That's a backup option. So from that perspective, yes, and therefore it has to be, if it's written in the contract, parties agree to it, yes, certainly it should be. Now, whether or not it is mandatory, there is various views on it. especially under the earlier drafting of the mediation bill, which did make it mandatory, but left, it was sort of the section was lawyer's paradise. It said, it has to be irreversible, urgent, and so on and so forth, which even the standing committee has looked at it and say, the fundamental of mediation is a voluntary process.
Absolutely.
And therefore you cannot by virtue impose on it, yet recognizing the fact that the parties may be referred to mediation by court and so on and so forth.
Right.
So if the parties contract for it, certainly. But of course, keeping in mind that you can parallelly, and which the mediation bill allows for it, parallelly seek urgent relief.
Right. And how effective is it?
So okay, let's take a statistic, right? So if you look at the Delhi High Court attached mediation center, Samadhan, that has in the last 5 years or so done all manners of cases. And if you look at a lot of the original site filing on the Delhi High Court is IP litigation. So about 14,000 odd cases were referred to mediation. To Samadhan alone, right? They refer it to the rest of the world as well, but to Samadhan alone, 14,000, and about close to about 8,000 cases were actually settled. And so that's an overwhelming majority. I mean, yes, the statistics would say that's nearly 50-50 or so, but not. But the fact is that those were settled. It reduced litigation cost. It reduced the burden. So even though the number may seem 50 is a good number. If you look at it in the overall scheme of things.
Right.
And it's mostly not very effective when lawyers themselves fight between themselves.
In fact, I like to add to the effectiveness part. See, there are 2-3 aspects to the effectiveness. One, lawyers part is important because I feel as such for lawyers, there is no incentive. What is the incentive for a lawyer there to have the matter settled? The other problematic and practical aspect is we do not have trained mediators. Just getting a training or a 40-hour training doesn't make you a good mediator.
I agree.
The approach is so different. The manner in which you have to conduct the mediation is so different. So I act as a mediator, I act as an arbitrator. But when I'm sitting as a mediator, my approach is very, very different.
Absolutely.
It has to be, and it comes with experience. So we are lacking that today. That is number one. That's a practical problem. The other aspect is all the other stakeholders involved and their approach as such to mediation. That is also very, very important. Because today what is happening is that lawyers just by choice do not attend mediation hearings, unless of course they want the mediators to be asking them to please step out. So they choose not to attend these hearings. That is number one. But the instructions to the parties is very clear. Aap sun ke aiye, and we'll deal with this. It's just a process we need to get over.
I agree. Yeah.
So that intention and the approach itself is not there. If the part and it's not their problem, because I'm sitting there as a mediator and these parties are coming to me for the first time, right? You have to develop that trust with the parties. It won't come on the first hearing. So that's why the training part is very important. How do you deal with the dispute at hand?
I agree. In
Can
fact,
I just add a third to what
yes,
I think that's the important part is also to train the lawyers who are representing those parties, because I cannot tell you how many mediations I have been in as either acting as one or there where I'm addressed as my lord and I'm like, when did I get elevated? Because the mindset still is its adversarial
of the court.
and that the fact that, and it is the mediator's job to make sure that it is conciliatory and to put that forward. But when you have your trusted advisor sitting next to you and trying to make a point to the other side, that is not conducive to the whole concept of amicable.
Absolutely, I agree. And in fact,
why I think conciliation failed.
Absolutely.
Like under the Arbitration Act. So for under the Arbitration Act, we had a conciliation. It's also Arbitration and Conciliation Act. I've acted as a conciliator in many proceedings, and it has failed miserably.
Yes, sir.
And that's one of the reasons, because it's like an adversarial process. Your lawyers are there, they're arguing it as if it's a court matter.
Absolutely. In fact, I myself have experienced that we have a dearth of trained mediators here. And while when we do mediation anywhere abroad, it's very different, and they are very professional, and they are going to, probably I've done mediations outside where they actually settle the matter in one given day. Even if it takes 9 hours, 10 hours, they will finish it. They will not, and they will not even let the parties meet each other, because they understand if the matters are of, of a sensitive nature, or if it can lead to an adversarial situation, then they will, probably work it around that way. So I understand. Ms. Bharti, coming to you, when we, of course, you discussed and you shared with us how ODR can be a very effective way of, or a game changer in the near future. What are the handicaps that are attached to it? Because
before coming to the handicap, Patel, I would want to add to the question that you have posed earlier in this regard. I think, and I'm a very strong propagator of med as a concept, because once you have explored mediation and you have realized where do you, stand,
Right.
and if it is only the ego of the parties which is not letting them settle, then in that case you go back to arbitration.
Right.
And the arbitrator thereafter adjudicates on the issue, and your sense of, you're able to then gauge on where you stand legally as well. And then when you come back to mediation, I think it really works well. So if we are talking about, high value disputes, I think med is definitely going to have a future ahead of us.
Absolutely.
So, and making it mandatory in that sense, I don't think that any law can make arbitration or mediation to be mandatory, because this is something which is because of the choice of the parties. So both, the dispute resolution concepts have its own limitation in that sense, that it cannot be made mandatory by the legislature. So unlike the Commercial Courts Act, where it can be, because there are certain kinds of disputes which are taken before the commercial courts, here in the arbitration sphere, it is more about the party's choice and willingness. And that is how you decide on the venue, seat, everything is because of the choice of the parties. Right. So that is how it has to be. So we as lawyers have to be sensitive that to understand whether it can be, or the disputes can be resolved between the parties through mediation. We have recently, in fact, in one of the arbitration matters, and it was the arbitrator who actually pushed the parties to try and settle, because he said, see, these are the loopholes in your case, these are the loopholes in the counterclaim. Now you decide whether you want to go ahead or not. I have not made up my mind, but I can tell you what the loopholes in both the cases are, because you have reached the evidence stage.
Right.
And at that stage, when the parties realize that it is possible that we may or may not get what we are actually fighting for. So it was the time when we really were able to push the clients, and the clients were able to settle the matter. So those success stories are also there when we talk about mediation.
I think in that lawyers also play a very important role.
Very important role, absolutely.
To give
Very
a correct
important
picture.
role. And what she pointed out is really very important issue, meltdown of ego. Because
Absolutely.
When does the dispute happens?
When they know that there there are certain loopholes in the matter, is when the meltdown of the ego also happens
It is
somewhere.
one of the most important ingredient of the recipe of dispute.
Absolutely.
Clash of egos. So when you talk to each other, those egos come down.
Come down.
Many a times they come down. If that doesn't come out in one go, it will come down in the second go.
Right.
Sometimes it happens twice, thrice people have gone to mediation. On
Absolutely.
fourth time, they have ultimately resolved the matter.
Yes,
Recently, that has happened to me.
Yes, same here. Yes, absolutely. Yes.
Yeah, so coming back to the question that you had asked, I think we addressed it in the first round itself in terms of the challenges. Of course, the digital literacy is one very important factor, because I think 70% of our population still needs to understand what ODR as a concept is. There are very few people who understand it. So unless and until we have a sense of digital literacy, people will not be able to take it up as a process. Second, of course, is the lack of awareness, as we mentioned. I think it is important to talk about in these forums on the virtues of ODR and why and how it should be attached to the consumer courts to reduce their burden, and also with the other metropolitan magistrates, etc., to be able to reduce their burden respectively. And third, very important, is the digital infrastructure, which the government is already creating in that sense, but there is still a lot which is required to be done. The penetration of the internet to the rural villages is something which is necessary for us to develop ODR as a concept. So I think till the time all of this is not done, we still are a little behind in that sense in terms of implementation of ODR. But with the legislature, the judiciary, and the executive all thinking in one direction so far as the implementation of ODR is concerned, with Niti Aayog coming up with its report also. And then if you look at the RBI also, which has focused on all the disputes relating to digital payment systems to be only resolved through the online dispute resolution forum. SEBI also coming up with this platform called SCORE for the resolution of the
It's very
disputes.
good, yes.
I think there is a lot of work which has already been done. So it is now about just seeing the dream to be a reality in some time that we are seeing.
Mr. Sen, to
I'll just add to what ma'am mentioned. You see, I think the problem is a little more basic. The first thing, as she mentioned, the access to technology, but access to technology also has very many dimensions. One is, as basic as having a steady internet connection. When you're having these hearings, as such, the problem is that, you're dealing with someone who has a bad network. These are practical issues, right? The other is the comfort part of the parties to deal with technology, and I'm talking of bulky matters, voluminous matters, where, either your filings are that efficient that, if a lawyer is referring to a particular document, he's able to, the arbitrator or the mediator, whatever, I mean, arbitrator more so, is able to, get to that document very quickly. Otherwise, it can be a very frustrating exercise. Add to that, I also feel there's a little disadvantage, especially with respect to mediation, because mediation, I feel, requires that personal touch. Which will come in only when, I feel you're sitting down with the person, you're trying to understand that person's body language, I'll share an example. In fact, I was acting as a mediator in this matter, and this lady, and I refer to this a lot, we were struggling with both the parties. It was a simple property matter where, they were all in agreement that this property needs to be partitioned. Like, only one had to understand what floor will go to which brother. But this particular lady, who was a widow, she was not agreeing to any solution which was being offered by the brothers concerned, right? And we as mediators were watching, and at the end of it, my co-mediator, we were like, then we might as well send the matter back to the court. To that, the lady immediately said, no, I need one more hearing. You don't send the matter to court. So we adjourned the matter, that we'll take it up the next time. Now, when the other brothers left, this lady walks up to us and tells us, I am going to settle this matter, but I'm going to push them, I'm going to frustrate them, because when my husband passed on, they really created a ruckus in my life. They were not supportive. So now is my time. The point that I'm trying to make is, these are things which may not come out in an online platform. The problem may be, the cause for the dispute may lie somewhere else, right? But you may not be able to appreciate or understand that. Right. That may just come out only through a physical platform.
Absolutely. Absolutely. Yeah. Mr. Sen, when we talk about, so because we are short on time, we'll go as per the schedule. So Mr. Sen, when we talk about, of course we know now with the judgment that the stamping of arbitration contract is is mandatory, and only then it is enforceable. Of course, it has been interpreted also in various ways. We have seen somewhere that a lot of times corporates also have very basic contracts. Like you mentioned, ideally, any arbitration should only be in a contract which has a value more than 10 CR. But how it has been happening is that in most of the contract, actually all of the contracts, even employee contracts, one wants to include arbitration because it's a more controlled proceeding in some way, and the corporates think like that. Now, when we think of that, and when we think of the procedure that we need to follow of stamping those contracts, of course, it looks like an impediment in, ease of doing business. What is your take on that?
Well, it's possible, of course, as we all know, the judgment has come under severe criticism, and there could be a relook. The Supreme Court could have a relook at the judgment, but as it stands, that is the law. So I don't think, as far as that is concerned, we will have any option or choice. We'll have to go ahead with it. One very important function and benefit of arbitration, and to some extent mediation also, is confidentiality. We shouldn't lose sight of that. So that's one thing which a court litigation will simply not be able to provide, because it's, by definition, it's a public proceeding. Whereas in arbitration, it really helps. In fact, the other day in our firm, there was a discussion as to, in our engagement letters, should we have, what should we have as a dispute resolution clause? All of lawyers, we have engagement letters. Should it be a simple dispute resolution or should we have arbitration? There's a lot of internal debate as to what it is. And my take on that was that don't forget confidentiality is something important. So if you have a rogue client and there is a lot of fees pending and you want to go after that fellow, then it's something which you don't want to go for the court.
Absolutely.
It's something which you want to do it in private.
Yeah, like you want to keep it restrictive and controlled.
Yeah,
maybe.
for the record, we have not done any of that, but
Mr. Malik, yes, you want to.
One can provide for a provision of expedited or fast track arbitration.
Yes.
So now with this new amendment, one can actually finish arbitration within 6 months. One can say that there will be no evidence will be led,
Yes.
no hearing will be given.
Yes.
Only
In smaller contracts,
Yes.
that can be done.
So you only
Yes.
say that you file your pleadings, no hearing, and there will be a award. That's
Right.
it.
Right.
So it
Mr. Malik,
helps.
yes, in foreign contracts, if you can elaborate on this, that how much, of course, we did discuss that how seat and venue can be very, very important when we are actually, drafting the clause. Especially in foreign contracts, when there are foreign parties involved. What is your take in that? How important it is to, specify the seat and the venue, or let's say the place very, very categorically, and how much
It is
importance that
extremely
plays?
important. And once you suppose there's an Indian party and there's a foreign party, you are entering into an agreement, and then you want to arbitrate, then it is very important to understand that the emergency awards, so-called emergency awards under C Act rules, if they are passed, there is no mechanism to enforce them here in India. So
Right.
you only remedy that is available to you in that case would be you file a Section 9, and courts have held that in those cases you can file a Section 9.
Right.
That continues to apply after the amendment that eased off that problem.
Right.
But earlier there was no such mechanism.
Right.
So it is very important. In fact, interestingly, the Supreme Court has recently given that judgment where even Indian parties can choose foreign seated for arbitrations.
Right.
So where, for example, the disputes are huge and the confidence in their system is more as compared to ours because of the vagaries that we
Yes.
face. People are choosing that. It's a recent trend.
Yes. Yes.
Now Indian parties are choosing foreign seated arbitrations.
Absolutely.
That is
Absolutely.
happening.
So coming to Mr. Chandiokan, I think we'll close with this. When we talk about seat and when we talk about, let's say, a foreign party and an Indian party, a lot of times the Indian party feels like how Mr. Malik also rightly said that having a foreign seat is much more beneficial, and maybe a jurisdiction of that effect too, because then it's easier to enforce it in their jurisdiction when it comes to executing the orders or awards. What is your take on this? Should we do it? Should we not? How to go about this?
I think the first point is it comes down to how parties, typically parties will look to a neutral venue or a place, and that's where certain centers have come up across the world, and that is attractive to all parties, especially with sort of if you look at the fact that the New York Convention has allowed for whether you're an Indian party or a foreign party, doesn't matter. If you have an international award, you can enforce, and that is the benefit that gives you, and that has value across the board, across nationalities, across jurisdictions. That if you distinct that from, for example, the mediation, the current draft of the mediation bill does not give it that same parity.
Right.
And therefore it doesn't enforce the Singapore Convention in its full form. So there are, again, goes back to what we were discussing earlier, intentionally drafting your arbitration clause, what matters to you, where it matters to you, would mediation work, would arbitration work, would med work. All those things are considerations that it's very difficult to anticipate, especially in the euphoria of doing a transaction. But at the same time, it is important to take a step back and see what works.
Right, right. So thank you so much to all the panelists, and thank you for the audience to really being very patient with all of us. Thank you.
Could I please request you all to kindly come up front for a group picture? Let's bring up a very enthusiastic cheer for them, ladies and gentlemen. With the same, we are now breaking for a 30-minute networking lunch, requesting you all to kindly proceed towards the hall. Also, requesting everyone to kindly assemble back in the hall in exactly 30 minutes for the next session. Thank you. Ladies and gentlemen, I hope that you all enjoyed the lunch. Requesting everyone to kindly start settling down as shortly we are about to begin. Let's quickly take a look at the GC Conclave coming up on July 9th. If I may have everyone's kind attention, please, ladies and gentlemen, requesting everyone to kindly settle down. Welcome back to Global Leaders Summit and Awards 2023. Ladies and gentlemen, post-lunch sessions are a little bit difficult. Could I please request everyone to kindly stand for the next 30 seconds? Be a peach, join me. Perfect, perfect. Well, I must assure you that this is not a ruse for me to get out an applause out of you. Just when we clap our hands together, it helps us with a better blood circulation and helps us stay awake and more concentrated. Could I please request everyone to kindly clap their hands together for the next 30 seconds? Super easy. Perfect. Thank you very much. You all may kindly be seated now. The topic at hand for the next panel discussion is strategic M&A trends and opportunities. Join me as I welcome our panelist. Please give it up for Mr. Abhishek Sanyal, Partner, Economic Laws Practice. Please welcome Mr. Dushyant Bagga, Partner, TTNA. Check. Please give it up for Mr. Dushyant Bagga, Partner, TTNA. Let's welcome Mr. Naveen Kumar, Partner, Cyril Amarchand Mangaldas. Join me as I welcome Mr. Vaibhav Kakkad, Senior Partner, Saraf and Partners. Please give it up for Mr. Varun Bajaj, Founding Managing Partner, RSD Bajaj Global. And completing this panel, please welcome the session chair. Please give it up for Ms. Priyanka Duggal, Director, Deloitte, M&A Tax.
I hope no one's sleepy anymore. Yeah. So a quick, we'll just start with a quick round of introduction for all our panelists. I'll start with myself. I'm Priyanka Duggal and I am a director at M&A Tax practice with Deloitte. It's on, I think. Now? Yeah? Okay. Hi, I'll start with a brief introduction. I'm Priyanka Duggal and I'm a director at M&A Tax with Deloitte Haskins and Sells. As part of my career of about 15 years, we've handled multiple restructurings, internalizations, externalizations for our clients. And I'll be happy to share my experience here on the recent M&A trends and opportunities. I'll request each of the panelists now to give a quick introduction, and then we can start with some interesting discussion around M&A. We'll start with you, Abhishek.
Hi, my name is Abhishek Sanyal. I'm a partner at ELP. I head the corporate practice out of the Delhi office of ELP. So we advise our clients on mergers and acquisitions, private equity investments, and venture capital transactions as well. And yeah, happy to be here and share my thoughts.
Thanks. Hi. I work with TTNA. Clear? Hello. Yeah. So yeah, Dushyant Bagga here. I'm work with TTNA right now. Was with AZB for a good 15 years since basically college. So primarily look at M&A and PE investments. And yeah, happy to be here and discussing the trends around.
Hi, I'm Naveen Kumar. I'm a partner in corporate practice at Cellular Merchant Mangalas. Happy to be a part of this honest gathering.
Good afternoon, everyone. My name is Vaibhav Kakkar. I'm a senior partner at Saraf & Partners. I look after the M&A and regulatory practice, particularly with a lot of focus on issues relating to RBI and SEBI.
Hi, everyone. My name is Varun Bajaj. I'm the founding managing partner of RSD Bajaj Global. This is one of the upcoming firms. And we have grown through the new economy. So completely a first generational lawyer, growing with the India new economy story. And we have reached so far. Happy to address any queries.
Excellent. Thank you, everyone. So M&A has actually been a very, very exciting space in the last few years. Especially post-COVID, I think the M&A activity in India has just seen an uptick, which is not seeing a downtrend so far. The last year's economy saw about $150 billion deals coming through India way, with lots of economic reforms on the way, with India's commitment to doing business, right, ease of doing business in India, making changes on the tax landscape, on the regulatory landscape, along with a lot of these regulatory and policy changes. I feel M&A is really the upcoming thing. There's a lot of excitement on the deal side, a lot of excitement on the M&A side. The deal values are increasing. There's a lot of focus on IT, ITs, startups, pharma, healthcare. All of these industries are growing massively. Now, despite the global, the bleak global network around M&A for, global economy as a whole, India has still seen an uptick in the deals. So I'd like to ask, Abhishek, what do you think is one of the important factors which has contributed to India growing from a deal perspective, and what are the key, industries which you feel are being focused on the M&A side?
Right. So I think before answering this question, I think we need to take the context of the India growth story into account before I answer that question. And that is very important because, as you rightly mentioned, India is being looked at as the sole light in an otherwise bleak global economic environment. If you look at direct tax collections, for example, for 2022, we've reached the highest ever, 14.12 lakh crores. If you look at indirect tax collections for 2022, and that has been, I think, close to 13 lakh crores, adding up to 27 lakh crores. Now, these are the highest numbers that India has ever achieved in terms of direct tax rates. And what is also healthy to look at is that direct tax is actually higher than indirect taxes, which is always a healthy sign. Otherwise you would generally have a situation where your indirect taxes would be higher, the collections would be higher than direct taxes. So the government is flush with funds. That's point number one. Point number two is that the Indian economy is going to be the third largest by 2029, 5 trillion by 2030 and 10 trillion by 2041, 2042. Now, there are a lot of steps that we need to get right to actually reach there. And then, we keep talking about demographic dividend. India has a population of 1.4 billion people with a median age of 28.2. If you look at China, they're at 39. So there's a huge demographic dividend. And this population, which has a per capita GDP of 2,200, this is going to increase to 4,000. So you can see the consumption story that is going to play out in the next few years. And we absolutely need to get it right to achieve where we want to reach. Then if you look at the infrastructure push that the government is giving, $1.7 trillion are going to be invested in the infrastructure sector in the next 5 years. Now imagine what that is going to do to various sectors of the economy. It will have a trickle-down effect. Now, some sectors, for example, real estate, logistics, and hospitality and travel, are obvious winners in this, in such a situation. But that will also reduce your cost of doing business in India. Now, so these are some macro factors which are playing out why India is being looked at as the next beacon. Coupled with that, let's not forget, you also have the whole geopolitical situation of companies wanting to divest to sort of spread out their manufacturing ecosystem. So they want to follow a China plus one strategy. So all of this is augurs well for a country like India. Now, if you look at the transactions that have happened, there are some very key factors that have prompted companies to undertake strategic M&A. One is growing their core business. So you have, for example, coupled with that, on the other side, on the sell side, you have situations where people want to divest their non-core businesses. So, for example, Wholesome selling its shares in ACC and Ambuja to the Adani Group is one such example. Then you have situations like Viatris selling its biosimilars business to Biocon. You have situations like Citibank selling its consumer banking business to Axis Bank. And then you also see another play where you see companies that are consolidating. So you have the Inox PVR merger as an example. You have Sony and Z merging. So that's another example of that. And another theme that we've seen that is playing out is a lateral play that companies want to have. So for example, you have a situation where a Zomato acquires a Blinkit. A company that is engaged in food delivery now also wants to expand into micro deliveries. And then you have other situations like, for example, what's that? The Bacha Masala acquisition by Dabur. So, that's another play where a company wants to, so you're seeing both. You're seeing companies wanting to double down on their core, and you're also seeing companies wanting to, have another line of business that they want to prop up.
Right. No, I totally agree. I think strategic investments are something which the clients definitely have. There are a lot of companies who have big pockets and they definitely want to expand vertically, horizontally, both. One more interesting thing I'm going to add is the private equity. The private equity has a huge chunk of money that they're waiting to invest, right, and waiting for the right deal. So I think my question is going to be for you, Varun. What do you think are the key trends which are going to be in the private equity space? And how do you see private equity playing a critical role around the Indian M&A dealscape?
I think this is a very good question in the context as we stand, especially the geopolitical position. Now, I think to answer that, we'll just throw a bit of macro numbers and then you can come back to it. India broadly $3.5 trillion. First $1 trillion we took 60 years to reach there. Next $1 trillion we took 12 years to reach there. And the last trillion is from 2014 to 2019. It's like 5 years. Now, if that is the movement, now as 2023, next 10 years, we are targeting a $5 trillion mark by 2017, and I would say a 10 trillion by 2030. And I say this because we lead that policy think tank at the government level also. So we are into a lot of policy think tank. So just imagine in the next 2 years, you're talking about that kind of wealth creation, which has not happened in the last 73 years. And out of this, you talked about private equity dry powder. You have $3.2 trillion with global PE and VC funds looking for a market. Now the question is, which is the market? Now there are top 5 economies, right? US is growing at 1%, China 4.5%, Germany is under growth. Japan is hardly 1%. India is the only bright spot, which is 6.5% growing. And they say that even it's projected. Out of this $3.2 trillion, they're saying around 600 billion is a known number in a lot of the reports, but I think $1 trillion. Just imagine the kind of M&A activity and the private equity investments is going to create. I think India is the space to be in, and it's great to be a PE and M&A lawyer right now. Just last coupled with the fact, and I think this is the reason why the foreign law firms have seen through this and they're trying to tap in this market. And that's the context. They don't want to go into courts. This is where the dollar lies.
Vaibhav, I think you want to just add on something, right?
Yeah. First of all, I think with greatest respect to all the esteemed panelists here, I have a contrarian view. I don't share the same level of enthusiasm when it comes to M&A deal activity as my fellow panelists do. I think, look, at a macroeconomic level, as Abhishek and Varun both rightly pointed it out, that we have certain things going very well for us. One, the large domestic market that we have, largely consumption driven and so on and so forth. So it is, of course, all the macroeconomic factors make India an outlier in the current sort of downturn that the global economy is seeing. But, if you actually think about it, whenever you look at business growth and whenever you look at business growth cycles and corporations, when the economy is growing at a very moderate pace, companies continue to flourish and do their business. But when the economic activity is extremely rapid, that's the time when a lot of businesses fail as well. And, to be very honest with you, my experience and a lot of my other colleagues in other firms is that over the last year or so, see, a lot of business cases were made on the basis of the use of digital technology around COVID. And as soon as COVID sort of situation returned to normalcy, a lot of those business case assumptions on the growth based on technology has obviously taken a huge hit. We have in the last 8 to 9 months seen almost 40 to 50,000 people losing their jobs in the tech sector. The cost of debt has gone up. The cost of equity has gone up. And you add to these complications the challenge that a lot of businesses are right now under massive issues of corporate governance. So you look at all of that, and most people will tell you the number of term sheets that they were churning out on a month-on-month basis has gone down. I think the global investor community is now going to go into a slightly pause mode up till the elections. Once the election results are out, I think is when you're going to again see a revival of sorts. But I think what is very critical is that, as I said, when there is such massive economic activity, this is the time when companies will also shut down. There'll be a lot of businesses that will end as well. And it is that process of ending of those businesses that will be critical. See, there is nothing wrong with, business bets going wrong. The problem in this country, however, is that each time a business shuts down, you have the SFIO, you have the enforcement directorate, everybody breathing down the neck of the promoters. That's a problem. So businesses crumbling, businesses failing is certainly not a problem that anybody should have. What I have a problem with is when issues associated with governance become the big challenge, right? Go Mechanic is a classic example. You've seen what's happened with Bharat Pay, which is in the matter of litigation at the moment. We're all reading reports of what's happening with one very large edtech over the last 2-3 days. So there is, of course, going to be these challenges. And I think the global investors are getting nervous. And I'm sure you being a part of a big four will also vouch for the fact that one of the biggest nervousness that international investors have is the credibility of numbers. The balance sheets, the numbers on the basis of these business assumptions that are made, are they genuine? Are they legitimate or not? So I think what's going to happen over the next 1 year is, I think there is a funding winter. Most tech company founders, you talk to them in strict confidence, will tell you there is a funding winter. They're all trying to shore up resources from here, there, try and reduce their cash burn. And now they're going to wait for another year or so to again hit the markets, whether it's the primary capital markets, whether it's PE. PE VC is definitely, there's a bit of a slowdown. But M&A and strategic M&A, some of the examples that Abhishek gave, in fact, I was a lawyer for Zomato when the Blinkit acquisition happened. I think all of those will continue. But private equity, venture capital money that was fueling this growth, I think there is a sense of realism. There is a bit of a funding winter that's crept in.
And just one point to add to that, and I kind of agree with what Vaibhav said. It kind of goes on to show also, in my view, that there was a little bit of short-sightedness by the investors when they invested maybe 3 years back on the digital economy, or when when COVID came around, half of these companies which were flourishing because of, let's say, Baiju or whoever they got down. I mean, after the COVID got up, the normal colleges started, educational institutes, whether it was medical, everything changed. So I guess now all these PEVC guys are taking a little more time in terms of, deciding what they want from their investments. As he said, corporate governance is a big issue. So there's a lot of kind of diligence which goes on there. So there's a slowness. I mean, the investors do have funds they want to deploy, but I guess they want to take their time and do the proper diligences when they. But yeah, I think hopefully it should pick up soon. So yeah, I mean, that's what I think.
Now, amidst this whole slowdown, what is that one piece of advice you'll also have for, the investors as well as the sell side, amidst all these uncertainties, amidst, this slowdown, what is that one piece of advice you'd want to add that?
Yeah, so I think one piece of advice, what at least we are telling investors now, that when they enter into strategic M&As, as I said, PE is a little less, they are asking promoters or let's say the founders to stay back in the company. So it's not like a full buyout at a full consideration, everything is paid upfront, right? So they want promoters to stay back, run the show for a bit, have incentive options, have incentive structures which are in place, which kind of ensures that you have some kind of backing in terms of people who are running the show. So it's not like you completely give them exit and completely they are free from everything. So that's the protection which we are kind of seeking from people.
Priyanka, if I may just add, actually, our experience is that now there's a lot of focus on getting the governance model right. A lot of oversight into how promoters are running their businesses, regular audits and checks on the credibility of the numbers that are backing the business models. And these are third-party checks over and above statutory audit. That's another sort of discovery. A lot of time is now being spent by investors in getting background checks done on promoters, which is over and above your standard financial legal diligence. Also, I think a lot of time is being spent now in negotiating agreements, clearly thinking through what will happen if there is a dispute. Because, until the point of dispute, most agreements will have trigger events, EOD, default scenarios, consequences. But how will the company run its business while the matter is sub judice? So a lot of time is actually being spent on those kind of constructs as well. Because over the last 6-8 months, there have been quite a few examples of companies going bust. Companies going bust is not a problem. Companies going bust where there are allegations of siphoning of money by the promoters, that's a big problem. And I think that is where there's a lot of nervousness.
No, I totally agree. And being a part of the consulting firm, I think gone are the days when we used to only focus on financial and tax. A lot of focus is being made on forensic and commercial diligence as well. And that's a big ask, at least from all our private equity or even strategic clients. That's a big ask. And as a part of diligence, they are focusing on forensic and commercial. Sorry, Naveen, you want to add on?
Yes, I think I tend to agree with what Vaibhav just said. There is a winter in PE and VC investment. But my sense is that that's going to be a short-term winter. If you look at the trajectory, why and when it has happened, you'll see that there is a corresponding Ukraine war that has occurred, and immediately after that, the cost of capital has gone up. Interest rates have been increased in US, which has resulted in sucking off money from global jurisdictions. That is one of the key reasons why capital or the cost of capital has increased, and that is why PE or VC would probably think twice before putting money. The second point is that when we took a long-term vision, I tend to agree with Varun and Abhishek that the long-term vision is bright and it will continue to be bright for some time. And that is why probably everybody acknowledges it. It will be an Amrit Kal. Now, the third point is in the short-term sense, apart from there being a forensic evidence or forensic diligence, tax, others. Now there is also an emphasis on verification of assets by a company. Because recently, I mean, this has been my experience in a couple of transactions. The investors have realized that the assets which were disclosed by the company were not actually there on the ground. It was all there in the books. Clearly, it was a case of fraud. So now the investor community has also started verifying the assets which are being claimed by a company or a startup. This has been seen in the startup segment. Now, this is all about the startup world. In the strategic segment, things will continue to move the way they are moving. Whether we look at the short term, the long term, Abhishek cited Adani acquisition of ACC, and I was the one who was involved in the transaction. If you look at the pattern, most of the big Indian conglomerates, I'm not saying the biggest of the big, but even amongst those conglomerates, there is a sense that now we need foreign money and foreign expertise. That is why many such group companies have foreign investment and they're increasingly increasing their stake. Kubota's investment into Escorts is a classic example. Likewise, there are many others. So my sense is that in the short term, yes, there is a winter, but in the long term, it's going to be very bright.
Thank you for that. And on the note of that foreign direct investment, this has been a topic for discussion for last few weeks because of the angel tax which has come in, right? Any thoughts around that? Maybe Dushyant, if you want to add on. So just to put a perspective, angel tax is a tax which is, I know this is a bunch of lawyers, so I don't know if tax is something which is of their interest. So angel tax is something which has just come in, where earlier they were trying to only tax the Indian domestic investors for investing anything more than the fair market value in a company. Now the tax is being levied on foreign investors as well. Now the government has come up with a list of certain exempt countries as well, but it doesn't include Singapore, Netherlands, Mauritius, and Dubai, which actually have been the biggest contributor to FDI in the past. And that's where the challenge comes in, because most of our investors, use those routes to actually put money in India. And so, any thoughts around that in terms of foreign investments?
Yeah, I think so. That's you're completely right, and we're facing challenges almost in all transactions now, because this is one move which shows that maybe the government doesn't want investment, but obviously that's not the case, because you have other avenues which are being opened up in terms of what FDI is. So, and as you said, some of the countries are exempted, but even those countries, even under those countries, there are only certain entities which get exempted. So, a normal FDI investor today gets hit by that regulation, even if it's from one of the exempted countries. So that, at least from our side, it's not the ideal situation, and it's definitely going to impact. Obviously, people are going to find ways to do things, have an entity set up in one of those other jurisdictions, because I think the 2-3 jurisdictions which have been kind of banned are more or whatever, or were used as tax havens previously, whether it was Mauritius or Singapore. So it seems like it was a trend which started when Mauritius was the tax haven status of Mauritius was taken away. But I definitely think that this really needs to be rethought by the government, and more exemptions need to come in.
Priyanka, I just wanted to answer one question. You said, what is one big trend from the sell side that we are seeing? I think what has happened is that with a few sort of very celebrated rulings, particularly what we saw with Daiichi, with Singh brothers, what Unitech went through, some other sort of interesting disputes that are playing out in court right now. I think promoters and business owners are understanding the value of reps and warranties, and what it takes and the onerous liabilities that can flow through if they are negligent when those reps and warranties are given. So, I mean, typically, people used to find it earlier a very convenient way to blame the lawyers, saying, hey, they're spending too much time discussing reps and warranties. But now I think a lot of promoters, they've understood that there is value in negotiating hard on reps and warranties, because ultimately indemnity payouts are a near certainty if there is a claim event. It's a matter of time. And with arbitration law also getting reformed, and one of the fellow panelists in the previous discussion did bring that up. So therefore, I think that's a near certainty now, that you're seeing better enforceability of contracts, particularly Delhi High Court, Bombay High Court. They're also strict on enforcement. So as a result, you're seeing that I think sell sides are also very careful, in particular about indemnity covers, reps and warranties. And as a result of offshoot of that, rep and warranty insurance is becoming again a vogue sort of a device that many sell sides are actually sort of adopting.
One point on the sell side, especially now in the startup kind of industry, non-competes are becoming very important, because a lot of time these promoters who have kind of now sold out their idea, so to say, they want to still not be out of business, right? I mean, they're all young people. They want to still do something for the country, for themselves. So that's also a very, very important aspect when you're especially looking at a startup M&A transaction.
I'd just like to come back quickly on Section 56, because I think that shows, I think we need to strike a balance between anti-abuse provisions and ease of doing business. So I think Section 56, the applicability to non-resident investors is a bane for, just in terms of doing, business in India and investing in India. you had a situation, so now effectively with 56 now being applicable to non-resident investors, you have a situation where under FEMA, you are saying that your FMV has to be your floor. But under section 56, the FMV becomes the cap, because if it increases if the consideration is more than the FMV, then the Indian company is going to get taxed, and we're perhaps the only jurisdiction that is taxing a capital receipt as a revenue receipt. The problem is that, you may still say, and we're all adults here, we're all lawyers, we all know how valuations are done. So in terms of section 56, it permits two methods of valuation. One is, the DCF methodology, where it says that it has to be a Cat 1 merchant banker that has to issue the certificate. And the other is a net asset value method with some deductions, with some adjustments. Now, the problem is, all fine. You've now started having cases where the tax authorities have said that, okay, you invested in 2015. I want to see the valuation report. What assumptions did you take? And then they're going into questions of, in your valuation, you had projected that revenue is going to go 5x. Actually, you've just achieved 1x. So therefore, valuation itself is incorrect. And so therefore, I have a claim under section 56. Now, all of this, has started coming up in domestic transactions. The moment you have foreign investors also, subject to this regime, that is a Pandora's box that's going to open up, and that is going to be Vodafone number 2. So I think we need to be very, very careful of the kind of legislation that I think the approach has to be mature, and we really need to think through what are the second order and the third order effects of any legislative changes that we want to bring up, merely because we're trying to cover up, one regulatory loophole.
No, I absolutely agree. And that's why structuring of a transaction, closely becomes extremely important. Whether do you really want to issue an instrument which is equity, or would you want to consider a convertible debt instrument where 56 will not probably apply. But at the same time, it's a convertible debt instrument, not an equity. So I think we all have those open points, and therefore a careful consideration is required for structuring a transaction before actually it takes place, right? So I totally agree with that. Coming on to the next question, which is actually on the IPO side, we've seen a lull in the IPO in the last year, right? What's the current market trend around IPO which you are looking at, and do you see IPOs going up, because there have been a couple of RHPs which have been filed in this year. So any thoughts around, the IPO market? How do you see the IPO market coming in?
Well, I think you're absolutely right. As I mentioned, I think companies now are, wait and watch mode. They're all going to wait for, some political stability to play out. And remember, there are lots of state elections coming up. And that can also sort of swing the pendulum one way or the other in market sentiment. Right? But one thing I do want to point out, right? Most of us do talk about it. There's almost a inverse relationship between IPO market and M&A market. And normally when IPO market goes up, typically that's when M&A activity goes down, because obviously then every investor is looking for an exit through the capital markets route. The trend that we're seeing is, and as all the other fellow panelists have called out, I think definitely strategic M&A is playing out in a big, big way. So everybody's now trying to sort of consolidate, grow their businesses, and then maybe look at an exit in a year, 18 months from now. So we're going to see all of that play out quite soon.
Coming on to the election point, that's something which definitely is going to play an important part. Considering that, we are hardly a year away from elections, how do you see the M&A trend and the IPO trend moving, from September onwards, let's see, which is just 6 months before the elections takes place? So any thoughts around that, Varun?
Yeah, so my view, I think, is bit contrary to some views here. I'm very optimistic. And I think reason probably is also that I'm a lawyer plus running my own firm, so I'm an entrepreneur also. And I see the macros, and we see the numbers are not saying it's negative. It's only holding, it's a bit of a hold up because of the Ukraine war situation. But as I said, these issues of corporate governance or tax issues, these are not macro level issues. These are operational issues. at a macro level, when you get the big dollar, there's $3.2 trillion of dry powder with private equity funds. And India is growing at 6.5. There's no way this is not going to trickle down. Election year, I think if anybody heard the PM speech at the US Congress, that would set the tone actually. Categorically, he is mentioned, and this is the first time, which is coming from directly, it was indirect, that Quad is going to be acting and India is going to change supply chains. It's a statement by the PM at the floor of the US Congress, which means it's not only the new economy, it's going to open up the entire manufacturing sector. So, and that is good, a statement of that effect will have a trickle down effect. So I am of the view that even if it's the election year, Apple has entered. Apple is a $3 trillion company itself. They've entered India in the election year. So I see a trickle down happening and this is going to open up very fast.
Just one point. I think, a lot of times when people compare India and China, one thing that comes up is that China has grown because of the government, and in India has grown despite the government. So I think, in the long term, I think, we're all set.
Garima, I think the sentiment, I think the point that I do want to make is that the sentiment is that of careful optimism. I think being sort of carried away with the overall momentum, the macro story is great, which is why we are all here and having a good time doing what we do. But I think the sense of a caution is very critical. Because I think we are also going to see, and remember, all it takes is two bad stories and suddenly investors start looking at other jurisdictions. So we need to be careful. Governance is going to be a big challenge in times to come. Even if you look at the domestic sector, you are now seeing almost the pendulum swing the other way, where the regulators are working overdrive mode to actually plug regulatory arbitrage. Whether you look at the e-commerce sector, you look at the consumer protection rules, they are draconian, if I was to put it mildly. If you look at what fintech sector is having to experience at the moment, RBI is going absolutely hammer and tongs in trying to sort of make sure that there is no arbitrage. So domestic sector, I think regulators are going to be strict and they are continuing to be strict. So the pendulum is swung the other way. I think they're trying to weed out all the smaller players to get more organized players in the system. And when that happens, there's always heartburn. And I think that's the story that's currently playing out.
No, actually,
I'll just add to what Vaibhav said. I think regulators take a very cautious view. That is why they are regulators. So I think if you look at the uniform pattern of most of the regulators at a macro level, more or less, they start off with a strict position, and based on the market sentiment, market practices, they regulate or deregulate or tighten the noose, or probably will liberalize certain provisions, but they have to start on a strong footing. That is what the job of a regulator is. Now, coming back to your question on how the election year will pan out, I think it will literally have no impact. M&A is purely commercially driven exercise. It's an exercise of corporate houses which are driven purely because of commercials. I don't think election year will have an impact, except probably the infrastructure sector, where the government has a lot of interference. And that will also be impacted probably not around September, but when Model Code of Conduct comes into force, which essentially means when Election Commission announces the dates for election. That is when the government cannot announce any new project, will not float any new idea or tender or go into something new, which eventually will result into commercial action and acquisitions. So I think if we leave that part aside, I don't think it's going to materially affect the M&A segment in the Indian market.
Okay, on that note, our time's also up. So I think the theme I'm going to say, which Weber rightly mentioned, is we're all optimistic, but there has to be a caution which needs to be surrounded around this optimism as well. And yeah, we are all optimistic about the M&A traction and tax changes and commercial regulatory changes which are being made. But yes, that point of caution needs to be there.
I am not optimistic. I'm saying this is going to be unprecedented. Never has happened $2 trillion in next 3 years. Never ever.
So
that's my position.
I'll supplement Varun on that. And he's very right that in the long run, it is going to be India's time. And this is something which can also be, this is also reflected in the government documents.
Next 36 months, not long.
No, if you recall, there was a lot of news around India Economic Survey referring to the fact that India is the third largest ecosystem for startups. And if you look at the previous documents issued by the government, it envisages that by 2025, probably, around 2030, the startup ecosystem valuation will reach $1 trillion. That will be unprecedented. So this correlates to the earlier point that we were discussing, that the P and VC investments will come in. So this entire growth will be fueled by P and VC investment. But like Vaibhav said, it's going to be it's a winter right now, but I think it's a short-term winter. Once the cost of capital goes down, which experts envisage will probably go down in 1 or 2 years, then I think we'll again have a fine innings in the Indian startup ecosystem.
Priyanka, if I can just add, I think, look, the overall India growth story is beyond debate. And I think we are all very, very bullish about India is where China was in 1990s, as Abhishek pointed out. We are at a per capita of about $2,600. I think we are going to now move from here to about a $5,000 per capita. So there is going to be a lot of growth. But I think the point to watch out for us as lawyers is that whenever there is growth, there is a lot of disruption. And disruption means also pain stories. I think that was my sort of focal theme here.
And through all of that, there's optimism for insolvency, right?
So on a lighter note, lawyers earn both ways, whether even if it's pain or growth.
Yeah.
So I think it's a good position.
And through all of that, Vaibhav talked about, some disruption in traditionally run businesses as we proceed in the next cycle of growth. I think a central pillar will have to be how maturely regulators and the government acts when situations that are not conducive come up, and how you plug them, and how maturely you think about them and how maturely you address them.
Absolutely. So thanks everyone. Thanks for an interesting session. I hope the audience enjoyed as much as we did. Thank you so much, everyone.
Thank you very much. Could I please request Thank you very much. We live in an ever-changing world, and this brings us to the topic of our next panel discussion, the impact of AI on lawyering. Ladies and gentlemen, please welcome our panelists. Please give it up for Ms. Anisha Patnaik, Managing Partner, Lexstart Partners. I must offer my sincerest apologies. Kindly provide me a couple of minutes. But before we move forward, I'd like to once again request everyone to kindly put their mobile phones on silent or vibrate only mode. Please welcome our panelist, Ms. Anisha Patnaik, Managing Partner, Lexstart Partners. With a round of applause. Perfect. Please give it up for Mr. Apar Gupta, Director, Internet Freedom Foundation. Please welcome Mr. Harsh Butch, Associate Partner, TMT Law Practice. Please give it up for Ms. Manisha Singh, Founder, Partner, Lexorbis. And completing this session, please welcome the session chair, Mr. Tarun Nangia, Associate Editor, NewsX.
Good afternoon, all of you. Happy to be here and happy to be moderating this session on a topic which I myself have read a bit about in the past few years, and very curious to know where this takes our profession. We have very little time, so without much, you've got all the introductions. We'll hit the ground running. I want to request Apar Gupta to start this session with about a 3-minute opening comment on use of AI in law. How will it affect the profession of lawyering?
Over to you, Apar.
So thanks so much. I think a bit of this question is a hypothetical. We are seeing into the future how it will impact practices, and practices are very different for lawyers based on how they practice and what is the nature of their practice as well. But just taking it very, very in terms of a very broad framing, the first is that in terms of how digitization is impacting the larger justice system, which is the courts, is that phase 3 of the e-courts project is ongoing. In fact, I'm on a subcommittee which is going to formulate how judicial data is used in terms of how it's made available to different stakeholders, and yet at the same point in time, data protection is implemented. So you also see that there's at least one judgment to my notice from the Punjab Haryana High Court where ChatGPT has been used. ChatGPT uses large language models. It's one of the many technologies in artificial intelligence. And I think right now we are in the midst of a hype cycle, Gartner's hype cycle. So we are estimating the productivity gains as well as the disruption to the legal industry at this point in time at a much higher extent than what is actually happening. And most lawyers, I think so, will at best be using plugins to respond to emails. And most lawyer emails happen to be also very carefully drafted if they happen to be working good firms, right? So they charge for their emails as well. But coming back to the point, I think over a longer period of time, it is a paradigm shift. It is a transformative technology. It will lead to certain kind of changes, which will be driven by unit economics, either in firms, because AI does not ask for time off. AI does not ask for increments. AI does not change jobs by itself. So there will be certain changes. I also think the third aspect to that is that AI will be implemented in certain state processes in the justice system by itself, particularly towards policing or petty cases by itself. That will represent risks because AI consists of firstly training data and secondly then the larger algorithm, which is then deploying it. Training data itself has huge amounts of bias, but a lot of people will say that if you outsource something to a machine, its decision is objective, it is not biased. But at the same point in time in criminal justice, housing, entitlements, a lot of the legal interactions which ordinary people have, which larger entities, artificial association of persons don't have, it will have an impact. So I would say it's a very, very broad topic, and it'll have a tremendous amount of impact. And happy to have this conversation, take it forward.
So thank you, Par, for the opening comment. I'll go to Manisha Singh. Manisha, what I read The Economist very recently about Michael Schwartz, a lawyer in New York, using ChatGPT to file his petition. It helped him draft his petition. This is how it helped lawyers be more productive. Do you see anything more than that happening in this space? Of course, we've read about AI courts, but I think that was too far-fetched when we read it. I don't think it's a reality even today. But could you, in your own experience, tell what is lying ahead for all of us in this field?
Yeah, hi. Hi, good afternoon, everybody. Rather, good evening. Is it working? Thank you, everybody. This is very pertinent question, definitely in the current times. We see a very fine synergy about the overall development on the data. Data is the new oil, and definitely when there's a data, we have a technology to read it, and that leads us to the artificial intelligence. The US case which you are referring to is definitely, I would say it's a clerical error which happened. Even we do not file anything, even if it's drafted by the interns or the juniors, we read and go through it. But I must say that it reduces the time frame substantially of doing so. We have to keep using the AI. As far as the adjudication system is concerned, going forward, what's going to happen is that people will measure the time. Even now, like traffic policing, we can argue that. I know some of the people who have been challaned and they have gone to the court 2-3 times and then they have argued that they have not violated. Whereas what they can do, why to waste them? You measure the time taken to argue that and the time, money which you are paying for it. So those things are already automated, particularly in India. Now, I'll take something extra from the questions which you have raised. Like, I specialize in intellectual property. I'm an IP attorney, and we have been dealing with this IP innovations by the AI instruments. So it is completely, till now it has not been recognized. Okay, you have an invention, AI is doing an invention, but we have to be mindful that how the AI is doing the invention. It is doing the invention based on our own prior inventions, which we call in our practice as an improvement of the existing patent. So it's based on analysis of that. So it cannot be, we also do the same thing. But when we come at the machines doing that, that means it's an analytics, it's an use of algorithm. So that's why we are not recognizing it, because then it will be very, very massive and there will be no boundaries for that. So we still, as the topic says, that the influence of AI on lawyering, we are still going to have place for doing a lot of things.
Point well taken. I'll go to Anisha. Anisha, your opening comment.
Sorry, I just wanted to add to something that Manisha said, right? There is AI and then there is generative AI, right? The Schwartz case, what it taught us is that AI should be used as a tool, right? It should be used as a tool for us to optimize our resources. But at the same time, it cannot completely take away the human element of having to verify everything. And, actually, I started LexStart with the idea of actually using AI in contract generation 8 years back. Back then, there was no ChatGPT, so systems were not that sophisticated. But even there, what we did is we could at least bring up the optimization in creating the base drafts. But at no point of time could we take away the requirement of an experienced lawyer having to look at the specific use case and then reviewing the contract. So that element will always require human intervention.
Okay. Point well taken, that there'll be elements that will require human intervention. I want to share an anecdote. In India, any automation which came right from the time when banking was computerized, I remember there was protests by unions saying, what will this lead to? Anything has a employability or a job angle to it. And when we speak of lawyers, I think the lawyers that work in district courts across the country also look at these things. It's not just lawyers who sit in halls like these. And that is why I remember a conversation with a judge that I hold in high regard 8 years ago about mediation. And he simply told me, I was very excited to speak about mediation. Before the panel, we were having coffee. And I said, sir, that if you encourage mediation, the pendency will go down greatly. So he told me, young man, let me tell you, if I send cases for mediation, what will I do? So I was speechless so just before the panel discussion was to start and the gentleman in question, the judge, was to speak on mediation, and I had an idea of how this is going to go. But any which ways, I'll go to Harsh Butch, associate.
We have a lot of mediations happening.
Yes. Harsh, your opening comment on this issue.
Right. Thank you. So a lot of these questions about AI is about how will it affect practice. Much to my agreement to the panel, I have a slightly different view where I say that lawyers today practice in two kinds of roles. One is the traditional role of being a lawyer practicing law. Another is that of a businessman, of managing their own law firms. As an entrepreneurs, independent lawyers, partners of law firms, you all will agree that a lot of administration work also does fall at our desks. Looking into the future where AI is able to assist partners of law firms into these activities is something that I am really looking forward to. Not just having petitions drafted, but for example, all over the country, pan-India, most courts are moving towards e-filing. If at some point of time there is an algorithm that recognizes what kind of petition, in what format is supposed to be filed, in which court. A lot of human time spent in pagination, in formatting can be, saved. And obviously, I don't need to tell all the lawyers here, money saved is, time saved is money earned. Bringing that aspect, a lot of lawyer fees are usually outstanding. We are, reaching out to clients through emails, through phone calls, through messages. If there is an assistance in that nature where, a lawyer just needs to mark the clients that need to be reminded, and there's an automated generated email considering what was the past invoice, what is the invoice outstanding, and when does it need to be paid, how long has it been remaining outstanding. This itself would help lawyering greatly. On the other hand, I am not really a proposer of AI-based law. I feel that there, in dispensing justice, apart from a very neutral judge, one of the most important things that a judge needs to understand is emotional intellect. And my example is the Article 300A of the Constitution of India. You come to a court and say that, look, I have been living on this plot of land for eons, my family, everyone has been living here, but unfortunately, apart from legitimate paper titles, I'm not able to establish. I'm able to establish the fact that I've been tilling this land. I'm able to establish from a lot of witnesses that I've been living here, my family's been living here. An AI-based justice dispensation system would have completely rejected this plea, because there is no concept of understanding that, yes, this man, this person has been living here, the family has been tilling that land. That would only come through a human, emotional, intellectual mind. So until and unless there is ChatGPT or any other kind of AI algorithm that can show me this emotional palatability, I am not going to be a real proposer of AI doing any kind of law.
Point well taken. I'll go to Apar. Apar, there are many India-specific decisions we take on many issues. Digital courts was one. Until COVID happened, there was very little adoption. Suddenly, you saw people who were very wary of using digital technologies adopted to it. It was, I think, a necessity at that point. As far as AI is concerned, this discussion in the past 5 years, greatly we saw in China, also in Europe and America greatly. India, this wasn't much. This was limited to lawyers in cities like Delhi and Bombay reading international magazines talking about it. What do you see is going to happen in the next 5 years, given that we have a Chief Justice of India who's greatly promoting the use of technology in courts? And when it comes from the top, changes do happen. In your view, what lies in the future for us?
I think, firstly, I think it'll be the firms, law firms, which have already allocated budgets for knowledge management systems. So there'll be some person there and they'll say that, hey, let's look at these 3 tools, these 2 tools, they'll try that out. So I think that, and specifically younger litigation lawyers will try to optimize how they utilize it. I think that will be the primary impact, and the kind of things which they will do is also in terms of transcription services, things like that. Rather than much more application based. Law students will plagiarize projects. That's to be expected. I think that will be the primary impact. And I also think that to a large extent, there'll be puffery. People will say that we are using AI when they're not using AI. That's also to be expected. We've already seen that in some state deployments like Arogya Setu, or even in the Delhi Northeast riot cases, Delhi police has claimed we used artificial intelligence in courts, etc. So all of that will happen. I think what is needed is, and I don't think so given its institutional culture it will happen, is that practice guidance needs to be provided by the Bar Council of India. Through a working group or something, on how lawyers can use AI and do it without breaching their ethics obligations towards their clients. And I think that is what is necessary, and that is where the conversation needs to go.
Point well taken. Manisha, your inputs on this issue.
So as far as the law firms and the legal practice is concerned, there is many law firms who are already using automation tools. Automation tools is that building their internal algorithms to check out from their own databases. Like I'm an IP practitioner, so we use, like the government is also using the portals for online filing. So there is substantial automation over there. Now coming to AI, AI definitely we are not using it as Harsh said that there will be puffery lot. Many of the clients will ask, have you written this or is written by the AI? That's a very dangerous thing to commit. So definitely we do not, and I personally do not advocate to use it on a mass scale because it's still getting reformed, it's still getting upgraded, and but we cannot say that we are going to be very far away from it. It's a very, very important tool and we must use it to further improve it. So there's a long way ahead, but still it can be moved very fast.
Okay, I'll go to Anisha here. Anisha, two things. Let's take a 30,000 feet view. The generation which was born in the 1980s, probably they all have turned partners in law firms now. They're closer to 40. Then a generation came, which is the 90s and the early 2000s. There was now a generation that will enter lawyering that was born after the first iPhone was released in 2007. So we are talking by 2027, the boy which was born, which will take up law, will be the boy who had used iPhone since childhood. His adoption to technology will make us feel like dinosaurs. When these boys enter and come out of law schools, they will establish law firms. Obviously, they'll join law firms. Do you think the great leap in AI will come then in the next 5-7 years? That is because we are talking of a generation which will be much more clued in or grown up in a digital ecosystem than this generation, which has seen, I think all of us would have seen landlines in our time and grown to this age. These guys haven't seen all that. And secondly, the foreign law firms using AI, and now that foreign law firms will establish offices, at least a few, their operating mechanisms will have an impact on the local big law firms because, of course, best practices are adopted. Your views on both of these?
So the current generation has already started using ChatGPT to start drafting clauses, right? Because they don't want to make an effort trying to draft better clauses. So you're already seeing it, right? Where at least the dinosaur generation that you just mentioned would go through umpteen number of drafts to find the right clause, try and fine tune it better. Today, like you ask a first-year associate or even some of our trainees, like, hey, why don't you take a stab at it? ChatGPT to the rescue, right? And so it's already happening. But and that is where one has to kind of build more sophistication, because when you say AI and what Manisha said, right, within the four walls of a firm, right, automation and using AI, great, right? And that'll help in making the organization far more efficient. Another use case is due diligence, right? It'll make the organization more efficient. But the minute you take it outside those four walls, so when you start using ChatGPT, there are concerns around privacy, there are concerns around confidentiality, all of that. And there's also concerns on the authenticity, like we saw in the Shorts case, like ChatGPT completely misled him. Right? So I do agree that sophistication will come in. And yes, by the time the latest generation becomes partner, AI would be at a very, very, very different place. And I'm sure, they will help law firms become more efficient, like Harsh pointed out. On the second one, sorry, what was the second question?
Second was about when foreign law firms come to India and that.
Yes, I think absolutely, because foreign law firms have actually been the early adapters, right? I mean, 4 or 5 years back, some of these law firms had contract generators on their website already. So foreign law firms are the early adopters. Even due diligence, a lot of them had already created tools. So it is only a matter of time that we catch up and also create equally sophisticated tools. And we'll also be, of course, the influence of foreign law firms coming in, and we'll also be learning from them. So yes, it's only a matter of time.
It's only a matter of time. Harsh, I'll take all these questions to you for your inputs.
before I address your questions, the comparison of generation just brought an anecdote to me that life has evolved from taking a bite from the apple to putting a bite into the apple. I mean, look at the way the world has just changed. In terms of what will 5 years or the future lawyers have, they are definitely going to be equipped with AI for legal research. One thing, lawyers from our generation or seniors to me have toiled their books, libraries, different libraries, judges' libraries, different senior counsel chambers. You know, you try and get a conversation started just so that you can enter the senior counsel's chamber because he has a particular commentary which not other seniors keep for his expertise, and trying to, you know, spend that 10 minutes to just get the correct judgment. That is all going to become very easy. That's going to be handheld. Answering a question that generally comes as much of a scather when you're arguing, when the judge says, do you have any authority to support this? And the lawyer is going to be like, just 1 second. Yes, I do. You know, that is going to really aid lawyers. So AI is going to take, assist practice exponentially. I hope it makes lawyers more efficient in terms of time, in terms of delivery. But if you are going to look at, you know, a completely AI run firm, that's not going to happen. That's not going to happen. I don't think we're going to let that happen either. But concentrating on the India specific first, we have district courts, we have magistrate courts, we have lawyers who come from not such established backgrounds, but with intellect. Trying to get them to be equipped at a time where still, as of today, internet is not available to all villages is going to be a difficult task. And we can't discriminate that just because you are a lawyer who does not have access to AI, you know, you shouldn't be getting a brief. So I think it is going to be accepted well, but the traditional form of practice is going to continue a long way.
Point well taken. I'll go to Apar. Cost is not a factor according to an implementation of AI-based modules. We saw ChatGPT is virtually free to use. Do you think cost is a factor or no?
Cost is certainly a factor. If it depends on the kind of thing you're doing. If you're training your own model, okay, it takes money. Firstly, you need to have the data, you need to train it, you need to hire people to adjust it in terms of the outputs which are coming, play around with it. The other thing which you need is large amounts of computing power, which is called GPU. And because all of it usually will be done by AWS server, and the server cost will be very, very high. So to make your own model and then to run it, and if depends on the number of users which are there, endpoint users and the cloud computing cost which is there are costs which stack up. So there's a very good report by the AI Now Institute that the tech monopolies which we have right now will perpetuate because the costs to building the model by itself, specialized models. Number one, for instance, if you think about healthcare in terms of early detection, etc., it's not only intellectual property or database rights, etc., which will protect it. It will also be the computing costs by itself. The availability of computing costs, the availability of the GPU and your ability to run them, because there's market scarcity right now. And the second is your ability to pay them. Primarily for law firms, one thing which is not touched upon is, I think so, there's going to be regulatory activity in several sectors. I think it may be driven through some individual regulators like SEBI, etc., towards looking at large patterns, towards recurring problems they have been facing, like insider trading, etc. They're going to implement these systems, and it's also going to lead to a lot of policy-based billing, which will happen over a period of time, because regulation will eventually at some point be prompted. And I think if there's true displacement in the labor market for lawyers by itself, Tarun, then lawyers will petition the Bar Council and say that only natural persons are lawyers, which are entitled to give legal advice, and thereby all these tools need to be prevented from it. I'm not throwing out ideas. I'm just saying profession is rent-seeking. It is a guild, and doctors will do the same thing, poor journalists. Okay, but that's not directed to you, but this is the eventual outcome. This is what I see
Point
happening.
well taken. Since we have only 5 minutes and we've had a good Q&A, but I think we should let the audience in to discuss with us. Throwing open to all of you. Vaibhav, I can see.
One experience that we are sort of coming across, and question to all the panelists that we touched upon in Asia, is that some of the international clients are actually reaching out when they're looking at engagement terms, even with international firms. They're asking for an explicit prohibition that no AI tool shall be used for the purposes of giving any legal advice, because these AI tools are ultimately at the moment publicly sourced. So there's a massive issue of breach of client confidentiality and attorney-client privilege as well. And so until and unless you reach to a point which Apar was alluding to, that law firms come up with their own tools, which will be an expensive affair, where they can develop their own tools, I think corporates in India will also now start forcing lawyers and getting restrictions that you should not be using AI, because there is a very real risk of breach of client confidentiality as well as compromising attorney-client privilege. I don't know what other panelists think about it.
Vaibhav, the Samsung case, you must have heard about it, that there was some coding to be done and it was a new invention and the inventor put it on the public chat GPT and it was a messer.
Correct. Anybody else on this?
Yes. I think that soon a time is going to come where, just as how our websites are right now showing a disclaimer from the Bar Council saying that, we are not soliciting work, there is soon going to be a disclaimer saying that we do not adopt AI norms to give out legal advice. I think that's going to be a future that is going to come up soon. But apart from that, I'm just trying to address this one question that goes about the costs. We do realize that if you are looking at training our own in-house modules for each firm, you will be appointing or you will be bringing on board lawyers for training purposes itself, whilst also having lawyers to give out the legal advice. Because you will have to have specially technology trained lawyers with intricate understanding of AI to train the modules. But at the same time, you will also want to have on your sleeve lawyers with expertise in that legal field who are going to explain what is required from these modules. So the costs are going to naturally, rise. It's not really just because today ChatGPT is free, your internal module is going to be, judicial in your expenditure. Today, even an HR module for attendance itself for your own firm is raising lakhs of rupees as invoice.
But that's where we come to what Apar said, that you can't use a public platform because Vaibhav says client will not allow it because your breach of data. But preparing your own module is really expensive. Right. So maybe the top 2 firms, the top 5 firms can afford it. There is a cost, I think, prohibitive cost. Are there any answers for this, Apar, in your view?
I think just continuing with it, I think what will be most useful is that a lot of law firms also invest in training people, especially abroad. So how to use which tool and which tools are permissible, which tools are not, will be a good starting point, because quite frankly, law schools don't teach you a lot of this stuff. For instance, how to even use a spreadsheet and things like that, which will be a little much more useful and avoid a lot of this heartburn. So that's the approach which can be taken through PQE kind of modules, which are done even for people who have been at firms for some period of time.
See, I have about 1.5 minutes. Anybody from the audience who wants to speak, raise a question, make a point. Can you give?
So hi, everyone. This is Varun Bajaj. I run my own law firm, RSD Bajaj Global. Completely new economy driven. And actually, I just wanted to make a comment that we are actually leveraging AI tools as on date to replace the human resource. It's happening as on date. Now, if you go, a lot of your video conferencing, the transcription has started with some tool known as TL-Watt TV. It's replacing Zoom. Now, what it does is, if you do a Zoom call, it automatically transcripts it and gives you the summary. So at multiple fronts, whether it's communication, there's a huge SaaS play coming, which is software as a service. And what we are doing, to the point which was made, so that there's no breach of confidentiality. In fact, we have amended our engagement letter to include permission of any third-party softwares for delivery to the clients, and the clients have agreed to it. So I just wanted to make it a point that it is actually happening as on date, because emerging firms do not want to take the cost on, and they want to do smarter ways to build new firms rather the traditional way. So that movement is happening. Any comments on that? Happy to.
Just a small thing on that. When you transcript on the basis of audio recording, which is done on Zoom or anywhere, but its use is in terms of, let's say, an investigation you're doing, right, into a company which has appointed you to find wrongdoing. You need to also notice where are the pauses. What is the intonation and change in pitch by itself? Those are active ingredients of witness and testimony examination. It's not only transcription. And what I'm trying to highlight is that sometimes there'll be a loss of function in the transcription. For, let's say, a YouTube video, the transcription which is working may not work in a professional engagement between a client and an attorney or a lawyer. So there'll be a cost to the efficiency, and it may not necessarily result in a better product in terms of advice to the client by itself. It may not actually aid that function. And that's important to halt and consider always.
So I think the time is up. We can continue this over coffee after this, because, but I would like to thank Apar, Anisha, Harsh, and Manisha for joining. Please give a huge round of applause.
Thank you.
Thank you very much. Could I please request you all to kindly come up front for a group picture? Thank you. Quickly on to the next one. The topic at hand for the next panel discussion is role of General Counsel in business operations. Please welcome our panelist, Mr. Amar Kumar Sundaram, General Counsel, Senior VP Legal, NEC Corporation. Let's welcome the gentleman with a round of applause. Please give it up for Ms. Garima Budhiraja, former Director Legal, MobiKwik. Let's welcome Ms. Pooja Bedi, Head of Legal and Compliance, India Subcontinent, Philips. Please welcome Ms. Pooja Sehgal Mehtani, General Counsel and Company Secretary, Sun Life. And completing this session, please welcome the session chair, Mr. Ruhail Amin, Senior Editor, BW Businessworld.
Thank you, Sabjit. My boss was to moderate this, but he's caught up, so I am here to kind of chair this discussion. We had a ice-breaking session outside, and we kind of agreed on some questions, and I'm going to pose those to all of you. You know, the topic is very interesting, role of General Counsel in business operations. And as we all know, it's a very complex role. They are the leaders at the center of most critical business activities. There's no doubt about them. So let me start with my first question with the second man on the panel. Mr. Sundaram, we spoke about, that when you look at legal departments in-house, they're always seen as a cost, right? There's a perception that it is a cost. While as if you look at the larger picture, there's definitely a value add, but that narrative, that conversation is never highlighted. What is the reason that is still seen as a cost primarily? How can we alter this perception? Is there anything happening on that front?
So thank you so much, Rohil. Let me inform the audience that Rohil is not a lawyer, and when we were doing a small chat outside, on the rep and warranty, Vaibhav, you mentioned about rep and warranties. He has taken a warranty conditions that we will protect him. So we are bound to protect him. So coming back to the question, see Rohil, this whole concept of legal department being a cost is an old concept now. This we used to debate some 10 years back, but now it is no more a debatable point. Organizations are not debating whether legal is a cost. We as lawyers, as in-house lawyers, we bring a lot of value to the organization, be it in terms of the non-litigation piece, be it in terms of the litigation piece. And the more important role that we as lawyers play is that we have an eye on the business operations, and therefore we know where the business is going wrong and on what decision they should take before actually deciding on a particular set of business. And therefore we also ensure a preventive litigations. And therefore, if you talk about the preventive litigation piece, we are saving a lot of costs to the organizations. Having said that, like any other business unit, we also have a budget. But we manage our budget very, very judiciously. And to answer your question, we are no more a cost. We are a value addition to the entire business.
That's great. I think the perception that has changed. But is that the same case with startups, Ms. Buddhiraja? Is it seen in the same way as Mr. Sundaram pointed out?
Thanks so much, Rohil.
Yeah.
Thank you so much. Happy to be part of this esteemed panel. Again, I will totally endorse, Mr. Sundaram's view that the role has evolved and it has evolved for good. We as general counsel, even we and as our teams, we have a seat on the table now. When the CXOs talk, they do call the general counsel in that meeting, which is maybe a product strategy or a business strategy, which they are discussing. Because, I have been part of a regulated business for most of my career. I've spent in fintech and startups. 5 years back, 6 years back, there is a pilot. I mean, I can give some anecdotes in the sense that, a product manager has thought of something, they're taking some tool, or they're making some kind of product. They've started the project, the pilot has happened. Suddenly the invoice is pending for the vendor or for, or for the service provider. And the product manager or the business person comes running to us and says, we need to close the agreement because the invoice is pending. Now it's no longer the case. We are involved in the beginning, like when the product is being strategized. Basically, the product document is called PRD. And in fact, in my company, and I've heard of many fintechs or regulated businesses, each legal SPOC is assigned with each product manager, to understand that PRD, whether the product flows, the money flow, the knowledge flow, the information flow is compliant or not. So I feel that role has evolved and evolved for good. We are no more like a cost function. It's more of enablement of the business. No one, basically actually refers to us as a support function anymore. So that has been my experience in the last 8 to 10 years.
No, that's very heartening to hear that, even in the startup world, it kind of resonates in a similar way. Ms. Bedi, your take on this, the same question.
Hello. Yeah. So I think I will take a step back. I would say that we ourselves as lawyers need to first believe that we are not the cost center.
That's
and
an
I
important
think the
point.
starting point is that, and I'll give you a few examples of how, we've sort of, and I, in my own experience, working for in-house for about 23 years now, we have evolved. We actually, as lawyers, go after business opportunities. And it could be as simple as account receivable. And we pin ourselves on a target and we say, we'll find the legal budget out of the recoveries we are going to make. And we are also going to increase the quality of service to the business through our own endeavors. So at some point in time, me and my team, we were chasing an opportunity of almost 40 to 50 crores, which is sometimes a single line of business may not be able to manage. So I think it starts with our own mindset change. It starts with our own attitude. And if we consider ourselves to be cost centers, we would be. But if we choose to look at ourselves as business lawyers and people who are, equally invested in the commercial success of the organization, we'll come up with our own ideas.
It's a very, very important point, that self-perception, I think because we were having this perception for a very long time, it has got ingrained, I think that doubt may be still there. Do you agree, Ms. Mehtani, on what?
Absolutely agree with the views all the three esteemed panelists have shared. And I would like to sum it up saying that, it boils down to, it's not about cost anymore. It has evolved. It is about the value add. The very, howsoever cliched it might sound, we are the general counsels, and it, revolves much more rather than just being restricted to a strict legal view. It goes much beyond that. The legal department in itself and the general counsel is embedded in the business now, and it's totally not about cost. It's the value add that the business is seeing coming from them, and that's why you've earned the seat at the table. And the discussions have gone way beyond. And in fact, in the role that I am leading, I also have, maybe because of the business that we are in, I also have a revenue vertical that I'm leading, where some of the lawyers in my team who are experts in certain fields are providing services to, the wider organization. So opportunities like that are also there, where, you can also be seen as a revenue vertical.
Wonderful.
And Rohil, just to share my own experience, I mean, for last 7 to 8 years, I have been in part of the leadership team in a couple of organizations that I have served. And I can tell you that I have been involved in major decisions of the organizations, be it on the business side, based on the policy formulation side. And I have been involved in a lot of critical decisions that we all take collectively, before jumping. And therefore, the evaluation of the risk, the evaluation of the legal possibilities of doing that particular set of business that is where the lawyers come in, and they do a real good job for the organization in terms of warning them that these are the red flags. And if we want to do it, this is how we should do it, but these are the possible consequences. So therefore, legal is no more a cost.
Right. And Amar, to just add what he said, it goes, of course, we have to, caution as what could be red flags. But since if you're involved from the very beginning, it does not even come to that point, because you are a part of that decision.
Right.
So the way you kind of, lead that whole discussion also matters a lot.
Right. So, another role which a GC plays, is also to reach out to the corporate management, both, of course, the top management, even the junior management, the mid-level, and to make them aware of all the legal advice that is there, One, how has that participation from the management changed when it comes to legal matters? Is it still confined to the legal team only, that they come to you at the last time? Is there a deliberate attempt, proactiveness that, okay, let us do it beforehand, then wait for some crisis to come? How is the culture within organizations shaping up? I mean, what is it like in today's times?
So two things. One is that definitely as the general counsels, we are privy to a lot of confidential information and confidential strategy, which cannot be shared across the board. And therefore only the top people needs to be involved into that. And that kind of a discussion happens in a very, very confidential manner, because those are strategic decisions and confidential discussions. But barring those confidential discussions, there is a flow of communication which now goes. So I'll give you my own example. In my department, we analyze a particular issue well in advance, and then we debate within our team, we debate with the key people in the business, and then we send that communication to the entire workforce. So this arbitration discussion which was happening, this NN global judgment which has come, now this has a ramification in the organizations, the way the appointment letters are being issued, which is not stamped and it has an arbitration clause, the way purchase orders are issued by the organization, which is not stamped. Now these have ramification now in view of this judgment. Now we will analyze this judgment, we'll prepare a note, we'll talk to the management, and then at an appropriate time, we will enter into a discussion, collaborate with the business and communicate. The same thing goes when it comes to compliances, rules, regulations, new notification coming up. So the flow of communication is now much, much stronger and much, much larger, where entire workforce is engaged in that particular issue.
Wonderful. Thanks to the new technology also, I'm sure, right? Ms. Budhiraja, in the startup space, it's still an evolving space on many fronts, when it comes to the legal issues, for example, there are still new developments, and the litigation is still kind of coming up to match that, change. How is it within startup culture to make them aware? Because startup culture is also an informal culture. We kind of pride ourselves on an informal culture, while as an corporate has a very structured culture. Is it challenging within startup culture to make them aware, reach out to them, how they are doing in their organization, for example, what he spoke about?
So I've never worked in a organized, as you said, setup. I can only talk about, the comparison will be difficult for me to draw because I've never worked, I've only worked in startups, and that too regulated startups. So thankfully, RBI comes up with its whip, and no founder, no promoter, no business leader can do anything about it. And this has been actually, been reinforced of late a lot in the last couple of years. I was hearing the last discussion panelists as well, that the regulator basically does give signals. There are discussion papers which come. There are industry bodies which discuss those papers. It is not suddenly that the regulator is coming up with some, law which is like so harsh. So if basically you make your founders, your business leaders aware of those discussions, starting from the discussion paper, it is the duty of the legal team, especially the general counsel. I think the work becomes extremely easy. Of course, we have to manage on a daily basis, on a business as usual basis. There will be constantly changing goalposts, but regulation is black and white. And you have to make the business leaders aware that this is coming, so that suddenly you open the Pandora's box, there are business disruptions, then that is not taken very nicely. So we as general counsels, we as legal leads in the organization have to be aware. We have to keep our eyes and ears open as to where the industry is going, apart from, of course, the black letter of regulation, as you say. So that is something which, which we have to develop. And of course, then it becomes, of course, not totally seamless, but it does help. Because even, if you've told your founder, okay, this is going to come, maybe that time he says it's a discussion paper, but he has heard you out. So, you've bounced it past him. So when it comes eventually after a year, so if you see, I work very closely with the regulator. I was leading policy also for my company. So there is a gap of at least 1 year sometimes between the discussion paper and between the actual law when it comes. So, to have that constant dialogue with your product team, with your business leads as to what is coming, I think that really helps. Of course, you have to deal with the constantly changing goalposts, but because I've been in a regulated industry most of the time, it has to be within the regulatory guardrails. Whatever experimentation you want to do, there are grays, but there are blacks and whites also. So
Right.
that's
Not an easy space to navigate. Right.
Thank you.
Ms. Bedi, give me the Philips story when it comes to proactive reach out on legal matters. How does it kind of happen in your organization?
So Philips or not, one of my mentors early in my, starting off my in-house journey, actually told me, if you're not on the speed dial of the CEO, you don't exist. And I think I take that as the benchmark of, being the conciliary, being the confidant of the person, who's running the business, commercial business in an organization, to be that right hand or left hand, whatever you call it, to be that person where there is a question in his mind and he calls you first. And I think that's where we need to reach. I think I will also pick on, what Mr. Sundaram was alluding to. It's no longer a role of an absolute lawyering anymore, right? You have to have a skin in the game with the business people. You need to wear the strategic cap, but also be, and I would say this with a lot of emphasis, be the conscience keeper of the organization. Everybody wants to do the business, but you make sure that the business is being done the right way. So I think our roles have to elevate, and no one else is going to do that for us. We have to do it ourselves. So I believe that communication from that perspective is how accessible you are to all your business leaders, how you're able to find, not just fix the problem, but don't let the problem happen kind of an approach. And then you need support of a lot of external players, a lot of external law firms, people who are sitting out there. We reach out to them to sort of be the intermediaries between, how do we marry a business problem with a legal problem, right? And they bring in some expertise and we kind of tell them what the business is. While if you have to talk to me about the gaps that I have when I go out, looking for a law firm, I can speak at length on that as well.
I have a question on that.
Yes, but I think it's important to recognize that we no longer this, you're just not a lawyer anymore. You're just more than a lawyer when you're in-house.
Wonderful. Ms. Mehtani, what are the bigger challenges, in-house in a corporate, when it comes to engaging with different stakeholders, kind of reaching out to them proactively? Are there any kind of gaps that need to be addressed?
No, I don't think so. There are gaps. I mean, it boils down to a lot of collaboration. Businesses are transforming, and the way progressive businesses are, and you being, the legal department of a progressive business, it is all about collaboration. And if you are a business enabler, if you are solution oriented, I don't see any challenges, because I'll just give you an example. When, say, a business review is happening in different, you're participating along with different functions or departments. And this is a personal view that I have, is that there's no one presentation by a department where you see that somewhere or the other, the legal team hasn't touched upon that. That's where the role of the legal department comes out distinctly. There are various committees or groups in the organization where the legal team members are participating, and if there are, then it makes it evident that their solution oriented mindset would have gotten them there. The other business functions want them there, and I clearly see it happening. So there aren't any challenges. Of course, you have to, if there are, you have to solve for them. It's upon you to solve for them.
Right. Mr. Sundaram, one of key functions, of course, of a GC is relationship with stakeholders within and outside, outside, say, with the law firms outside. And then we spoke about, even when you kind of recruit a law firm and to kind of help you, what factors do you look at? First of all, let me go into it. And how do you manage this inside-outside relationship? What are the best ways to manage and develop those key relationships into an open kind of where you get the feedback, you can open channel, sort of equation?
Yeah, so over a period of time, this relationship between in-house lawyers and external law firm have evolved and changed also. I remember a couple of days back, there was a discussion I was doing with a few partners of a law firm, and it was an intense discussion about the entry of the foreign law firms in India and how is it going to impact the existing law firms, the legal business of the Indian law firms. There were a lot of apprehensions coming up. And I told them that, guys, you are missing one important point. You are just focusing on the foreign law firms, likelihood of them coming here, setting up their offices, and the impact that they will have, the competition gets impacted and the business they may lose. Why aren't you seeing the whole growth of the in-house team, which is happening in the corporate sector, as one of your competitors? The situation has changed in last 10 years. If you see the corporate sectors, we have a team of competent lawyers within the organizations. There are a lot of things that we are doing now. 10 years back, it was being done by the external law firms. Therefore, we are one of your biggest competitors today. We are equally knowledgeable. We are equally competent. We understand the business more than you because we are very close to the business. Therefore, why don't you see us as one of your biggest competitors? Now, having said that, the relationship is important. The relationship matters because as law firms, the kind of wider, diversified knowledge and experience that you guys have, we do not have that because you deal with multiple set of clients. The kind of problems that you deal with every day, probably we don't deal with that kind of a problems. So our depth is not that strong. Relationship is changing. It's deeper, but it is changing. It is evolving. And that's what newer firms, old firms are now understanding. It is not that they don't understand. They are understanding it, but that's a major, major change that has happened. We collaborate a lot with the law firms in terms of intense discussions on some of the evolving laws, some of the new judgments that come up, some of the notification that comes up, and how is it going to impact the business. So we collaborate. We work as one team. There is no doubt about that. We work as one team.
Thus you invited them to look at you as competitors, but I'll take their point, of course, after this question. I would love to invite some, counterpoints from their side. Yes, if I can get your point, Ms. Budiraja, on.
For me, I've always worked in very lean teams, 4-5 member teams. So the role of the external counsel and regulated businesses, the role of the external counsel becomes very important. Earlier, of course, it was only crisis management, but now again, it starts somewhere from the beginning, where we kind of, in our conscience, don't want that crisis to really happen. For instance, I have applied for a license of a payment aggregator, on behalf of my company. I want to know what the RBI is thinking, being just a nodal officer or, having the nodal officer in my team and he talking to a particular person in the RBI, that doesn't help. We want to understand what the regulator is thinking if they have some doubts. Sometimes it doesn't come, they're not very, very forthcoming about it. You have to kind of read between the words. Law firms do help us in that a lot. Of course, I was associated with a company which tried to hit the capital markets. We tried to kind of go for an IPO. The kind of collaboration you need with the external law firms when you are going for an IPO, it's amazing. At a point, with the partner I was talking to, we were like, we don't talk to our spouses that much or our kids that much. At night, 2 o'clock, in the morning, 6 o'clock, it's like a mammoth activity that you're engaged in. And, the whole company and even the external counsels, they have just one vision. There is just one target that we are moving towards. So I think, of course, that evolution has come, and that has come for the good, just from being a crisis manager. Even an external law firm has become, an external law firm partner has become like a business enabler for us, I would say.
Wonderful. Ms. Bedi, your point on, how do we build this equation, how do you manage it well, your, relationship with outside counsel? Does it get complex at times? How do you handle that part?
No, I have a saying, and I use it quite often with my team, is that the external counsel's output is as good as internal counsel's briefing. And I always believe that, the bridge that we need to create, because we are seeking counsel on a legal advice and a point of law, but marrying it with the business is a sole endeavor that can only happen when we collaborate well. And I think I have been very fortunate to work with some of the most fantastic law firm partners in my career throughout, that have not just helped me preserve the value for the organization, but create value as well. So, and I always have those statistics when we have to benchmark ourselves against any other legal department externally. We always say, this is the value preserved, this is the value created, right? And we really, I'm very cynical about it as well. And I don't think that can be achieved if I don't have these partners in crime, where I can just pick up the phone and, ask a question, and then they're up and about. And where I think I need more, and where I struggle is when there is a very, very fixated mindset on looking at a problem only from a legal standpoint, right? No business wants to do anything illegal. I don't think multinational organizations want to flout the law at all. But then they also need to find practical solutions to their problems. And which is where I think there's tweak in the mindset required. And Mr. Sundaram alluded to it, that you should see us as our competitors. And I do believe that we are slowly picking on the edge, and you guys are a little bit slow there. So I think you need to buck up, because the marrying of the business with the law and how to get that commercial success in is where your values will also count tomorrow. And the more you just side on the law and not focus on the business, the more challenging it would be. So I think if there are lawyers who really want to make it happen and be proactive, and I have people, I work in a very regulated industry. Medical devices is an extremely regulated industry. I've always been in regulated industries. Before that, I was with alcohol. So
Another regulated, highly regulated.
Yeah, but both recession proof though. So, but the thing is that I have always had people who saying, this is coming in 3 months, Pooja, watch out for it. So I love that partnership, and I think we need more of that.
Wonderful. Ms. Mehtani, 3 of your panelists, saying that, of course, there's a lot of value add, and plus the in-house teams are emerging in a big way and posing competition. Your take on this complex relationship inside stakeholders and outside, is it easy to manage? How do you navigate that?
Inside, I've already spoken about. External law firms, I think it's a it's a complementary relationship. So, and definitely it has evolved, as has a general counsel's role evolved. Similarly, this relationship has evolved and will keep on evolving. I mean, I agree with what Pooja also said, that, where the general counsel's role is more attuned to, marrying the legal and the commercial view and then helping the business. I think that's where the general counsel plays the role of bridging that gap. But, it depends on the relationship that you have with the external counsel, how you build on it, and how you keep them posted and they help you in certain transactions. That's very vital. So it in a way all revolves around how do you collaborate and how do you manage the relationships. I think external counsels also understand that their role is evolving, and they're also loosening up. So, but it's complementary to each other. Yeah.
External counsels here, the legal firms. Anyone having any question? I can take at this stage. Then I'm going on to my last question. Yes, sir. Can we have a microphone?
I think a great point
economists that the role of general counsel now become more of a business enabler than anything else. And so certainly gone are those days where legal departments used to be regarded as a cost center. And I totally agree with the overall thought and sentiment of all the panelists here that you all are business enablers and you have to enable business growth while of course ensuring that you're on the right side of law. One question for all of you, of course, there is this overarching issue that unfortunately general counsels do not have attorney-client privilege in India, which is, I do personally feel something that Bar Council definitely needs to act up. And I think it's absolutely paramount because all of you are playing a very critical role internally of advising, and ultimately all these business departments are your clients and you're advising, and there are issues of fiduciary responsibility. So one is this issue of attorney-client privilege that I think general counsels absolutely need. But the other issue is that if you look at the US, and typically India is always 10 years behind, and we typically follow the trend. What we are seeing with a lot of US corporates particularly is that the general counsel is now no longer reporting even to the CEO. The general counsel is reporting directly to the board because he or she has a fiduciary responsibility, which is much more than just maximizing revenue or maximizing bottom line. Governance is a key aspect of it. I don't know if there's a view of the panelist on this particular tricky one that, earlier I know that a lot of general counsels unfortunately used to end up reporting to the CFO, which, was absolutely ridiculous if you were to ask me. Is that something that's changing? And, what are your thoughts of how that will play out?
I can go
have multiple answers. Yes.
All right. So attorney-client privilege, absolutely. And I think we're fighting hard for it. I think we deserve it. And also but we also, we have a way around, right? You guys exist to help us there. And I mean, we take full advantage of that part as well. But it is an important aspect, the attorney-client privilege. And especially if you're working with international companies, multinationals, if you're listed on several countries' stock exchanges, all this comes into play quite significantly. So that's absolutely on merit that attorney-client privilege needs to be established for us. But till the time it's not coming, you guys, we rely on you. The other part is on, the fiduciary responsibility. I alluded to it in the beginning itself that I think we do wear a strategic hat and we are part of the business and we are all in for the commercial success of the organization, but we wear a different hat of a conscience keeper as well. And that's our responsibility. And if you see large size progressive organizations, to your point, do not have reporting lines. I mean, I don't even report into the market today. So I report directly, independently up there because it's important that we remain business lawyers, but it's also equally important that we have an independent view of how the business is being conducted with all the issues that we see today on sustainability, on ESG, on, the ways the companies are approaching a business problem. You have these issues around worker conditions, human rights, yeah, exactly. It's going to be even more, and we are all going to get accountable in how our companies are operating in certain markets, in especially emerging market like India, right? Where, we have this tendency of grays and chalta hai. That is no longer going to be, negotiable anymore. So from that perspective as well, I think it's going to go more linear. I think it's going to be an independent oversight that would be required. In most organizations I know of, Fortune 50, Fortune, strategically, they have placed supervisory board to be the reporting of general counsels and governance councils as well. So I think it's going to go more and more. And India as well, I think ESG reporting is going to get very soon mandatory, and greenwashing and criminal offenses around that are also going to come very soon. So I think companies need to start thinking about it already.
So my thought on the point of privilege, definitely because of that Supreme Court ruling where the in-house lawyers are treated as an employee because you draw salary, the employer pays you a salary, and there is an employer-employee relationship. Therefore, we are not at par with an advocate as defined under the Advocates Act 1961. But having said that, on the point of privilege, We know that what happened to one of the prominent law firm in India, the privilege was completely set aside, right? The attorney-client privilege was ignored. We are also hearing now that lawyers would be required to disclose the money laundering aspects of their client under the PMLA Act. So where is the question of client attorney privilege coming up? So purely from an Indian context, this is one arena where government need to respect the provisions of the Evidence Act, and client attorney privilege should truly be respected. The second component, as in-house lawyers, definitely we have been fighting with the government and the Bar Council saying that please accord the same status that you accord to an advocate, because if you see the whole A.K. Balaji judgment, we say that we are practicing the profession of law, right? We are also doing the same thing which an advocate is doing, except the appearance before the court, but we are also practicing the profession of law in courts. So therefore, we are talking about according the same status that an advocate has as in-house counsels. Now, in terms of, to answer your question on the corporate governance part, things have definitely evolved. I remember the days when in-house counsels or the GC were reporting to the commercial head or a CFO. That has changed. Now, people are reporting to the number one, the country head of the country. Are we reporting to the board? Many of us are not today. Do we have an interface with the board? The answer is yes. I'm going 2 steps further. I'm saying that as a general counsel, we are responsible for the corporate governance. I'm saying that why don't you make us accountable under the Companies Act, where we are accountable for the corporate governance, same as a statutory auditor is accountable, same as a company secretary is accountable. So give us that accountability. You give us that empowerment, give us that statutory recognition, and then make us accountable for corporate governance. We are ready to take, because that is what we are doing day in and day out. So make us accountable, and we are ready to take that accountability. You know, that's the.
Thank you. Thank you for elaborating. You have a point you want to make?
Just to add to, I think they've covered just another point, and agreeing with Pooja that if not reporting to the board, of course, where general counsels are company secretaries, you know, they also have an interface with the board. And also the reporting lines have changed, definitely changed. You report in, you know, to the legal hierarchy also, and that makes quite a lot of difference. You know, so apart from reporting to the country head or to the managing director, that really helps.
So it's no longer a catch up now. I think we are also making our own strides, right? If I understand it well. But thank you so much, my panelists, you know, for sharing all your thoughts, and thank you for that brilliant question, and thank you to all the ones who are here listening intently. I think we're done. It's almost just a minute left. I just want to, you know, thank you for sharing your insights. It's been a great panel. Thank you.
Thank you very much. Could I please request you all to kindly come up front for a group picture? We're now headed closer to the award ceremony, ladies and gentlemen. This brings us to the last panel discussion of the day. The topic at hand is cutting the Gordian knot of bail in white-collar crime. Please welcome our panelist. Please give it up for Mr. Nikhil Guliani, Head Legal and Secretarial, NDTV Group. Ladies and gentlemen, thank you for your patience. Once again, the topic at hand for the final panel discussion of the day is the cutting the Gordian knot of bail in white-collar crime. Please join me as I welcome our panelist, Mr. Nikhil Guliani, Head, Legal and Secretarial, NTTV Group. Please welcome Mr. Nikhil Vashni, Director, Cyril Amarchand Mangaldas. Please welcome Samudra Sarangi, Partner, Law Offices of Panag and Babu. With a round of applause, of course. Please give it up for Mr. Siddharth Batra, AOR, Supreme Court of India. Thank you. Super kind of you. Loving the enthusiasm. Please welcome Mr. Pramod Dubey, Senior Advocate, Supreme Court of India. And completing the session, please welcome the session chair, Neha Nagpal, Founder, NM Law Chambers.
Good evening to all of you. I must thank BW to have all of us here. It's indeed is a real pleasure to be here with my esteemed panelists, and I would just take 1 minute each to introduce everyone here. Mr. Pramod Dubey actually needs no introduction. He's a well-known, well-regarded face as a senior advocate in the Delhi High Court and Supreme Court, and has actively contributed a fair bit to the jurisprudence when it comes to especially bail law. We have Mr. Siddharth Batra here with us, who has been standing AAG for Additional Advocate General for the state of Haryana, a well-known AOR in the Supreme Court. We have Samudra Sarangi here, who is a partner with law offices of Panag and Babu, and constantly is advising various companies which are on the Fortune 500 list and Nifty 500 companies on white-collar crime issues. Nikhil Vashni here is a director with Cyril Amarchand Mangaldas, and is also a well-known face when it comes to advisory relating to white-collar crimes and money laundering. The topic for this panel is rather interesting because it is, bail law actually is today in the country a much talked about topic. The media covers it enough. When we go back in history to the 1950s as well, since then, Supreme Court has repeatedly held that bail is the rule and jail is an exception. But the trajectory of the bail jurisprudence has seen a lot of upheaval, especially since the advent of white-collar crime in India has been on the rise with the 2G scam and then the coal scam. For the first time when, despite the Delhi High Court judgment, where accused in 2G scam after filing of charge sheet were taken into custody. That led to the Supreme Court's judgment in Sanjay Chandra, once again reiterating the principles on bail. But since then, again, we've had a lot of upheaval, especially with the twin conditions in the PMLA Act and the serious fraud investigating office powers. So on that note, I think I will leave it to my panel to take it from there. I will start, of course, with Mr. Dubey. So my question to you is the bail jurisprudence in India, especially when it comes to white-collar crime cases, in consonance with Article 21 rights provided for in the Indian Constitution?
Thank you, Neha. You are well versed with, because you are practicing in the criminal side. One thing is very important in the entire criminal jurisprudence. That is the presumption of innocence.
Correct.
So, during the course of the investigation of the trial, you are not held guilty. So you being the person, you have the very precious right, that is the Article 21. And if you go in the entire structure of the criminal jurisprudence, the entire structure of the criminal jurisprudence is based on Article 21. From the very beginning till the end, the accused persons are being given the right every time to prove their innocence. Like at the time of the investigation, you have the right to move the application for the bail. After the filing the charge sheet, you can move the application for bail. Then the supply of the document without making the payment to the, then it is a duty of the court to supply you. You can consult your lawyer. If you are not able to engage the lawyer, the legal aid and the court will provide you the amicus curiae to assist you. Even at the last stage, every accused would make the statement on oath, but the accused has been given the right to make the statement without oath after consulting the lawyer. So the entire things, if you see the chronology of the entire criminal jurisprudence, the only thing you will find Article 21. And one thing is very important, and we must understand the only test in the entire criminal jurisprudence, whenever you are fighting the case, every stage you will find the doctrine of prejudice. This is very important. If the state is moving an application or the accused person defense is moving the application, the only test before the court is what prejudice is being going to cause. And you have to meet out your case regarding the prejudice. But there is no thermometer, there is no measurement of your prejudice. You cannot measure this is my prejudice is 60 centimeter or 90 centimeter or 99 centimeter. So there is only thermometer and there only test to examine your prejudice is Article 21. You cannot deprive the personal liberty of any individual without except the procedure established by law. So you have to follow the procedure established by law. And that's why we have Indian Evidence Act, we have the criminal law, we have the special statute. The moment there is a diversion from the procedure established by law, the benefit would always be given to the accused, not to the state. It is the duty of the state to follow the procedure established by law, because the entire criminal jurisprudence, the concept is the right and duty. If you go to the basic concept of the Haufeldian scheme of the jurisprudence, it is the right of the, if there is the right of the accused, it's the duty of the state to protect the right.
Absolutely, sir. Agree with you.
So I would say that Article 21 is the jewel of the criminal jurisprudence.
Absolutely, sir. Thank you for that, sir. My next question is to Nikhil here. Nikhil, since you are more from the industry specifically, I wanted to ask you, do you think that the reluctance or the alleged reluctance in granting of bail is dampening the entrepreneurial spirit in the country?
I mean, Neha, I don't think anybody sitting in this room would deny the question that you have asked. I think it's it's very much known that the environment in the country, at least in the white collar crime space, is such that whenever an investor comes into India, it's not, while of course a lot of focus has been on ease of doing business, but this is also one of the areas that an investor looks into, that how are the courts coming to rescue, just in case the company or they are in legal trouble. That's one part of it. The second part, of course, is we saw recently Justice Diva Chandrachud announcing 10 bail cases every day being heard, while of course the intent was correct with respect to hearing the bail applications. But I think what got left out is the white collar crime sector, because I mean, at least in while there are certain judgments which recently came in after Entel came in, Entel 3, be it Justice Bambani's judgment in Ashish Malhotra, or maybe Rana Kapoor, wherein the court, at least the Delhi High Court, if not the other high courts, have started giving green signal to bails, be it in ED matters or be it in ED matters or be it in the SFIO matters. But yeah, I mean, any investor coming into India would definitely has a question if the courts in India would come to save them. And funnily enough, the problem is that when the business is hunky-dory, everything is all good. But once you are in a soup, then you crumble like anything. So
that's lawyers also are remembered, no?
Yeah. And I think to some extent, maybe the IBC also has some role to play there, because it is only after the IBC came in that we saw, and of course it all started from 2011 when Sanjay Chandra came in.
But we saw, when it merged with the enactment of IBC that, once there's someone going insolvent or maybe fraud circular, fraud, and a bank account turning fraudulent, it's all the enforcement agencies is going to start getting active about it. So that way it is.
So
Thank
you're
you.
actually right to say that, and that in very many cases, IBC and ED issues or SFIO issues go hand in hand. One triggers the other. So actually, that leads me to my next question to Samudra. Samudra, tell me, how relevant or important, or more appropriately put, necessary is it to arrest somebody in sort of any money laundering issue or a fraudulent bank account issue triggered by the declaration of account as a fraud, especially when most of these transactions go back to the hunky-dory period and all of them are documented. So it's not that you need any recovery to be made. How relevant is an arrest in such cases?
Yeah. So I think as defense counsel dealing with white collar crime issues, we have a lot to bemoan in terms of how jurisprudence has evolved in terms of white collar crime. But the one thing that I think the agencies have a right to bemoan even more is the task that they're faced. Correct. It's a complex job. It's not, investigating somebody through and through to either identify somebody who's guilty or if actually a bribery crime has been committed. And when it comes to money laundering, the threshold is even higher, right? So given the significance of the task, unpopular opinion or not, I believe given how structured some of these crimes can be, arrest is probably one of the more effective ways to investigate. Now, I say this with a little bit of pinched conscience and some assumptions, of course, that if an agency is doing its job without any sort of influence and it's really conducting an investigation independently, subjecting yourself to arrest and walking out on the other side, explaining to them your innocence is probably one of the best clean sheets you can get, even better than getting a clean sheet from court. So I feel arrest is an important tool that agencies have to exercise. The question really becomes is it being exercised to find the truth or what the facts are regarding an investigation? Or is it only being done to deprive liberty? I think one set of exercise of power, moral, has a higher ground to achieve maybe some tangible benefit to the investigation at large. But if it's being exercised to curtail liberty, which in some cases more often than not is what seems to be becoming the trend, I think that's a dangerous set of jurisprudence that we're sort of walking into the future.
Well, I'd like to follow that up actually with a short question to you. How do you read what you just said with the Supreme Court judgment in Until, where Supreme Court has categorically said that if consciously somebody is not arrested and then post-filing of charge sheet, you needn't arrest them. How do you read it in with what you're saying? That means the investigative agencies actually have the power not to arrest, also have the discretion not to arrest, especially in white collar crime cases.
Yeah, so I think one important trend to observe is there's no longer a case where there's only single charge sheet, right?
Yeah.
There are cases with multiple charge sheets,
Correct.
cases with 7, 10 charge sheets.
Correct.
The more complex ones. So there is a scenario where a charge sheet has been filed and you still need to investigate further to unearth everything else you're discovering as part of a supplementary investigation. Now, again, as long as the supplementary charge sheets, the supplementary investigation is a follow-up to the initial investigation, fair enough. I think there's a merit to be had in a post-charge sheet arrest as well. But if the objective again is to come back with more dirt only to stick somebody in jail for an extended period of time, that's complex history. I think investigative agencies' motivations play a large part in whether that's a fair practice or not.
I would tend to agree with that. Siddharth, I'd like to ask you, tell me, in your view, is it correct to classify economic crimes as a separate category of offenses, especially when it comes to bail?
Good evening. First of all, it's great to be sitting next to Mr. Dubey, I believe, an authority when it comes to white collar crimes. I've had the pleasure of assisting him on a lot of matters, and great to be with him on this panel. And thank you, Hina. I got to know you've a lot of in-depth knowledge about this as well. Though this doesn't remain my area of practice, but I've also seen, since as a practicing lawyer, as to what has happened. I had the opportunity of advising a few clients on this. Obviously, look, as far as the mic, can you hear me now?
Yeah, much better.
So now, lately, if you see, the PMLA is what we are talking about, as what was mentioned about Vijay Madan Lal, the judgment. One of my fellow panelists was mentioning about. Look, the PMLA is, as an economic offense, is associated one with the schedule offense. It has to be a schedule offense first, which is provided in the list in the PMLA, and then comes the PMLA. This becomes a very significant feature because it becomes first, it's an economic offense. It's to do with the social system that we have, and it's to do with the economy of the country as well. So therefore, to categorize it separately, I believe Neha is completely valid. There's no problem as far as the categorization is concerned. Obviously, as you see that what is lately happening is that bail has become very difficult to get in cases of PMLA. Usually, the twin conditions which are coming in Section 45 is a very hard thing to cross. And the law is completely different, as you were also mentioning initially, that in fact, it has to be shown by the accused as to how he's not guilty. And if you see that the reading of the section itself, it says that the court will only grant you bail when it is shown on the record that the person is not guilty of the offense. Though Mr. Dubey can put more light into it, what my reading is that ultimately it's equivalent to an acquittal. It's today.
One of my follow-up questions. And
Yes, it's that severe, if you ask me. And the second thing is that the question that you've posed to me about this being an economic offense, look, it is connected to a scheduled offense, as what I said. If there's an offense under the IPC or the Prevention of Corruption Act, it does not originate on its own. Whether a person can be kept inside or whether a person can be prosecuted under the PMLA alone is a question which has been answered by Vijay Madan Lal. But if you ask me, the Enforcement Directorate is interpreting it differently. And in some cases, the ED is saying that, in fact, the accused need not to be in the scheduled offense if he's actually laundering the money which has come out of their offense. And it's single on its own can stand as well. Vijay Madan Lal, yes, put some clarity on it. What we as Defense Counsel read it as that, look, it can't be a standout offense on its own. It has to be connected. But yeah, obviously, as far as the categorization is concerned, it's a serious offense. And since it pertains to that way, the economy of the country, I believe I consider the categorization to be completely, perfectly valid.
Ms. Dubey, I'd like to ask you, sir, there has always been this whole debate about bail is the law, bail is the rule and jail is the exception. But somewhere post 2011, the Sanjay Chandra judgment, Supreme Court started taking a divergent view when it came to economic offenses by broadly saying that by Jagan Reddy and Neera Yadav, that economic offenses damage the social fiber in the economy of the country, and hence bail ought not to be granted, it should be restrained in such conditions. That coupled with what we call as the twin conditions, more particularly in the NDPS Act, PMLA, and now SFIO, which is where one, the public prosecutor has to be heard, and two, you have to give, the court has to come to a finding, which is pretty much equivalent to an acquittal, that there is no offense as alleged made out. So the bailing arena, if I may call it, in the country is stormy and tough. There have been divergent views, even with the twin conditions, where in 2017, Supreme Court struck down the twin conditions in Section 45 of the PMLA, Nikesh Tarachand's Jain. Then Parliament, by an amendment in the form of a clarification in August 2019, resurrected it. That came to be challenged in Vijay Mandal Lal Chaudhary. Finally, in Vijay Mandal Lal Chaudhary in July 2022, it was upheld. Now, though, of course, the twin conditions when it comes to SFIO is still pending consideration, the fate of it is almost way to comply. My question to you really, sir, is we've also seen until happen, three rounds of until 1, until 2, until 3, which is now also the last one made it applicable, the principles of until, as referred to earlier, to anticipatory bail law. But sir, my question is, and it's a disturbing question as a defense counsel, that are these twin conditions absolutely relevant? Are they required? Do we need them to be on the statute book? I mean, in your view, are they not, if they're not applicable to the predicate offense, why have them in the offense that arises out of the predicate offense?
Neha, being the part of the judicial system, we have the judgment in the Madan Bijay Lal Chaudhary.
Yes.
And Madan Lal Bijay Lal Chaudhary has already given the finding that twin condition is constitutional or the unconstitutional. You have rightly mentioned that the Nikesh Tarachand, it has already been declared by the Supreme Court that twin condition is unconstitutional. But see the beauty of this Madan Lal Chaudhary's judgment. Even after Madan Lal Chaudhary's judgment, Justice Rivington, who was the author in the Nikesh Tarachand, has openly made the statement at the public forum that this judgment, Vijay Lal Chaudhary's judgment, is not in consonance with the personal liberty and the constitutional mandate of the country. So even there is so many views are there. See, ultimately the question is bail. What is bail? Bail is for the limited purpose to ensure the person's presence to face the trial. You cannot put the stringent condition by putting the draconian law depriving the person. You cannot judge the person whether he and how the accused, this is also debatable, how the accused will prove his innocence at the stage of the investigation when the entire materials are lying with the prosecuting agency. And how the court will give the finding he is not guilty and he will not commit any offense in the future. So this concept of the twin condition is completely stranger to the concept of the personal liberty. But we don't have any option. The Supreme Court has already given the finding. But the beauty, we are very lucky, we are practicing in the High Court and we have the judgment of Justice V.K. Jain of Delhi High Court in Rana Kapoor. If the person has not been arrested and the complaint has been filed, at least we have the one set of the judgment which says that no, there is no need to put the person behind the bar. The question we have put the Y. Jagan Reddy case. Yes, there was a jury at that time the economic offenses and it should be seriously be taken and it is damaging the social fabrics and everything. But we are again very fortunate. We have got the jurisprudence by Justice Sanjay Kishan Kaul in Satinder Kumar until, and he has clarified even the offenses are of economic offenses. This cannot be the sole ground to reject the bail. You have to see the entire material. You have to take the holistic view. You have to consider the bail jurisprudence. So as on date, because Satinder Kumar until started with the 2 judges, ultimately it went to the 3 judges. So at least we have the judgment of the 3 judges which says, you know, why Jagan Reddy case is not the sole test for the economic offenses and the judges have the discretion to grant the bail. And I think since I am practicing in the defense side, so most of time I have taken the opportunity to defend the right of the accused and follow the personal liberty. So in my view, there is no purpose for the continuation of the twin condition and put the person behind the bar as a pre-trial convict. They are not the convict, they are the pre-trial prisoner. And that time, unless and until you release the person, how the person will create the defense? How will assist the system? So you are depriving the person by putting this in a stringent condition only under the garb of the so-called Commission of the Offense of the PMLA, SFIO, though there is no twin condition in the schedule of offenses. So they are bail on the schedule of offenses, but you are putting person behind the bar for the money laundering. And still, till the court has to come to the conclusion whether there is a commission of the offense or not. But you want to test everything at the stage of the bail. So I don't think that putting the twin condition is in the spirit of the protection of the personal liberty of a human being.
Thank you, sir. I think that's a great deal of insight into the position of law. Samudra, my next question is to you. In your view, since you are a defense counsel, like most of us here, in your view, does delving into allegations and requiring the court to come to findings on the alleged role of the accused in the offense, does it result in conducting a mini trial at the stage of bail?
There's a short answer to that. Yes, it does. There's a lot of jurisprudence now that we keep saying that, you shouldn't have mini trial at the stage of bail, but I think that's more paperwork as opposed to what we see in trial courts and what we have to fight in the High Court.
I know it was a rhetorical question to ask you.
Fair, but this is how I look at it though. I think I echo what Mr. Dubey said wholeheartedly, right? And at a principle level, I don't have to say much more about what I feel about the twin conditions after what Mr. Dubey said. So that's taken care of. But since the Supreme Court sort of closed the door on what twin conditions may look like in the future, it's pretty much going to be this. As defense counsel, our role has changed. I think we can no longer rely on the standard tests of bail that we've been historically relying upon for the last couple of decades.
Tripod test.
A triple test. A triple test is no longer, I mean, I think everybody here has defended somebody where we filed judgment compilations with until 1, 2, 3 and all the judgments that are, but other than adding to the wealth of paperwork for the court's disposal, they don't seem to move the needle on bail. So what I feel we really need to do is change what our approach to dealing with money laundering cases, especially. I think we have to be open that we have to fight an ECIR like it was a charge sheet. And then when we get a charge sheet, you fight the charge sheet like your life depended on it, like you were fighting a conviction.
Correct.
That's the only way to get bail. I feel
it's a very interesting prerogative, actually. Perspective.
I think we are past the stage where we can fight the twin conditions. I think that fight was fought and that's been lost. So I think we have a moral duty now to fight the twin conditions for what it is and an ethical duty to our clients to find a way around it.
Correct. I take this to Nikhil. Nikhil, very correctly, you mentioned the Ashish Mittal judgment, which recently by the Delhi High Court, Justice Bambani said that, even at the stage of bail, you need to prima facie come to a finding. So basically, he's kind of, blown off the steam to some extent. But despite that, I'll ask you, do you think twin conditions actually prejudice the accused of a defense? Because even prior to, arguing charges, you are going down, arguing your entire case. Do you think that causes a fair bit of prejudice?
That indeed does. I mean, no two doubts about it. That the twin condition basically is more like a test, other than the regular conditions that are there for a bail. You have to undergo the test of the twin conditions, which are there, and which again, as Dubey sir had put it, that it's more like you are undergoing a mini trial, and as you also just said it, that you're undergoing a mini trial at the time of bail, be it for the regular bail or whatever the case is. But having said so, I would also like to say, again, hats off to the Delhi High Court and hats off to Justice Bambani, that at least in Ashish Malhotra, he says that don't see these two conditions. These are only the conditions that have to be, the test that has to be passed through, but don't see them as, as anything which is benting against the accused. Whatever evidence you may have, howsoever good the prosecution case may be, at the end of the day, it has to pass through the test of, the trial.
Correct.
So that way it is. That's how I see it.
Thank you for that. And before I think we're running out of a lot of time, and I have my closing comments also. So Siddharth, I'll quickly ask you this. So there is an exception to the twin conditions, which is basically it's not applicable to the sick and infirm, to women. Being the only woman on the panel here, I should not be saying that, but to women and to anybody who's under the age of 16. So in your view, are such exceptions required, or do they create prejudice?
I think we all will agree here on this, Dice, that's the silver lining. Since being the twin conditions as discussed by the earlier panelists, it's so hard to get the bail. So that's the only silver lining that we have, that in fact, on medical conditions and all that, bail is being managed and courts are granting bails. But as far as your question is concerned, that as to whether, look, these exceptions are in the right spirit or not, obviously, yes, I feel women have special needs, and ultimately, my personal opinion, that in some cases, women are the directors, but it's the men who are running the business. And if there are some cases of the PMLA and with such stringent conditions that they have, it may not be the right proper thing to put the woman behind the bars. And the incarceration is also long. We are seeing that usually in cases of PMLA, it's very hard to get bail, not before the final complaint is filed, but even after that, it's very difficult to get the bail. And number two, regarding minors who are less than the age of 16, obviously, we already have a law. They are considered to be juveniles, and there is a reformative theory that our jurisprudence follows. So on that, I believe it's in the right context. And other disabled, and I think the care has been taken, because ultimately it's a fraud which has been played upon in the PMLA, where some money has been laundered, and where so some people with special needs may not face the incarceration. So exceptions have been drawn, I think rightly drawn, and I think a lot of us are now trying to manage for our clients if they can get out on some medical grounds.
Yeah. Thank you for that, Siddharth. And I'll finally take it to the closing comments. What I've personally noticed as a practitioner of on the white collar crime side is that multiple bail petitions sort of end up clogging the courts. So trials don't really end up starting. And then there is this whole hue and cry of pendency of criminal trials or trials generally. But read that in with this unnecessary load that comes in with bail applications. And because there are multiple accused now, multiple bail applications. So, Mr. Dubey, I'd like your views on that.
See, Neha, my first concept in the criminal law is bail must be granted. There is no purpose keeping the person behind me. And one interesting thing I would like to mention, you have mentioned regarding the exception regarding the women, I would like to say, you won't find since the enactment of PMLA Act till date, any female, any woman has fled from the justice who are facing the offenses of PMLA or the SFI. So one thing, second,
law-abiding by nature.
So, yeah, that's a law-abiding by nature. So they have not read, they have not misused the personal liberty granted to them. And the courts should see, one side we are crying every forum, our judicial officers, the Chief Justice, everyone has the concern of the pendency of the matters. What we are doing, we are multiplying the pendency by denying the person behind the bar. Every time they are after a month, after 2 months, the first bail application, second bail application, third bail application, because the person is not willing to stay in the jail. They have the right, they are the human being. You cannot put behind the bar on the assumption and presumption of your investigating officer. So at least you should be liberal. And I'm also again saying that we are very grateful to the jurisprudence led by Justice Sanjay Kishan Kaul in Satyendra Kumar Antil. And the Satyendra Kumar Antil has opened the path. And not only that, in Satyendra Kumar Antil, there was a defiance of the order passed by the Supreme Court. And the Justice Sanjay Kishan Kaul passed the direction to send the judicial officer for the training. So this kind of the proactive approach should be taken by the higher judicial officer so that the lower judicial officer should be encouraged to grant the bail. Yes. Unfortunately, what is happening, if you are getting the bail from the lower judiciary or the trial court, there is a presumption that no, there is no application of why the bail was granted immediately. You see, latest what happened in the Priti Chanda's matter.
It's unfortunate.
She got the bail after being behind bar for more than 2 years, and then they immediately stay of the bail. So this kind of the thing will increase the volume of the matters in the Supreme Court and the High Court and any matters, and there would be, there is a 100% certainty for the multiplying the pendency of the matter. You cannot deduce.
So on that note, I'd like to interrupt because you have a paucity of time and ask Samudra and Nikhil and Siddharth for their short closing comments, please.
To close, I'd say that the rules of the game have changed, and I think we need to change with it. To borrow from one of India's historical oppressors, if the ED or the agencies fight in the sun, then we fight in the shade. If they fight in the rain, we fight in the dry. But the question is, the fight's on. But one thing I'd like to borrow is, lower courts do need to come in. Lower courts do need to start granting bail a little more. That kind of jurisprudence has to flow down from top down.
Correct.
And that's when we'll see historical change.
Our Chief Justice has been very clear about that.
And I hope that continues.
Absolutely. Nikhil, I'd like your views.
So I would say that we have until now, we have seen until 3. Now let there be until 4 and until 5 possibly, because of course the Supreme Court is, monitoring all of the entire case. And now until 4 should be like this, that, let there be consolidation of bail applications when an investigation is happening, when 2-3 different enforcement agencies are, investigating one particular transaction or one particular accused. So let there be consolidation. Let one particular judge hear the matter, dispose of all the bail applications arising out of different enforcement agencies in one go. In the event it is so happening that the second bail is to be filed, because only the investigation came into picture only when the bail was granted in the first matter. This investigation by ED, for example, began only subsequently. Then in that case, the first order of bail should act as an aid as a protective order for me, so that I don't go running
Correct.
behind, taking that
Correct.
again
I
anticipatory bill
agree
or
with
something.
you. And on that note, I take it
Thank
to
you.
Siddharth for his closing comments.
Yeah, I'll be quick. I think I can feel the pain of all the lawyers at the dice that bail has been very, very difficult. I think the law needs a relook as far as twin conditions are concerned. And you talked about, Neha, rightly about the pendency of the case and time it's taking. Look, what the investigating agencies are doing, they're coming up with a plethora of documents in order to completely implicate somebody in an offense, and you're not even getting the bail. I know it's completely taking a lot of time. I echo what Mr. Dubey said about what Justice Rohinton later on made a comment on a public forum about the judgment. I think I completely agree that this needs a complete relook, and the lower judiciary needs to be sanitized as well. And their orders, when they grant bails in such cases, should not be looked upon with such kind of suspicion. And it's not just the superior courts which have the right to grant bail. I think our lower courts should have those powers. They already have the powers, but they should not be looked with any kind of suspicion. Yeah,
Thank you, Siddharth, for that. I'd obviously like to thank my esteemed panel for their views. It's been a very thought-provoking session. It's been an absolute...
And one thing, you'll give the credit to all the panelists. We are very disciplined panelists. We have basically made up the time.
I absolutely enjoyed
So credit goes to the jury chair and the moderator.
No, sir, it's so much so for diversity. I'm the only woman here. I have thoroughly enjoyed moderating this panel, or should I say manning this panel. But on that note, thank you once again. And I may open the house for some questions.
Ladies and gentlemen, the floor is open for questions and answers now. Kindly raise your hand and we shall pass on the mic to you.
So I have a question for Mr. Dubey. You talked about bail is a must, right? We also talked about the situations where trial court doesn't grant the bail. What happens when the FIR is quashed? What happens when the accused is discharged after the filing of the charge sheet? Why is that jurisprudence not developing where the state is compulsorily made to compensate for the wrong jail? The accused has been put into the jail. Why is the police officers or the investigators not penalized because they have made a wrong arrest? And we all know two things for sure, which is a matter of something which is in public domain. Many a times these arrests are motivated. Many a times the FIRs are filed, which are motivated FIRs. So why is that not happening? So tell us something about that.
Thank you, Mr. Sundaram. I would like to say we as society are not proactive. There is a provision for the malicious prosecution. If you go in the CRPC, there is a provision, I think 188 or 182 CRPC, IPC, which give there is a provision. If somebody has done the malicious prosecution, you can file the case. Even there is a provision, you can file the suit for the declaration and the compensation. But the people are so apprehensive, they don't want to come forward and file the case against the state agency because they are always carrying the apprehension that they would be implicated in some other case. So everyone enjoys the peaceful life and they are basically forgetting what is happening. We are not in that country where we are so proactive. We are so precise, so apprehensive with the state machinery. That's why we are sleeping over our right, but we have the provision.
No, but I'm on the point that why is the court not making it a part of the order wide which they're quashing the FIR?
See, there are two things the question. One is the ingredients of the cases are not made out. Second thing, the factual aspect. Third thing, if there is acquittal, ultimately there is acquittal. The prosecution failed to prove this case beyond the reasonable doubt. And there is one finding that there is no material at all. So it totally depends upon the finding of the court. If there is no material at all, then you have the right. You have the right to prosecute the person who has initiated the malicious prosecution. But if there is your acquittal is based, your requesting petition is based on the technical ground, of course, you are not liable to be compensated. So there are so many things in the criminal jurisprudence to get the FIR quest. If you apply Bhajan Lal test, then this is all together. And this is also the one of the ground for the Bhajan Lal is the malicious prosecution. Then it is the liable to be quest. So we have the provision, but the only the thing is the people are not coming forward. They are not utilizing their right. So it is not like that there is no provision. And why the courts should be so proactive? Because we have the three-tier judicial system. If suppose the trial court has given the finding, you never know what would be the finding in the high court. And the litigants, the accused persons have always apprehension. If they are going to file the case for the compensation, the state will fight tooth and nail to get the order set aside, then they will go behind the bar. So nobody is trying to and willing to fight with the state message. This is the reason.
I'll just close one added thought. I mean, to leave, just to close on a slightly unsettling note. As an agency, the ED has a staggering stat of its conviction rate being in less than single digits. Yeah. Single digits. Yeah, roughly single digits. So, and bail becomes a norm now, probably a year and a half. So just to put things in context, there'll be a whole host of people who are right now in custody who may end up never being convicted, but spending a couple of years in custody while as pre-trial
But that's
custody.
what happened in the 2G matter, in the coal block matter, where all this whole things gathered steam. It's very unfortunate, and you're absolutely right. To just confirm the numbers, we have the largest assets in terms of numbers, 1,50,000 crores that are attached by ED, and 1% conviction out of in the 5,500 cases so far filed, which is actually disturbing.
Well, before I can thank the panel, I, on behalf of BW Legal World and BW Business World, would like to apologize to Mr. Dubey for not updating his picture on the backdrop. But you, being you, are bound to no introduction. But ladies and gentlemen, this has been an incredible session. Let's give a huge round of applause to our panelists. Could I please request you all to kindly come up front for a group picture? Thank you very much. Ladies and gentlemen, with this, we are now moving on to the keynote speech. And for the keynote address, the topic our speaker will be covering is the changing role of law firms. Ladies and gentlemen, join me as I welcome Mr. Shashank Bajpai, Advocate, Supreme Court Managing Partner, Vardharma Chambers.
Ladies and gentlemen, esteemed guests, legal professionals, and influential leaders in the legal industry. I stand before you today at the Global Legal Summit, extraordinary gathering of brilliant minds and visionaries who are shaping the future of Indian law firms. It is an honor to address such a distinguished audience, as I'm excited to deliver a keynote address, which is the most important and the running topic, the changing role of the law firms in India in the era of 2023, in the era of computerization, in the era of artificial intelligence. I'm thankful to Anurag ji, I'm thankful to Mohit ji, I'm thankful to the Businessworld who has given me this opportunity. There's a lot of things which I have prepared, notes for the trends, aspects, future aspects, and the current legal positions of the Indian law firms. Yesterday I've discussed, because we have a small, new setup of the law firms, which is running by the 13, 14, 15 young managing partners, and the youngsters who was working with us in the different fields. I started my practice as a lawyer, government lawyer, corporate lawyers, and different other fields I'm representing. Now there's the Bardharma Chambers. What is most important? I'll go with my written speech and I'll go with all the important aspects, which is most important. Yesterday night, I went yesterday discussed with the 2-3 important persons. What is the challenging? What is most challenging before us? How we should decide it? These are the challenges which law firms are facing. I have discussed with one of the partner. We should establish the new law firm. They said what we need: the structuring. We need some capital, good infrastructure, hiring 2, 3, 5, 10, 20 good professional, hiring juniors, good juniors, settled some of the offices, Delhi, abroad, Singapore, Malaysia, and different places. But what kind of challenges we are facing, that is most important. Now, answer which is I'm going to share with you. That was the last line I ever shared with the Anurag ji. Our topic is changing role of law firms. Law firms. There's the 4 words: changing role, law firms. There are the 4 people who are sitting here. Like they will be after my address. They will be the keynote address, giving some of the different aspects and different fields. What is firm? That is also very important. Sometimes we are making the corporate LLP, we are making firms, we are making companies, we are making chambers and association, which is some 1%, 2%, 3%, and 4 persons. But the question of this global era where we are deciding it, what we need. We need Anurag. Yes, we need Anurag. In the changing this era, Anurag is required. If you have an Anurag, the law firm will automatically change. How? Because there's 3 different aspects. I'll go with the legislation side, I'll go with the judiciary side, then I will come to the media and who is running this very important function, Businessworld Legal and Global Summit. Client के पास, the most important client who is coming to us, उसके आपके प्रति उसका अनुराग है? हाँ, अगर वो अनुराग है आपके पास, वो लॉ फर्म्स में आ रहा है, तो इसका मतलब फर्म आपकी दैट गोइंग टू द राइट डायरेक्शंस. कोई अनुराग होना चाहिए आपके पास, कोई मोहित होना चाहिए जो लॉ फर्म के भीष्म पितामह हैं. एक लॉ फर्म एस्टेब्लिश करते हैं, दूसरी लॉ फर्म एस्टेब्लिश करते हैं, लॉ फर्म्स के मास्टर्स हैं. मोहित शराब साहब, गरिमा होनी चाहिए आपकी फर्म में. तो गरिमा होगी तो लेटेस्ट निश्चित रूप से वो फर्म एक दैट विल गो टू द नेक्स्ट लेवल. And last, which is most important, the last and most finest dignity will come and join that Iqbal. Agar wo firm will rule and monopoly in the country, maybe in the global nature, that Iqbal is there, it means that firm is going to the right direction. You have a right strategy, you have a right footprints. That's point number 1. Now come to the political side. On that same, what is the present trend? I was discussing with 2-3 my other juniors who's prepared my very good esteemed speech of 8-10 pages. I'll go with that speech also because I have not running out of time. I'll conclude these important. Who is the Prime Minister of India? That is the most important question. Anyone may take the name of our respective Prime Minister. What is the name of the Prime Minister? Sir, anyone? Prime Minister हमारे कौन है इस time? नरेंद्र मोदी साहब. दोबारा पूछूंगा, हमारे प्राइम मिनिस्टर साहब का पूरा नाम क्या है? नरेंद्र दामोदर दास मोदी. जब भी हम whenever we are going to fill any form, we always mention what's your name, what's your upname, surname that will come after that, Shashank and Bajpayee. Narendra Damodar Das Modi. Narendra, the person who is the prime minister. राजाओं में राजा, super king. नरेंद्र जो राजाओं का राजा है. Name distinct names change said this is the person who is doing, what is the role of that person, what is the answer, and how he will going to run this country, maybe this country or other country, and the global leader. So आपको law firm में, if you are law firm, Iqbal is there, Narendra is there, you are in the top of the law firm's field. What are the challenges? Challenges, no challenges. You are the super brilliant brains. If you are hiring the brilliant brains, your law firm will be one of the best law firm. Point 1. Then who is heading the Chief Justice of India? Our Chief Justice of India, Dhananjay Yashwant Chandrachud. Dhananjay. I was researching. Dhan ke father's longest serving CJI, son is also one of the longest serving CJI. The Dhananjay Yashwant Chandrachud. Dhananjay, jisko dhan ki ichha nahi hai, one of the most brilliant, one of the most admirable, knowledgeable professor justice in the history of the Supreme Court in last 72, 73, 74 and 75, 76 years. यशवंत जिसका यश कभी खत्म ना हो, चंद्रचूड़ भगवान शिव का दूसरा नाम, और दामोदर भगवान श्री कृष्ण का दूसरा नाम दामोदर है, और भगवान शिव का दूसरा नाम चंद्रचूड़ है, और यशवंत एंड चंद्रचूड़ एक शिव जी को रिप्रेजेंट कर रहे हैं लॉ फर्म में, दूसरे हमारे कृष्ण भगवान को रिप्रेजेंट कर रहे हैं. नाउ कम टू द नेक्स्ट aspect, which is the first fight in the world. Lakata latest we are discussing with the different 1, 2, 3, 4, 5 peoples. That is Ram, advisor, advocate Hanuman, communication Hanuman and Ravana communication. They are saying what you want. हमारा ये dispute resolve कर दो, आप वाइफ को वापस कर दो. That is coming into the law firm side. Dispute resolve हो जाएगा, कोई फर्क नहीं पड़ता. Now come to the second side, जहाँ पे communication हो रहा है अर्जुन का भगवान श्री कृष्ण का. That side they are discussing. Arjun advocated several times. Arjun ये नहीं करना है, Arjun ये करना है. Duryodhan, this is the important aspect. You are lacking these 3 aspects which you should finish it. So advocate was Hanuman was the one of the finest advocate. Krishna was the one of the finest advocate. Now come to the law firms. Hanuman established first law firm. I don't know, maybe that first law firm because they have created all the financial aspect, searching investigation agencies, and after that war strategies, then communication with the Ravan, most important aspects. My submissions regarding that we are discussing to the Hanuman, we are discussing Krishna, we are discussing Ram, we are discussing Ravanas, we are discussing in this latest scenario where the law firms are the existing firms. Law firms, they're the existing 100 years old law firms, 10 years old law firm, 5 years old law firms. There's a several. I would request Justice Iqbal is here, so everybody may give a big applause for him. Thank you so much for giving some less time. Sir, with the due respect, Justice Iqbal here, sir, I was discussing on the topic and that time I missed one thing. I told the law firm, one of the finest law firm, what is the quality is required. So Mr. Iqbal is required. If Iqbal is there, then your law firm will be the finest law firm. He's one of the most motivational speaker, eminent jurist, one of the finest justice, professor justice in the country who is giving several interviews, landmark judgments, and there are different fields. Now we are coming to the specific areas, which is most important, most reliable, like Mr. Dubey ji said, ki bail is required. Every time, every counsel is coming to the court, finding the best law firm, that is law firm where we can get a bail or not get a bail. There's a surety in enforcement directed offenses, there are the SFIO offenses. You are not going to bail in the trial level. You may get the bail with the high court level or higher or Supreme Court level after maybe 6 months, after a year, or after 2 years. But what is important? Sometimes the other counsel is representing the same matter with a different court on the basis of face value, same argument, same ground, same points, or you are getting the bail. Then what is required? Same drafting? Yes, same drafting, 5-6 page drafting is required for a one bail petition. Same 10, 12, 15 arguments is required for arguing before the same judge. There's the discretion. there's a discretion in the hands of judge who is saying, yes, I'm going to grant a bail in this matter. I'm not going to grant a bail in this matter. If they are not granting the bail in that matter, what is your object? Your object to ensure or secure the bail, you will appeal that concerned impugn order before the apex court, or apex court will consider it. Maybe that apex court will grant you bail. Opposite side will go to the again apex second highest court, and highest court will say, no, you are not going to get a bail. This bail should be cancelled. Maybe some of the time, some of the latest judgment, which is latest order, which is Priti Chandra matter, which is Supreme Court issued notice on that bail petitions. This bail should not be granted, and maybe this matter is coming for the hearing in the month of July. What we are discussing role. We are discussing the future of the law firms. We are discussing the future partners, because Mr. Sharaf is here. Mr. Sharaf is looking each and everything. They are building the law firm. He's giving the best of the best legal brains in the law firms field. But where is the problem? Problem is the bifurcations. Problem is the divisions. Problem is the after 10 years, 15 years onwards, you are facing some of the problem, conflict of the interest between the partners, conflicts between the associates, conflict between the staff, because some of the law firms, they are facing major problems. We need to ensure that problem should be resolved. We need to ensure we should get best advice out of that law firms. In this field, where a lot of law firms, they are doing a lot of pro bono work, public interest work, advocacy, initiative to promote individuals, community, social rights, and address systematic issue, challenging unfair practice and effective social changes through legal means by collaborating with non-profit organizations, legal aids, and the conventions, moral rights, and organizations. Indian law firms are expanding beyond the local market by offering offices for forming alliance to other countries. They are serve Indian clients with the international legal needs and attract foreign clients looking for the legal help in the India. Thanks to the expansion, for instance, several Indian law firms, they have established office important financial hubs like London, Singapore, Dubai, New York to take advantages of global business opportunities. Indian law firms are crucial in facilitating investment and cross-border transactions involving Indian companies. They offer legal advice and assistance to the Indian clients who wants to start new business abroad or from partnership and joint ventures with other companies. And there's a lot of other things which is preparing for some of the changes. But I'll come to the straight away. There's a two important aspects which is very close to my heart: building confidence and the momentum. This time, the new era of the schools is established, national law universities. You are pass out with any of the prominent law, National University Bangalore, National University Bhopal, Hyderabad. You are hired by some of the top law firms. They want the top lawyers, top brains, top individual, top advocates. They are advising in the top matters. Second choice, the prominent lawyers. They are coming before the court. They are preparing the matters. There's a site, because collegium system is there, one of the finest system. You are elevated as a high court judge in the age of 41, 2, 3, 4, 5, 6, 7, 8, 9, or 7, 48, 49, or 50. That depends your caliber, your work, your standing before the court, and several other things. Second aspect, you are coming as a designated senior advocate before the court that time, because one of the finest example, which is most admirable, and the first time in the history of India done by Justice Chanchund, there's the International Professor Lecture series was started in Supreme Court of India, and they have called the Chief Justice of Singapore as the first speaker, eminent speaker in that conference. They said, what is the role? Because he was the youngest Attorney General in the Singapore. He was the youngest Chief Justice of Singapore, who was at the age of 48, he's became a advocate, Attorney General. They said one thing which is also very, very important. I established my law firm, which was the best law firm in the Singapore. I left that practice, came to the government side, giving the opportunity. I become Attorney General, the youngest Attorney General, youngest Justice in the Supreme Court of Singapore, and the youngest Chief Justice in the world, who is looking the longest and youngest Justice. Now the time, there's a lot of time. Mr. Balbir Singh is another very prominent lawyer, who's the ASG. He's also running one of the good law firm. Then he started the tax practice and one of the youngest tax lawyer in the Supreme Court of India. Law firm, client practice, legal senior development of the senior practice, and after beyond that, giving the good judges, good barrister, good solicitors, good clients, good result, good orientation, and a one place, in the one place you are giving all the facility. You are sitting in Delhi, you are providing the legal assistance of the client who is based on Mumbai, Dubai, and London. This is the facility which you can get it only in the law firm. Otherwise, that facility was not available. Point one. Point number two, what kind of challenges we are facing? We are facing the challenges. Yes, client retention, trust factor, because we are opening the new law firms. Trust factor is there. I don't know Mr. Bajpayee, who is Mr. Bajpayee, what kind of practice they are doing. They are giving the opportunities. That opportunities you may admire, you may not admire. That time, what will be helpful to you? Helpful to you is your credentials, your name, not your name of your law firm. That law firm is giving you the opportunity, because these are the persons who have given the reputed advice, handled several matters, mergers, acquisition, equity transfers, good fees, good clients. After that, sir, the highest court, which is the apex court in the country, is the Supreme Court. Normally, all these retired high court judges and the chief justice, they are after retirement, superannuations, they are coming as a senior advocate and started practicing the Supreme Court. That is also one of the very holy field where they are giving the nurturing lot of youngsters, giving lot of opportunity. Because I have, sir, one of the finest example, which is very, very important in my life. I can't forget that example, sir. I started my practice in 2008 and 9. I came to Supreme Court first day. So Justice Fakhruddin was here. So he said, Mr. Bajpayee, aap aaye hue hain. I said, sir, I don't know what is the practice, how to get clients, how to start my law firm. That time, he said, you want law firm? There's some consultancy service. You should go hire some, interact with the clients. And because I came from one of the very small district in Uttar Pradesh, as a Kanpur. So they said, what you want? I retained a client is coming to me. I never charge any fees. I said, what is the fees is required? For consultancy, yes, there is a fees. How much fees? I got 25,000 rupees as a consultation fees. Sub Justice Fakhruddin San ko ye fees dena hai. So first time I met him, he said, Mr. Bajpayee, there's 25,000. I'm not going to take. Don't worry, you are a youngster. You keep it 25,000 rupees. In that day, 15 years back, I was very happy. For 30 minutes meeting, I'm getting 25,000. That time I told to my father, Papa, 25,000 rupees sirf meeting ki fees mil sakti hai? Yes. Now this is the facility which is law firms are giving. We need to the professional law firms. We need to nurture the challenges and focused all India, because India is the role model. India is number one in the population in the world. India is the number one in the highest number of judges in India, highest number of lawyers in India, highest number of courts in India, and highest number of litigation in India, highest number of new FTI which is coming in India. And there's a lot of new hubs like Noida, Gurgaon, Faridabad, Gujarat, Maharashtra. There's a lot of new hubs. That time, role of the law firm, role of the trust building, role of the opportunities, role of the communication, role of the Indian lawyers is very important. Role of the Indian law firm is very important. Role of the Indian talent is very important, which is appreciated not in India and all over the globe. Everybody is trusting. If you are going to Malaysia, you are going to Indonesia, you are going to Dubai, they are trusting Indian law firms. They are saying, Indian, you are a good lawyer, you are passed out from the Harvard Law School, now you have started your own practice, this is your law firm. Whatever advice you are giving, that is one of the finest advice, point one. Point two, you are saying what kind of advice you are giving, which is the international advice, international offices, international advisory, international communication, international agreements, which is lot of communication. That time, now I'll come to the other holistic aspect of the law firm. There is a procedure. You are getting how to get work. You started your law firm, you hired best partners, best senior partners, best clientage, best offices, best locations, best infrastructure. But you need a best client. What's the criteria to retain that clients who will give you the work? And work is also important. After that, the most important, Mr. Sharaf will appreciate the fees. If you are getting the good fees because running that office, to maintaining that standards, parameters, fees is also required. So there's a criteria, there's your office cannot give you the good work. Your talent, your hard work, your communication, your interaction, and your goodwill. That goodwill will say, yes, that time your garma is required. Yes, they are the trusted counsel. We can trust them. They will give the best advice. You're a person who's giving your whole business to you. After your challenges, you are giving some of the best compliance in the best tribunals, best courts, best authorities, best policy decision places. But out of that, what you are getting maybe a fees, a reputation, quality of work, quality of dedication, quality commitments. My submissions regarding in all these things, because we are coming on that field which is the most challenging but most emerging. The field where we can say, yes, this is the field where we are the institutions. Your Hari Salve is the institution, Mukul Rodki is the institution, Kapil Sibal is the institution. But law firms, they make the name. They are delivering the practice. They're delivering the name. If you're taking the name of any of the law firm will say, yes, go. If you have a big law firm, go to the big matter, go to the tier 1, go to the tier 2, go to the tier 3. That tier 1, 2, 3 is not tier 1, 2, 3. This is the reputation which we build in the 100 years, 15 years, 10 years, and 5 years. But in this age where everything is changed post-COVID or pre-COVID, post-COVID, because there's the most respected new development is going to the Supreme Court. All the Supreme Court going to be changed in the court number 1, 2, and 3. Everything will be super digitalized. Court is coming to your home. You can watch each and every proceeding from your home. You can file any petition from any place in the world. You can see that matter. You can watch this matter. You can take the certified copies. Then what is the role of the law firm? The storage room is short. Role of the client, role of the litigation, role of the communication, role of the technology, role of the artificial intelligence. And that time, you need a trusted law firm who will give you the best advice. What is the best advice I want to win that case. I am coming to you only. I'm going for a quorum shopping and window shopping. Question simple. I don't know the law. I'm coming to you. What is the strategy? I don't want how much money you want. We are ready to pay, but we want results, because results, sir, that is the result sometimes depends not in the hands of artificial intelligence. Self decided on the hands of the discretion, on the discretion of the God, on the discretion of the super God are the Supreme Court judges, God are the High Court judges, and all judges are the gods, where you can say you are getting the some of the best, super best, and super best advices. I can conclude my this whole argument with giving the one of the finest case which we won in the history of the 76 year. I've never seen these kinds of cases in the history, because there is a 3 why I've discussed taking the name of the Lord Ram. Shayad mein Bhagwan Krishna ke mandir ka, we are the retainer firm of the Lord, several Lord Bakeviyari temple. Before that, the most important, there are the few clients, they are the good teachers. They came to us, they said, we want Shashank ji, ye matter hai. Can you look into the issues? I've gone through the matter. I've discussed giving this matter to one of my junior and said, see what is going on and what is the issues involved. They said, we have lost this matter in 5 times. High Court level twice, review level twice, then there is the appeal. We have lost the matter 5 times. What you want? They said, yeah, we are coming with you. We want you should take up this matter and take a chance. We moved to the Supreme Court. First day matter was listed before the Supreme Court. Supreme Court said there's nothing in the impugned order. Sorry, I'm not going to hear it. Sir, with the highest regard, after 2.5 hours of arguments, Justice said, what you want. That was the landmark case in the history of India. Their highest number of teachers was re-employed in the same cadre. 1,500 teachers joined The same primary school after 10 years, 2013-year-old litigation, we've been in the 2023. That was the landmark case in the history of India. And that second aspect, which is also very important, they said that what you want to hear it, that can intelligence, there's a two kinds of judges. Justice Vikram Nath was there, that Justice Anuruddha Bose was there. They said there's a two kinds of judges in India. One is the judges, second is the big heart judges. We are giving the opportunities, these primary teachers. They are serving last 10 years in the primary schools. They are getting 12, 13 or whatever the salary is. You said, no, they don't, they are not properly employed. We are violating their terms. The role of the law firm is there. We said this is not a bad matter because we are not the judge. We are giving the assistance to the court. We are giving the best assistance to the court. At that time, we realized never say no to the client, never say this is the bad case, there is no opportunity, there is nothing in the matter. Take a case, prepare a best note, prepare a best, super best agreements. Sometimes God is with you, sometimes court is with you, sometimes nobody is with you, at least lawyer and law firms is with you because they are getting the fees out of that. Sir? There's a which is most important is in the client and firms, client and professional client and client communication. That communications, this is the most privileged communication. We are not disclosing with anyone. Fees, sometimes we are not disclosing after the law firm practice. Fees are coming in the accounts. Young lawyers, they are getting a lot of opportunities. They are appearing before the different courts. They are handling different kinds of matter. They are dealing with interacting with the clients. Emerging own law firms. Sometimes there's a best place where the law firms, you are joined as an associate, now senior associate, you are associate managing partner, and you are the managing partner after 10 years or starting your own practice. That time, what is important, sir? Sir, the most important, sir, which I am thinking about that. Like Mr. Dubey said, there's a PMLA offense, you are not going to get a bail. There's a divorce matter, you are not getting the divorce. In the financial transaction, IVC matter, you are not going to, because if somebody is going to liquidation, other side will say he's not a right liquidator, he is not doing this thing. You will go to the bail matters, the judge is not giving me proper opportunity, you are losing the matter. Business transactions matter, you are said there's a not correctly structuring in the matter. Law firm is not good, go to the second law firm is said, no, there's a 3, 5, 6, 5, 6, 7 lacunas in the drafting. Now I'll go to the better drafting with the better lawyers. And the end of the you are in some of the best law firms, best lawyers, best court, and you are losing the matter. What is this? These are the challenges? No, these are not the challenges. Because in courts, there's a very less chance दोनों पार्टीज जीतेंगी. देयर इज अ वन चांस. जिस मैटर में मैं आया, ये भारत के इतिहास का वो मैटर था जहाँ 10,000 टीचर रीइंस्टेट हुए, जहाँ 10,000 टीचर रिलोकेट हुए, जहाँ उसके बाद जो मिठाइयाँ थी सर, दैट फीस इज द वन पार्ट, स्वीट्स इज द सेकंड पार्ट, रिस्पेक्ट, और रिस्पेक्ट के बाद दैट फीलिंग इन सुप्रीम कोर्ट देयर आर 5,000 पीपल स्टैंडिंग आउट ऑफ द कोर्ट कि हम मैटर जीत गए. हुआ क्या? सुप्रीम कोर्ट में न्याय मिल गया. दैट न्याय वाज द नेचुरल जस्टिस. देयर इज नो लॉ, no law, no act, no principle who they are supporting. They said this should be done. Now come to the second, which is the most other very important aspect regarding the submissions, regarding communication, regarding the interaction with the foreign clients. Yesterday, Mr. Modi, our Prime Minister, visited to United States of America. His words was very important. Tesla se kaha, jo baat chal rahi thi, aap India aiye. The credentials of the Prime Minister, then credentials of the law firm, credentials of the Indian lawyer. Just Mr. Harish Salve argued Kulbhushan Jadhav matter before the International Court of Justice. They said, we are giving you the access. Same Shah Rukh Khan's son's matter, Mukul Rohatgi, same bail petition, same argument, same court, he secured the bail. Salman Khan matter, he secured the bail. That time, Harish Salve lost that matter. This is the Italy, both one of the different issue which I'm not going to get it. That time your reputation, that there's no challenge. If you have a very highest root of the reputation, point one, best clients, best advice, best submissions, best preparation, best talents. Best talents means continuously reputation of 10, 12, 13, 14, 16 years. No, there's reputation build, minimum build within 10 years of time. After 10 years, you will get 20 years of time and 30 years of time. Now, come to the last aspect, which is also very important. And Anurag, there was a very close, there's a very poised submissions, and there's a very precious and there's a very holy submissions which is discussed between the Bhagwan Shri Krishna, Lord Shri Krishna and Duryodhan. और वो सबमिशंस जो है सर, वो भारत के इतिहास का वन ऑफ द फाइनेस्ट सबमिशंस, क्योंकि सुप्रीम कोर्ट की जो लाइंस हैं वो लाइंस वो कहती हैं सत्य की जीत होती है, सत्यमेव जयते। सत्यमेव जयते इज द कोड, वन ऑफ द वर्ड जो हमेशा ट्रस्ट करते हैं। लॉ फर्म्स को हम ट्रस्ट करते हैं आफ्टर 10 years, आफ्टर 50 years। कोई नहीं जानता शशांक वाजपेयी कोई लॉयर थे। 50 years बैक कोई नहीं जानता MC शीतल वाज द फर्स्ट चेयरमैन ऑफ द बार काउंसिल ऑफ इंडिया। बट दैट कम्युनिकेशन जो उन्होंने लिखा था, आई एम गोइंग टू रीड इट एज सिंपलेस्ट, जो रामधारी सिंह दिनकर का कोट करने के बाद, क्योंकि आज जिस धरती पे हम बैठे हैं, जिस धरती पे वी आर डिस्कसिंग दीज चैलेंजेस ऑफ द लॉ फर्म्स, वन ऑफ द लार्जेस्ट पॉपुलेशन इन द वर्ल्ड, वी आर आस्किंग, जहाँ पे दुनिया की सबसे बड़ी डायनेस्टीज रही हैं, डायनेस्टीज ने राज किया है, और सेंट्रल विस्टा बनने के बाद हम एक 8वीं नई डायनेस्टी जो एक पूरी दुनिया की लॉ फर्म्स के लीगल ट्रेंड्स को चेंज करने वाली है। ओवर क्राउडेड कोर्ट्स को रिड्यूस होंगे, पार्लियामेंट की स्ट्रेंथ को थोड़ा सा रिड्यूस करेंगे। नाउ दैट हस्तिनापुर में जो कम्युनिकेशन हुआ है पांडवों के बीच में, वो कम्युनिकेशन हुआ है दुर्योधन के बीच में, वो कम्युनिकेशन हुआ है भगवान श्री कृष्ण के बीच में। भगवान श्री कृष्ण का वो कम्युनिकेशन था, भगवान हस्तिनापुर आए हैं, पांडवों का संदेश लाए हैं, न्याय दो तो आधा दो, कम्युनिकेशन दोनों लोग कर रहे हैं। पर इसमें भी यदि बाधा हो तो केवल दे दो केवल 5 गांव और रखो अपनी धरती तमाम, हम वहीं खुशी से खाएंगे, परिजन पर असी ना उठाएंगे। दुर्योधन वह भी दे ना सका, आशीष समाज की ले ना सका, उल्टा हरि को बांधने चला, जो था असाध उसे साधने चला। जब नाश मनुष्य पर छाता है तो पहले विवेक मर जाता है। डगमग डगमग दिग्गज बोले, भगवान कुपित होकर बोले, आ केशव बांध मुझे, जो है असाध्य उसे साध उसे। दैट टाइम ही इज गिविंग वन ऑफ द फाइनेस्ट ऑफर। आप क्या चाहते हो? हमें हस्तिनापुर नहीं, आप क्या चाहते हो? हमें 5 गांव चाहिए सेटलमेंटली, दैट्स द पार्ट ऑफ द सेटलमेंट। द रोल ऑफ द लॉ फर्म, चैलेंजिंग एस्पेक्ट्स ऑफ द लॉ फर्म इज वेरी इंपॉर्टेंट, कि आपको सेटलमेंट, reduce the litigation, reduce the communication, reduce the pendency of the litigation, trend of the arbitration is also very important, mediation is very important, and role of the lawyer is very important. Anurag ji, day for yesterday, because every day we are dealing with matrimonial matters, there's a one of the oldest matter we have handled, that's a different thing. Yesterday I was reading, sir, one of the very important newspaper, 2 headlines were there. Headlines was there, एक India का one of the lawyer who is staying in the, sir, Ahmedabad, उसने ये कहा कि अगर आप शादी करेंगे और शादी करने के बाद तलाक लेंगे, मैं आपके केस की फीस चार्ज करूंगा, बट तलाक लेते लेते अगर मामला सेटल कर लेंगे तो मैं फीस नहीं लूंगा आपसे, और वो केस में फ्री लड़ूंगा। तो उन्होंने साहब 138 केस लड़े, 138, जिसमें दोनों पार्टीज दोबारा डाइवोर्स के बाद मैटर सेटल्ड हो गए। 38 केस लड़ने के बाद घर में इतनी लड़ाई हो गई हस्बैंड वाइफ में कि तुम सारे केस फ्री लड़ते हो, हमारा घर नहीं चल रहा है, और उन वकील साहब का स्वयं तलाक हो गया। ये जब आप कहीं ना कहीं, दैट दिस इज द ट्रू स्टोरी, कि हमने अपने घर बचाने के लिए पैसे बचाए और हमारा घर ही खुद चल गया। लॉ फर्म्स चलाई, इस्टेब्लिशमेंट बनाया, बिगेस्ट चीज़ें बनाई, बड़ी लॉ फर्म आई और छोटी लॉ फर्म को सेकंड टियर 4 टियर 3 को खत्म कर दिया कि इसको क्लाइंट नहीं मिलना चाहिए, इसको चीज़ नहीं होना चाहिए। तो व्हाट वी वांट, जस्टिस इकबाल इज देयर, आई एम सेड अगेन आई एम रिक्वेस्ट टेलिंग दिस थिंग, कि फर्म में इकबाल है तो फर्म चलेगी आपको। तो उस लाइन के ऊपर आज जो लेटेस्ट लॉ फर्म्स हैं, न्यू लॉ फर्म्स हैं, बड़ी लॉ फर्म्स, उनको प्रमोट करना चाहिए, कुछ क्लाइंट्स रेफर्स करने चाहिए, यंगस्टर्स को प्रमोट करना चाहिए, अपॉर्चुनिटीज देनी चाहिए। और अपॉर्चुनिटीज में लीगल प्रोफेशन इज द ओनली प्रोफेशन इन द वर्ल्ड वेयर यू कैन मीट एनी लॉयर विदाउट हेजिटेशन, यू कैन रिक्वेस्ट फॉर द इंटर्नशिप, यू कैन रिक्वेस्ट फॉर द जॉब, यू कैन रिक्वेस्ट फॉर द केसेस, you can request to giving these keynote addresses ki I am one of the council, you should give me opportunity, I'll come and address the gathering, other media will give you the access of that challenge may be removed. They're the fraternity which is the most friendly fraternity in the world, the legal fraternity. You are the lawyer, you are going before any international court, everybody will appreciate you because you are a lawyer, Indian lawyer, it's all right, I'm giving the opportunity, I'm giving the work, I'm giving the shelter, I'm giving the clients. within a span of 5, 10, 20, 20 and 15 years, you are going to get the you may be established one of the finest law firms. क्योंकि आज जो US based law firms हैं, American based law firms, American based law firm है, Dubai based law firms हैं, Indonesia based law firms हैं. They are the managing partners, the owners, the chairmen, the co-partners, the associate partners, maximum Indians हैं. Point. Second, international arbitration का आने वाला इंडियन हब जो होगा वो इंडिया का हब होगा. The role and the challenges of the law firm is very, very and very big. Very big. They need most competent lawyers, most competent advice, one of the best infrastructure, and I'm with the greatest proud we are saying this thing. After maybe within 5 years or within 10 years, India will be the hub of the arbitration. India will be hub of the litigation. India will be hub of the international law firms and the finest law firms. जो आज के 5 या साल बाद जैसे मिस्टर श्रॉफ आज चीजों को देख रहे हैं और चला रहे हैं, I can assure you, after 5 years, एक देश की finest law firms वो होंगी, वो Indian law firms दुनिया पर रूल कर रही होंगी और best law firms होंगी. इन्हीं के साथ I'll conclude my lines and say thanks, Mr. Anurag ji, giving me one of the finest and best opportunities. Thank you so much. Namaskar. Jai Hind, Jai Bharat. Thank you.
Do you see any change in the, in the way, currently the way things are stacked up? कुछ changes होने वाले हैं to be able to make it a little more equitable. I don't know what is the right word to use, but maybe more fair, because right now it's stacked up against the accused.
Anurag, in the accused side, I say I don't want to go in the PMLA side because a lot of the PML matter I am appearing and addressing before the other side also. That is the main reason I don't want to say on that part. Now there are 2, 3 which is very, very, I don't want to mention that thing with the role of the policies. What is the poll when it comes to Mr. Lalit, who is the most eminent and prominent lawyer in international community? Everybody is aware. Sir is here. Ki international law firm, Mr. Lalit is there. Lalit is the body. Sir is the body. Sir is the institution. Ki hum aaj baithe hue hain, to puri duniya mein Indian law firms, Mr. Lalit is there. So the changes, there are the 2, 3 very important things. This is a collegium system is a one. Secondly, empanelments of the empanelment of the lawyers in the state level, high court level, Supreme Court level, and the law officers level. The criteria कि मैं ये जानता हूँ, he is the finest lawyer. He is the finest lawyer, and the finest lawyer, he is handling these kinds of matter. There's no particular training. There's because that time somebody is in that age. You are changing yourself, you are switching your practice to one court to another court, district court to high court to Supreme Court and other places. Most welcome, Shri Lakshmi Narayan Saab, the former Home Secretary Government of India. I'll request to each and everyone to give a big applause. Within a span of, I hope within a span of 1.5 years, we are going to change. There's a lot of jurisprudential and legal change is going to be taken by this court and the apex court level, because there are a lot of new orders and appeals are pending. We are expecting the different, because Mr. Batra has already said so many times, Mr. Dubey ji said कि सब बेल बड़ा कठिन हो गया है, वो बेल मिलने लगेगी मुझे लगता है थोड़े समय में, predictive offenses में भी, SFIO offenses में भी, और at the end of the day everybody is rushing to the big law firms. They are saying, okay, hire the good law firm, hire the good lawyer, come to the Supreme Court, you will ensure you will get a bail. That time some of the lawyers, they said यार मुझे bail नहीं मिलती है, because this practice also changed by the Honorable Justice D.Y. Chenchur. There is the latest matter. They said the bail was granted by the district court, high court checked that high court quashed that bail order. They said come to the Supreme Court and they restored that original order which is passed by the district court. They said no, if bail is granted by the one of the court, the word subordinate is also replaced. They are saying there is a judiciary. There is no subordinate judiciary. There is a lower judiciary, higher judiciary, and super higher judiciary is apex court level. So Anurag ji, changes हैं और बहुत जल्दी बहुत ज़्यादा बड़े changes in the month of July onward. आपको इंडिया में आएंगे, the total Supreme Court is totally reformed, changed, and the technology wise they are changed. I mean, Government of India has also already allocated the budget of 7,000 crore for the e-court level. Each and every step you are going to change, and we'll feel there's a changes, because the latest lot, जो Justice Chanchud ने latestly we have here heard 2-3 places, कि district level judiciary, they are giving one of the finest judges who are coming. जैसे भी राजस्थान जुडिशरी हुआ सर, 80% प्लस वाज क्वालिफाइड एज ए लेडीज जजेस जो वहां पे क्वालिफाई होके आई हैं. यंग टैलेंट्स दे आर कमिंग इन द डिस्ट्रिक्ट कोर्ट लेवल. दे वांट द बेटर इंफ्रास्ट्रक्चर, बेटर quality of work, committed judiciary, more responsible judiciary, vibrant judiciary. So there is the probability, without fear, you are getting one of the finest order and finest changes within a short span of time. Thank you so much, Mr. Anurag. Thank you for giving me the opportunity. Thank you so much.
Thank you, Mr. Bajpai. Ladies and gentlemen, for his address, please welcome Mr. Mohit Saraf, Managing Partner, Saraf and Partners.
Justice Ansari, Mr. Bhasin, Mr. Lakshmi Narayan, and Mr. Dr. Batra. When I was thinking about today afternoon, what should I be speaking? I really thought, and help me with the technology, how to move pages. This is the way? Okay, thank you. Okay, sorry, how, this is the move back? This is to go back? Okay. And this is to move forward. Yes. I'm 55-year-old, so not very technology savvy, but I'm going to talk about a little bit, and Justice Lokur is also here. So let me restart. Justice Lokur, Justice Ansari, Lalit Bhasin, Mr. Lalit Bhasin, Mr. Lakshmi Kumaran, and Dr. Anurag Batra. When today morning I was thinking about what we should be speaking, I think really for me was to think about everybody in the room, how our future is going to be for next 10 years. Because everybody comes and talks about long term, which is 30 years. We don't know that. Well, most of us will be dead and gone. So let me talk about only 10 years. And when I look back, what I'm trying to do is I'm going to look back last 20 years. How did the economy do and how did the legal profession do? And it will be relevant for in-house counsel. It will be relevant for young associates of law firm, independent practitioners, arbitrators, retired judge, present judge, policymakers. I think that's the way I was thinking about it. And this is really a little bit about economics. If you look at 2000, and I'm talking about last 20 years. If you look at last 20 years, the basically our economy, the size of economy was $500 billion in 2000. In 20 years, we have gone down, we have multiplied by 7 times. Today we are $3.5 trillion, very important. So economy moved up by 7 times in last 20 years. But per capita income moved only by 5 times. Now, typically in a poor country, per capita moves higher because productivity level goes up, because poor makes more money. It's difficult for rich to make more money. That's the typical thing. But actually, if you see last 20 years, we did not create enabling environment for people to produce more. That's an important thing. And once you cross, if you see our per capita was $440, which is very bare minimum, till we got to 1 lakh rupees a month, which is a $1,500 per capita. Virtually, there was a very little correlation between lawyers and economics, because that is a subsistence economy. But once we crossed $1,500 and moved up, there was a significant correlation between economics, well-being, and legal profession. And I want to talk about that. Just look at this. If we, in last 10 years, the respect for legal profession, particularly in 7-8 years, I would say it has moved tremendously. People are comparing lawyer's job to a doctor's job, an engineer's job, and sometimes even preferring. When I was doing law, and I did law because I came to Delhi to become a civil servant. And when I qualified civil services and I took in one of the lower level job, and I was supposed to take it back, and then I started working as a lawyer. And I thought that I will not go back to civil services. My parents virtually fell off. He said, this is the worst decision in your life. Everybody who's incompetent should be a lawyer. And you are reasonably competent. So really, that is what has changed in the last 7 years, 8 years, dramatic changes. If you look at lawyers' compensation, I remember my time when I used to get 1,200 rupees a month when I started legal profession. And today, even if you multiply by 20 times, lawyers make tremendous amount of money. If you see Justice Chandrachud's idea about paying interns money, that clearly shows that legal profession has moved a long way. If you see the legal law firm growth in last 7-8 years, particularly, most law firms have doubled the size because the economy moved up. Remember, $0.5 trillion to $3.5 trillion, and $1 trillion we added in last 5 years. That's a big thing. And that's the reason there is a lot of writing on the wall for next 10 years. If you look at really, when I started working as a lawyer in early 2000, all the business related legal work, I'll deal only with CFO. And basically the general counsel was looking at litigation work. Today, the general counsel office runs the show, both for business, both for integration, and that is what has changed. So it has changed all over the world. And today, lawyers get involved not just on litigation and arbitration, but on strategy, on business growth. And that's a tremendous change which is happening. Now look at this, which is very important. Everybody knows that India is growing at 6-7%. Now you add inflation, then it gets to 10%. So really, if we are going at 10%, today $3.5 trillion economy is getting to $10 trillion. Imagine $10 trillion, 3 times this in next 10-12 years. Imagine the opportunity in front of us. This is the opportunity. And globally, if you look at it, earlier 20 years back, because our productivity level was very low, we used to invest $1.50 to grow $1. Today, we invest 55 cents and grow $1. That is how it has increased. So to increase our GDP from $3.5 trillion to $10 trillion, we will be investing $3.5 trillion in next 10 years. Imagine arbitration, imagine litigation, imagine regulatory work, competition work. It is going to be mind-boggling. This is an opportunity, but bigger is a challenge. And I will talk a little bit about why we have reached here. This is an important part. I'm talking about government policy and law. I'll talk about both these things so that you get a little bit better picture. So if you see today, the government has focused on productivity a lot in last 10 years. Infrastructure, road infrastructure, ports, airports, irrigation, a lot of things have happened. And therefore, the lower per capita is moving. So now the per capita is actually the key focus of growth, not adding people. And that is tremendous. If you see today, we don't have a good infrastructure, but we have social connectivity across. Today, you would be surprised to know that the smartphone in India is more than the cumulative smartphone in US and Japan, in US and China put together. Smartphone in India is more than US and China put together. 76% of our GDP is through transactions through net. Can you imagine? Did we ever think of 10 years back this is going to happen? So this is a tremendous thing which has happened. Now look at this part, which is the next part. So, and therefore we should know what we are really heading towards as a lawyer, as a legal community. Corporate tax virtually lowest in the world. If you're setting up new factories, you're only paying 15%. So you are making industry competitive in India. That's the reason why Apple is here. That's the reason why they're shipping. If you see the US, welcome to the Prime Minister, leave Prime Minister and leave his policies and other things. But just by the sheer fact, why is he getting so much of welcome is because India makes a lot of sense for US multinationals today. It did not make 20 years back. IBC, just see the credit uplift in the market. It's crazy. The growth in banking sector is crazy. That's how the whole thing will change. Same is because of RERA, the housing uplift is going to, foreign direct investment is all-time high. And if you today look at the foreign reserves, we are at a 600 billion. That was our GDP in 2020. 2000. Today we are a foreign exchange reserve of all-time high at 6. This is what is dramatically changing. Now look at what have we done as lawyers, legal system. We have done a lot of things. And I think that's an important part, that we've removed hundreds of outdated laws. We have tried to decriminalize civil offenses, which was part of Companies Act. I was quite active with the FICCI on working on that. We amended a lot of new old acts. We have brought new acts. The present justice has worked in filling on all vacancies. I think a virtual hearing is possible. So a lot of things we have done. And that's a very positive thing. Now see this. I think I'll take you back and say, in this situation, when we were all doing that, because of the changes on economic policies, on ease of doing business, in 2014, we were 142 out of a nation of 190. In 2019, we have moved from 142 to 63. That is a tremendous jump. 142 to 63 in 5 years. Now look at what we have done here. But on enforcement of contract, remember we talked about a lot of good things we have done in law. On enforcement of contract, in 2015, we were 186 out of 192 nation, really bottom 6. And today, we are 163 out of 192 nation. Not done enough. And this is really an opportunity for everybody in the room. And also this is a big challenge because we can stop the growth of the country. We have an ability where people will not put money in this country because they cannot get justice. Justice delayed is justice denied. I think we've heard it all our life. And therefore, anytime you delay, you're making sure poor stays poor. So this is an important thing. When economy, remember, the economy goes to $2,500 per capita and $3.5 trillion GDP. When economy triples, which is next 10 years, the legal work will go up by 4 to 6 times. Today we are collapsing. Imagine in next 10 years, if the legal work is going 4 to 6 times, what an opportunity. I think what I did in 55 years of my life, a lot of you can do it at 45 years or 40 years, because just by the sheer opportunity in front of you. And this is what we have to, because when economy doubles growth, you will have more transactions, more litigation, more arbitration, and these are various things will happen. So this is a big opportunity. I think what is important is for all of us to understand, because if we don't understand, when I told my dad is a very anti-present government. So I told him that, Papa, you criticize, in India, we have done 7 times GDP in last 20 years. He said, I don't believe. That's all. So what I'm trying to say is these are numbers and how we have added. If the currency in India had not depreciated because of Fed, we would have been much at $4 trillion. We are depressed by $500 billion because the currency depreciated. So this is a very, very important part. Just to look at the next point. So really what is important is, therefore, there is a requirement from every stakeholder to make sure that we are able to deliver. So I think the first most important thing is on the policymakers, on the lawmakers, because this is a demand side, because corporates, litigants should not use courts and legal system to buy time. And I think for that, most important thing is that Indian Contract Act, the damages has to be changed. Because today, even if you have intentionally breached a contract, the court will give you only reasonable damage. Remember, if a court has to give a reasonable damage, why will it not breach? Even if there is an intentional breach, even if there is a payment due, a damage is paid and he's appealed against it for 4 years, but interest is not paid as a right. It's a discretionary, and rate of interest is discretionary. So it's a very, very important thing. And I think I was at an India Today conference where they were putting a lot of questions to Dr. Chandrachud about speedier adjudication of cases. But I think this is a policymaker issue. This is not a lawyer's issue, not a judge's issue. Because if your courts allow people to litigate frivolously, and you remember, lawyers don't have a public duty. We are only married to our clients, unlike an auditor. If that is the case, then obviously somebody will abuse. And if that is the case, then if you really want the $10 trillion the economy to grow, then you better do the changes in the law. And this is an important thing, changes in damages, making sure interest is compulsory. And remember, I was taking a session at National Judicial Academy, and which was attended by 35 sitting High Court judges. And I told them the maths of dishonest in India. They were very surprised. I said, I work with corporates in India, and I can tell you, India, you make more money by being dishonest. He said, what are you talking? Mr. Saraf, I don't agree. And I said, okay, I'll explain you the maths of being dishonest. If I'm a corporate, if I have to pay another corporate 100 crore rupees, I will create frivolous litigation and arbitration and appeal. And World Bank says that it takes 4.25 years for a case to get resolved at the first instance. So in India, it takes 1,445 days for a court case to get resolved versus Sri Lanka versus Singapore, where it takes 165 days. 165 days versus 1,445 days. And the cost of litigation is 31 cents to $1. So if I have to pay somebody 100 crore, I litigate. So I buy 4 years of time. Now, typical cost of capital for a corporate is 14%, 12%. Even if it's 12%, so I save interest of 60 crore, 48 plus interest on interest. So I save 60 crore interest. And what I do, 3.5 years later, I go to the other side and say, I agree, my lawyers are telling me we don't have a very good case. Why don't you take 95 crores and settle it? So really, I made 50 crores. This is the best business to be in. And this is because our law supports this. And often our judges get swayed in India by who appears for them. And that's an important part. And it's a very important, the Penta test, if you look at today, the court said that you cannot read implied terms of contract. The Indian Contract Act, we are a common law country. Whatever said and done, we have to enforce contract the way it is written. But we end up, lawyers always are talking about reasonableness on every aspect, where the Indian Contract Act and the common law does not provide that. So I think this is the supply side. This is what the Chief Justice is doing, better case management, appointment of better quality judges, regular training, all these things are being done. So you can, when you get the case, you can manage it fast. If you remember, Malaysia used to be as bad as India, but they got a COO to run the court system under the superintendence of the Chief Justice, and that improved. So you get a technology officer to run, and that's an important part to think about. So this is from a supply side. This is very important. What really today, I think I heard the previous speaker talking about India will become hub for international arbitration. Forget about international. If we are going from $3.5 trillion to $10 trillion, our domestic arbitration is way too much. If we can handle that, I think we are home and dry. Forget about all these international things. These are all political stories. Domestic, we can't today handle. I think today corporates are very disappointed with the Indian arbitration. Because firstly, you have ad hoc arbitration. Arbitration, there's a lot of delay, court interferes. You don't have specialized arbitration tribunals. This for EPC contract, this for disputes, or the shareholder dispute, a lot of these things, which will actually help the process. Limited arbitrator pools. This is again a very important thing, because very limited. Today, I think this entire thing is by retired judges, and it needs to be expanded. A lot of cost inefficiency and enforcement challenge. So I would say today, if we are moving, remember, we are talking about arbitration pool to go to 6 times in next 10 years. And therefore, if we are collapsing with the present level, then you can imagine how we will face in next 10 years. This is a very important thing. And now this is very important. I think today, this is very relevant for each one in the room. A lot of people talk about artificial intelligence. And I was in the US and talking to a lot of people, and people believe that artificial intelligence will come and take our job away. I think that's an important thing. And therefore, I thought I must talk about it. As per Deloitte, they say 100,000, which is a lack of legal job, will be taken over by artificial intelligence by 2036. I believe it will be done by 2030, not 2036. So really, I'm much more optimistic. Today, artificial intelligence can do a lot of these things. But what they can, important thing is the fourth one. They can actually do predictive analysis. So they will look at the case law and say how this will be. Now, this is very easy to do in foreign countries where the law is well drafted. Today, if you see on the same point of law, different courts can take different view because the law is so poorly drafted. And therefore, this predictive analysis probably may not work in India because everybody can argue differently and courts are inconsistent on the view they take. So I would say this is a very important aspect we have to understand, but I think this is more important. Key challenges for law firm, really. I think we all have pressure on fees from outside counsels, from GCs. If you actually start using artificial intelligence, what has really changed? A lot of time, artificial intelligence was used by big law firms, global law firms, but was not available to smaller law firms. This is changing dramatically. Now, today, ChatGPT is available to all of you. So that is a big game changer. So small can become big. Earlier, a big had to stay big because he had advantage of productivity. Today, that is dramatically changing. So therefore, there will be a lot of pressure on fees. Now, if there is a pressure on fees, how do you handle this pressure? By adopting artificial intelligence. Same thing is, there is a talent retention issue. There's my young firm, I'm the oldest, and there's a lot of burnout issues. Now, how do you handle that? Making sure whatever can be done by machine, because this is not a Google machine. Remember that. This is a thinking machine. And every time you ask a question, today in corporates in the US, the most important thing they check is how intelligent you are on computers. If you are very good MBA, but you are bad on computers, they will not hire you. Because they told me, the CEO told me that this man will be obsolete in 5 years. So you need to be technology savvy. That's very important and challenging for my generation. And if you are, then a lot of your job can be done by machine, but you have to keep in control. You have to control. You have to see today, you cannot imagine what ChatGPT can do. And this is a thing where a new firm can grow up to a different level using this. We can handle the pressure of fees from GCs, and we can handle talent retention. And this is the most important part which we need to understand. We should not, in countries like US, if the economy is not growing, they should be worried about ChatGPT and artificial intelligence. In India, when we are growing like this, and we are going to go 6 times, I think this is a blessing in disguise for us. Otherwise, we will collapse. Then I'm just at the last bit. Now, this is the key challenges for in-house. Because today, if you look at every in-house company, the companies are expanding from technology. Now they are doing cement, they're doing everything. If you see Ultratech, you look at the group, they're doing finance company, they're growing. So therefore, more and more business, more and more complexity is falling on GC's table. And this is increasing workflow, growth alignment with legal requirement, because if business wants growth at all costs, but a GC cannot allow growth at all costs. He has to make sure you behave, you are comfortable on ethics, and you have to comfortable on growth, and which is sustainable growth. Risk management is a big important issue. Talent acquisition, again, burnout, similar issues. So AI is going to be a very important, and by that, legal cost can also be checked internally and externally. So I think this is an important thing. What got us here till $3.5 trillion won't get us to $10 trillion. I think, guys, we have to understand. And therefore, some of us in this room will make best use of this opportunity, and others will sit on the side and say they were not connected. And I think that is what important is, that if you have such an opportunity, and this opportunity always happens in every nation history once in lifetime. And this is that lifetime for us. When you are moving from a 2,500 per capita to $5,000 per capita in next 10 years. So this is a great opportunity. $3.5 trillion will be invested in next 10 years. $7 trillion GDP will be added. The per capita will more than double. And therefore, in my view, we need to be, I think everybody, whether it's policymakers, whether it's the court system, whether it's arbitration, whether it's lawyers, law firm, everybody have a very big role to play. And then with that, I come to an end. Thank you very much.
You have referred to the possibility of the legal work increasing by about 4 to 6 times. When you talk of legal work, are you talking of litigation and disputes, or you are talking about transactional work and corporate work? It will be a very sad day if we see multiple increase in disputes, either by way of litigation or arbitration, because I don't see end of the road so far as litigation is concerned, or even arbitration is concerned, because arbitration has failed, you see, to take off in India, despite the lip service that we have been, you see, giving to the cause of arbitration. So are you talking, you see, or are you saying that litigation will increase? Because what about then enforcement, you see? What about the disposal? Our Honorable Chief Justice says that digitization, technology, you see, that will improve the functioning of the courts. I beg to differ. It will facilitate filing of the, you see, document, petitions and all that. It will not, you see, result in disposal. For disposal, you don't need artificial intelligence. You need real intelligence, which is only here. So I don't understand, you see, these observations.
I'll tell you one thing. In my personal view, the dispute, the arbitration, the M&A, the due diligence, the financing document, the capital market, everything will increase 6 times. Now, what I said was, if we bring substantive changes in law, where you do not get benefit by litigating, lot of these things that you can manage the supply side of issue, that people will not litigate. Today, when my clients call me, they show me the matter and they are fighting a case in the US. I tell them, sir, sir, kapde utar jayenge. Ye matter bada mushkil hai. Wahan pe judge will get against you. He said, okay, wahan settle karo. India mein koi fark nahi padta, sir. Don't worry, Mohit, don't worry. I'll handle it. If there was a case when it was illegal to draw on the bank guarantee, the chairman called me. He said, Mohit, we need this money today. I know it's illegal. We'll draw on it. Then I will fly down, talk to the chairman and give the money back when I have the money. Don't worry, but I need the money. Why do you do that? Because we are taking the judiciary and the legal system for granted, and we benefit out of being dishonest in this country. That's the reason. So you will not agree, because everywhere there'll be litigation. In foreign country, it will get resolved quickly. In India, it will not get resolved because there's no incentive to resolve. I told you the maths. You make more money by being dishonest. I told the National Judicial Academy 35 judges that when I bring a senior advocate to the court, you get enamored, thinking itne महंगे lawyer ko leke aaye ho. You don't know how much they make because of this, because they buy time. Then you don't listen to the matter for 2 years, and they make money. So therefore, the system, the cases will increase, but unless there is on the cost benefit analysis, you lose money by appealing, or you lose money by taking dates, then only the thing will change. And therefore, this cannot be just done by Justice Chandrachud. He can do only management of the courts improve. If it has to be done by the policy maker, it has to be done by you and me. It has to be done by Justice Lokur and Justice Ansari. So everybody has a role to play. We all have to work, then only disposal. Otherwise, everybody will benefit. That is correct.
And as you said, that it will include litigation and non-litigation work as well. But what you are also saying is, and therefore the need is to augment the judicial infrastructure. That's what you're saying.
Judicial infrastructure, GC's infrastructure, arbitration infrastructure,
right,
and create an enabling environment for speedier disposal of cases.
Absolutely. So overall, the judicial infrastructure, the infrastructure needs to be created and augmented to support that 4 to 6 times of a growth. That's
Correct,
what you're saying.
correct.
Something even beyond the judicial structure, you see, that is required. And that is where you don't need a change in law. What is required is, I think, which has been missed out in many presentations made, is samjhauta, settlement, mediation. That is the only answer that India has.
Sir,
with 5 crore cases pending, which is official figure. If the filing is made easier, by use of technology, the disposal will be very scanty. This 5 crore will become 10 crore cases, and there is no future for arbitration because there are no arbitral institutions in this country. Only one small beginning has been made by setting up under Honorable Justice Hemant Gupta, but we have yet to see the results, you see, of that. Therefore, mediation is the answer. That requires a change in mindset. That mindset has to be created right from the law schools. That samjhauta, try to resolve the disputes. That is the heritage, panchayat, consensual form of justice.
So let me give you my little bit. Sir is a senior from my school, college, and I have learned a lot with sir, but I will beg to differ here. And I will tell you why I differ. Samjhauta only works in a place where if you do not compromise, you pay. Samjhauta only works in that jurisdiction if you are a litigant and you are falsely litigating, you will pay a huge price. Samjhauta does not make when you make more money by litigating. So therefore, in my view, mediation is a wrong idea in this country. Unless our judicial system improves, mediation always comes once the arbitration and the judiciary is moving full blast, and therefore people go for mediation. Today, people go to mediation only to buy time, because one guy has done something to the other and he's basically bought 2-3 months. So today we are not in the right environment. Mediation, and you cannot show me one country in the world where enforceability of contract is 183 out of 197 and mediation works. I think it is not going to happen in our lifetime. So therefore, these are good things to talk about. But remember, today dispute is business dispute. People are asking for money and paying money. So there's no question of samjhauta. They are all question is, what is beneficial to me? When clients ask me, the question they ask me is, what is the worst case? What is the best case? I say the best case is you make 50% IRR by delaying it. Oh, say, wow, this is the best country not to pay. So really samjhauta is not a right word. Once our enforceability of contract moves up from 183 to top 30, samjhauta will become an important thing. Thank you.
Thank you very much, Mr. Saraf. Ladies and gentlemen, we are delighted to seize this moment to inform you all about our upcoming significant event, the GC Conclave, scheduled for July 9. You will find the QR code for registration placed on your tabletops. Without any further ado, we would like to present a preview of the event. And now towards the much anticipated segment for the day, ladies and gentlemen, the Global Legal Leaders Awards 2022 to 2023. And to deliver the inaugural address, please welcome Dr. Anurag Batra, Chairman and Editor-in-Chief, BW Businessworld and Exchange for Media.
Good evening. It's my honor and privilege to welcome our chief guest, Justice Lokur, to the gathering. Please give Justice Lokur a big round of applause. Thank you for being here. Thank you for being part. It's my honor and privilege also to welcome our guest of honor, Mr. S. Lakshmi Narayananji, who's a retired IAS officer, but he's not retired at all. I can tell you that, whatever little I know about him. He's very active. He's on the boards of large companies, advisor to entrepreneurs, and he's very active in his pursuit of God. So I must welcome you, Mr. S. Lakshmi Narayanan. Both Justice Lokur and our guest of honor, Shri S. Lakshmi Narayananji, don't need an introduction. I have your formal introductions. I figured out you went to modern school, then you went to St. Stephen's, then you went to Allahabad. I figured out when's your birthday, 31st December. I won't give the year, right? And same for you, sir. But please give our chief guest and our guest of honor a bigger round of applause. They'll be handing out the award. I also have the good honor of welcoming Shri Justice Iqbal Ahmed Ansari ji, who's been the Chief Justice of the Patna High Court. He was a judge at the Guwahati High Court. And I would also like to use this opportunity to welcome Shri Lalit Bhasin ji, who is really a lighthouse. And he was jury chair of the 4th edition of the Global Legal Leaders Summit. He was there in the morning. See the passion he has for this domain, the emotion he has. He participates. Whenever he's there, he's full in. Even in the jury, he was running the jury. You know, he has a strong viewpoint on things, ideas. And we love involved jury members and jury chair. He's outside the room. I'm sure he'll be in. I'd also like to congratulate Mr. Mohit Saraf on a fantastic presentation. And, you know, you made me think, and, you know, I am a student of this profession. I know a bit about everything. I'm not a domain expert, but having done this for 4 years, I think, you know, your presentation made us think. And thank you, Mr. Bhasin. I was just acknowledging your contribution as the chair of the jury. So Shri Lalit Bhasin ji was our chair of the 4th jury. We also have Mr. Pramod Dubey, who's a senior advocate. We have Shri Shashank Bajpayee ji, who's also spoke, who was the founder of the Vardharma Chambers, leaders of the legal fraternity, all stakeholders, students, the winners of the 4th Global Legal Leaders Awards. I can only tell you at BW Businessworld and BW Legal World, all the awards are done through a jury process. I'm sure we'll see the jury and we'll acknowledge all the jury members. In the morning, since I was speaking on the changing role of law firms, and I have had an experience in litigation, and I have worked with 3 law firms broadly, maybe 4. And now with BW Legal World, I said, you know, like Mr. Saraf, I took a view on how the business is changing and hence the legal services, and you have really stalwarts from the domain. So I don't know what I'll add to your knowledge or your understanding, but I just did say that as business is changing and as the in-house legal departments of corporations and of the companies CRM, very importantly in the business context. $1 billion companies built in practice CRMs. But lifestyle management will be very important task in the law firms. Legal World is the homepage of General Counsel. Will also become very important or possibly more important than the General Counsel. So I just want to end there. I was thinking about the question Mr. Bhasin asked, the answer you gave. I was looking at the body language of the body language of the sorry. I can only say that the world has changed a lot since I was born, since you were born. I want to give you an example. In the last few days, one of the big events has been the Prime Minister's visit to the US, and it's been a successful one. The Americans rolled out the red carpet literally in every sense. And yes, you cannot ignore India. The Rosen event was the inclusion of the sky submersible. Around that time, 2 days before that, there was a boat which was going from Libya to Italy, carrying between 600 boat capsized hospital boat ground. Till last count, 51 bodies were already found and hundreds are presumed to be dead. There's also been some survivors, about 60 odd survivors. The count there. And I was thinking about the role of media. This is a fight, every life is important. Whether it's 1 life, 100 lives. The fact is there were 5 people in the submersible. There were 600 plus people on the boat. India is also my alpha. Just giving example from what I went through and I went back one is what is called what I there is like we are doing OND, we are doing UPI. If the government starts thinking in this segment, and leaders who every young person listens to, every professional listens, if we start thinking of legal services as a value of good, where like we built UPI, we built COVID, we're building ONDC, early days for ONDC. Says basically human beings are very kind, and we saw what happened in COVID. So I think while everything is a profession, everything is about making money today, but I think life is about making impact. It is about making relationships. It's also, you need money. I'm not saying you don't need money. When you run an organization, you do need money. But I think if you can be kind to each other, whether in your office, in your company, outside the office, to people you interact with. And I'm the recipient of a lot of kindness from a lot of people. And I really feel that. So I would recommend, I get no money from the sales of this book. I wish I did, but I must have gifted a lot of them. And I just want to end by saying that legal services as have India is producing the best minds. Our judiciary is among the best in the world. Their intent and heart are in the right place. Look at some of the judgments. There's a lot that can be, but I mean, you have to call a spade a spade. There's a lot that can be improved, but I think there is a lot to be celebrated. And tonight, when we award the legal services professionals, the leaders in law firms, the excellence has come through a jury route. It has come through, whatever Mr. Lalit Bhasin and the jury members have decided, that is what is being awarded. There's no other viewpoint. There's no editorial viewpoint. I mean, it's a process. We're only custodians of that process. Sometimes we may not agree with one or two names, not me, but people who have granularity on it. But we bought a process, we instituted a process, we stick with that process. So I just want to say, these are honest awards. Justice Lokur, we do not sell our awards. In every part of whatever we do, there are lots of things we do for commerce, we have to. But, I don't want to, and I also want to use this opportunity to show a small AV. And I would request if all of you can, after the AV, stand for 30 seconds, 20 seconds. And he was a tall leader in the legal profession. He died. He was at our events. I remember in the COVID, he was the first few I did a conversation with, and he was part of our inaugural cohort of the 40 under 40 jury. There was never a dull moment with him around. I mean, when we started BW Legal World, he did contribute in our growth. So I just want to take this opportunity to, to acknowledge Mr. Rajiv Luthra, who is in heavens there. And whatever, I say it from a good place. He was not like a friend that I would see daily. I would meet him 4 times a year, maybe 3 times at our events. But I do want to remember him today. I do want to express my gratitude, and whatever he's doing, I'm sure he's having a good time. And we do have a small AV that the team prepared to be able to. Can we have that AV? Very short. It's a very short.
I decided to my own. I did my law, 89, I finished it. I started with my law firm. I've never had a senior director and took small space in Ashoka Estate Park, where at that time most lawyers had their home, their offices at their home. And I said, if I have an officer of the law, I have nothing with them.
It'll be nice if you can stand up in his memory for 20, 30 seconds. Thank you so much. Thank you. Thank you and good evening. And, I'll give the podium back to Sahibjeet.
The Malaysian court had a CEO which could look at the operational issues. Actually came out of a report which was prepared by FICCI and which was headed by Justice Lokur. I only brought that point across.
Yes, I think it made.
So I'm not the author of that
Yes.
the idea. I just wanted to acknowledge that Justice Lokur and Justice Sikri were the author of the report. And because I'm very active with FICCI, I'd worked along with that.
Absolutely. And Mr. Saraf, in a short time, you have made an impact. I mean, you've been in the profession. I was listening and I was taking notes. And, it's a point that did appeal to me. I'm not an expert in law, but I thought it was a very good. Sir, I wasn't aware that you were chair of the committee that proposed that. So that is only serendipitous that that point has come in. Please give our chief guest and our guest of honors and our jury chair and Justice Ansari a big round of applause. Can you give? Clapping is good for heart muscles. Thank you so much.
Thank you very much, Dr. Batra. Ladies and gentlemen, we also have with us today our guest of honor. He has spent more than 30 years as a bureaucrat, as Joint Secretary and Additional Secretary in the new Ministry of Information Technology. He was instrumental in the setting up of Software Technology Parks, STPI, in India. He was also India's representative in the United Nations Affiliate World Intellectual Property Organization in Geneva for 5 years. Ladies and gentlemen, join me as I welcome our guest of honor, Shri S. Lakshmi Narayan, Secretary to Government of India, Ministry of Home Affairs, retired.
Respected Justice Lokur, Justice Qureshi, the organizer of today's conclave, Dr. Anurag Batra, respected members of the legal fraternity, ladies and gentlemen. It's a matter of great pleasure for me to have had this opportunity to be with you all, the elite of the brains in India. In our democracy, the strongest pillar and the pillar which sort of really upholds the democratic principles is the judiciary and the legal fraternity which services the judiciary. Even for our freedom movement, most of the people who were at the helm of leading the agitations were advocates, respected lawyers, and they were the founding fathers of our great country. I have seen, as an IAS officer for 38 years, that it is the judiciary which invariably comes to the rescue of the government whenever, whether it is a government or an administration, which is a government at the district level, is in deep problems. I would like to recall a small incident. I've been a district magistrate for 9 years, and I had a bitter time as district magistrate as Gwalior when the police were all unionized and the law enforcers were the people who broke the law. We used to have a small mela every year in Gwalior, and we found that on one occasion the police went and had, as usual, free halwas and free other things from a big Mishtan Bhandar which had set up shop there, and refused to pay, and there was an altercation, and the policemen had the audacity to throw the man who was on the sitting over the kadai or the place where these jalebis were made into the kadai itself, and the fellow died. And as a district magistrate, I was told by the SP, sir, there is a huge law and order situation. The man has died, and there are over 5,000 people crowd which is collected there, and the police itself is responsible for this. So I immediately rushed, and we found that because the police was unionized, they said that we can't take any action against the people who had been responsible for this murder. It was a murder because they just threw the chap who was the owner of the shop just because he demanded money into the frying pan, and he was burnt alive. So as a district magistrate, it's a very difficult decision. But because of the unionized police, even though I had a very good and a smart superintendent police, we decided that, okay, we'll arrest the people concerned and register all the charges as per the IPC, and we must immediately arrest them. The moment we arrested them, they burned the district magistrate's vehicle, which is my vehicle, and they bet up my ADM. They surrounded the SP and said, unless the men are released, they will beat him up. And because it is a police union, there was no other policeman loyal to even rescue their own superintendent police, who is the head of the police force. Any amount of my begging to them had no this thing whatsoever. And I spoke to my chief minister, who was a strong chief minister, Mr. Arjun Singh. And I said, sir, we need to sort of put an end to this union business of police. Police can't be having a union. And I have a situation where the SP is being beaten up by his own men. And we are not able to arrest the people who have killed a person. And on one side is 5,000 public demanding action. And on the other side, we are unable to take action because of this union baji. So anyway, I said, I've arrested. But they are not going to release the SP and the additional superintendent police till these fellows are bailed out. So you need to, sir, speak to, because it is not very easy for us to simply go and explain all this just like that. So please explain it to the Chief Justice of the Madhya Pradesh High Court and see that somehow instructions are given to buy temporary peace, because the Republic Day was on 26th, this happened on 22nd. So the Chief Minister was very keen we should not have a huge law and order problem or any kind of a situation. So there should be no firing, there should be nothing. So he just told me, somehow buy time and I will speak to the justice to bail them out. But we'll have to put an end to this unionism. So it is the judiciary which came to rescue. They gave bail on the specific instructions of the Chief Justice. At the same time, the Chief Justice extracted a promise that we should put an end to this union business the moment Republic Day is over. And true to the promise given to the judiciary, the BSF came to my rescue. We disarmed all the police armories and we dismissed 798 policemen. And they fought up to Supreme Court, and my hats off to the judiciary that the court upheld, because we removed all of them without any departmental inquiry, just saying that they no more enjoy the pleasure of the governor, because as law enforcers, they had themselves broken the law, and they were also ill-treating their own head of the force. And it's hats off to the judiciary. Up to Supreme Court, these guys lost. And the government had the guts for the first time to abolish unionism among police force. And I'm very happy till today the police is not unionized. Otherwise, as you can imagine, because you're all very senior luminaries from the legal profession, how the union leaders hold to ransom the industrialists in many industries, how some of these people who hold to ransom became chief ministers in states like Maharashtra, or their sons are chief ministers. And if the police itself is unionized, you can imagine what law and order we can sort of have in this country. It is the judiciary which came to the rescue when I saw as a young district magistrate. And when I rose up to the Home Secretary, I again found that government always, whenever they have to take a very unpopular decision, they would look up to the courts so that they can take the decision. And it is a matter of great pride that we have the best of judges in the world, in our Supreme Court, manning the judiciary, who have the guts of calling a spade, which most politicians don't have the guts. I've seen it as an executive officer of the IAS, that when it is a very unpleasant decision, or which is something which will affect their votes, they will not like to take a decision, but they would expect the court to take the decision. It's a matter of great pride for me that I am amid such eminent people like Justice Lokur and Qureshi and members of the legal fraternity. The members of the legal fraternities are like, if we can go back, as Mr. Dr. Anurag Batra said, I've been reading a lot about religion. If you have to make a request to Lord Shiva, even now people sort of will whisper into the ears of the Nandi. So if you have to get justice, you need the legal fraternity, and you need them to argue your case properly with the courts and get you justice. Now, whether it is merger and acquisitions, whether it is a question of facing the onslaught of the Enforcement Directorate or the CBI or anything else, we require advocates, we require legal luminaries, and as elaborated by Mr. Saraf, with a doyen in this field is wide open, and the chance and the opportunities are growing by geometrical progression as India grows. What we require is a very strong youngsters, a group of youngsters who can take up this profession, argue it well, and a judiciary which should be given the fullest support by the government in terms of staffing them, in terms of filling up the vacancies, and even the government should strongly consider having an Indian judicial service like the Indian Police Service and Indian Administrative Service, so that the brightest people through a competition come into the judiciary, even at the lower judiciary, and then they rise also along with the lateral entries from the legal profession in the various high courts and Supreme Courts. Well, with doyens of the legal fraternity and such eminent people like Justice Lokur, I would not like to further take your time by giving lecture on how important the legal fraternity and the judiciary is for this country. It is really the only pillar which is holding on our heads high and keeping up the democratic principles. And I'm sure with all these people here and the people who are going to join this fraternity, India's democracy is very safe and we're going to progress more and more. Thank you very much for giving me this opportunity. Jai Hind.
And now to felicitate Shri S. Lakshminarayanan, I would like to call on stage Dr. Anurag Batra. Moving ahead, we are joined by our chief guest. The gentleman is the judge at Supreme Court of Fiji and former judge of the Supreme Court of India. He has been a champion of social causes as a Supreme Court judge and is a constant commentator and a guiding light for the Indian jurisprudence. His judgments precede him, and we are honored to have him here with us today. Ladies and gentlemen, please welcome Justice Madan B. Lokur.
Good evening, everybody. Mr. Lakshmi Narayanan, Justice Ansari, a former colleague. We had a wonderful time in Guwahati. Dr. Anurag Batra, Dr. Lalit Bhasin, ladies and gentlemen. Let me first begin by congratulating all those who have got the awards for their excellence in the legal profession. Congratulations to all of you. I would also like to congratulate the chairman of the jury, Dr. Lalit Bhasin, for having made such a wonderful selection. I know it's a very difficult task. You know, you have to, it's difficult to balance whom to give, whom not to give, and why to give and why not to give. But you've done an excellent job in this. And of course, BW Legal World for organizing this wonderful event. It's been a long day for all of you, so I don't propose to take too much of time, but just to share a few thoughts. I would like to emphasize on one thing, which is simplicity. Mohit Saraf had mentioned about laws being complex. Dr. Lalit Bhasin also adverted to it to some extent. Yes, we do have a problem, you know, with simplicity. Our laws are complex. Some of the issues that arise are pretty complex. For example, data protection and so on. But yes, you know, we can certainly try and make our laws simpler so that there is uniformity in the laws, there is uniformity in understanding the laws, and also in the implementation of the laws. What happens is that if the law is complex, even lawyers find it difficult to understand what the law is, and they will give all kinds of interpretations. And the judges also get befuddled sometimes and come out with an interpretation which is not really what was the intention of the legislature. We've had this problem for many, many years in the Income Tax Act, for example, where different high courts have taken different views on the same section of the Income Tax Act, because there is a problem in drafting. Now, if you look at it from the commercial point of view, all of you are somehow or the other connected with the commercial world as lawyers. You will find that in contracts as well. You know, contracts have become voluminous. You have special conditions, you have general conditions, you have the contract itself, you have all kinds of addendum, you know, annexures, and so on and so forth. Now, one of the first principles that we were taught when we were studying law, and particularly the Contract Act, was that there has to be consensus ad idem. That was perhaps the first lesson that was taught to us in the law faculty. Now, if there is a meeting of minds, if everybody understands what the contract is all about, there can't be a dispute. And it's just a question of a breach of a contract. But because of the complex nature of the contracts that are drawn up, you know, we have all kinds of disputes. I remember when the Supreme Court decided to inaugurate the museum, they invited the high courts to give maybe one or two of, you know, something that they cherish as a part of the Supreme Court museum for about a month or two, and then maybe take it back. I remember the Bombay High Court had given a plaint which was drawn up for a breach of contract. The plaint was only one page. All that it said was in about 3 or 4 sentences. The plaintiff said that there was a contract entered into with the defendant for the supply of cotton, some 200 bales or something. The defendant has not supplied the 200 bales of cotton, and therefore I have filed this claim against him for damages. That's all. One page plaint. Today, it's impossible to have a plaint of that nature. You will have, facts, all kinds of facts. You will have arguments. You will have the law which is being cited. Plaints run into dozens and dozens of pages. So that simplicity is lost. And the result is that you get judgments, which are also very, very difficult to read. I mean, a 100-page judgment is something which is fairly common. Nobody reads them except law professors and persons who want to, make a critique of the judgment. You and I will probably just read some article written by somebody and say, well, this is what the judgment says, and proceed on that basis. I met a sitting judge of the Supreme Court sometime back, a couple of months ago, and he had gone to the Supreme Court of one of our friendly countries. And the judges over there told him, he saw, AIR and SCC and all that. So he was quite happy that, Indian judgments were being cited over there. And then one of the judges told him that, yes, we used to cite judgments of the Supreme Court, read them and incorporate them in our judgments, but we have stopped doing that. So he asked, why have you stopped doing it? So the judge said that you have stopped writing judgments, you started writing books. So nobody has time to read judgments which go into hundreds of pages. So again, that simplicity has got lost. And it was pointed out recently that when the judgment about Brexit came from the Supreme Court in England, a very, very important judgment, it was there in less than 24 pages. So that simplicity, I think, as lawyers, we need to inculcate that. We need to do it not for the benefit of lawyers. I mean, lawyers will make money if things are complex, but we need it for the benefit of the people, for the benefit of understanding what the law is, so that the law is clear, people understand it, the law enforcers understand it, and they don't misuse the law or abuse the law, and start putting people into jail for something which is frivolous and which obviously cannot stand legal scrutiny. So really, simplicity is one of the things I think that all of us as members of the legal profession, we need to try and inculcate. The second thing that I would like to mention to you, and this is from what Dr. Lalit Bhasin said about escalation in disputes, for example. The National Judicial Data Grid shows just 2 days ago that we crossed 50 million cases. Now that's a lot of cases. I don't think we'll be able to solve those cases, get a judgment in all of them in probably the lifetime of many people. I've had to deal with cases where it was a case of a mediation, by the way, where the third generation was fighting. And they went into mediation only because it was the third generation. They said, how long are we going to go on with this litigation? So really that mediation was compelled, was thrust upon them, because they said, my grandfather fought against your grandfather, and I don't want my children to go through all this. So really we have to think about, trying to bring about reforms in our justice delivery system so that we are able to get justice quickly. Why do we have witnesses turning hostile in criminal cases? Because they have to come to court over and over again. I remember when I was in the Delhi High Court, I received an email from an NGO to say that a 7-year-old girl had been raped, and she had come to the court 7 times for her statement to be recorded under Section 164 of the CRPC. Her father was a poor laborer, somebody who was a daily wager. So he had to miss 7 days of work, didn't get wages, obviously, for those 7 days. But look at the harassment. I mean, this girl came to the court 7 times. And the request in the email was that, can you please somehow or the other tell the magistrate to record her statement when she is produced tomorrow? I sent that email to my Chief Justice, and my Chief Justice sent it to the bench that was dealing with criminal cases. And they passed an order, a judicial order, saying that, listen, this can't go on. You can't have, a person coming for recording a statement 7 times. And every time, for some reason or the other, the matter gets postponed. The judge is busy, or the judge has no time, or something or the other. So these are issues, that we as legal professionals have to think about. We are there for the benefit of society. That is, I think, something that we have to understand. We often talk about lawyers who go to court and say, we are officers of the court. Yes, you're officers of the court, but you're also persons who are representing society. It is the state versus so-and-so. Now, if the state lawyer is not fair, if the state lawyer does not tell the court what are the correct facts, you're going to get a wrong decision. And who is going to suffer? It is our society that is going to suffer. So I think we have a higher duty than just to represent our client to the court, but also to represent society for the benefit of all of us. We don't come from a different stock. We all come from the same stock. I would like to share one experience that I had in Fiji. 2 experiences, actually. One was in August 2019. I wasn't on the bench, but one of the judges who was there on the bench told me this. The lawyer, by mistake, thought that the case was coming up tomorrow, but it was in the list for today. So she told the bench that, I'm sorry, I'm not ready. Can we have it tomorrow? Because I thought it was tomorrow. So the bench said, fine, we'll have it tomorrow. There's no difficulty about it, subject to certain conditions. And what were the conditions? The conditions were that the lawyer for the opposite side had come from New Zealand, right? So he has to stay 1 extra night in Fiji. So you have to pay for his hotel expenses. He was to go back to New Zealand today. He's had to cancel his ticket and buy a fresh ticket. Maybe there's some cancellation charges. Maybe the fresh ticket is at a slightly higher price. You have to pay that difference. Third, the lawyer had been engaged for today, but he has to stay back for tomorrow. So he's going to charge his client the fee for tomorrow also. So you have to pay that also as well. And there was some 4th condition. I don't remember what that 4th condition was. So subject to all these conditions, we'll take up the case tomorrow. And she had to agree. And whatever costs were imposed were paid. Now, the point that I want to make is that, adjournments are taken for the asking in India. You say, pet mein dard ho raha hai, sar mein dard ho raha hai, I got held up in a traffic jam, kindly grant an adjournment. And the court says, all right, adjourn it. Why? Because they've got a whole lot of cases, 100 cases, 200 cases, 300 cases. That's why we have 50 million, and the number is not going to come down if this is the attitude. Whereas in Fiji, you don't have any pendency at all. It's a small country, of course, with a very small population. But this is how they enforce discipline in the courts. The second incident that I would like to share with you, I was on the bench. That was in April this year. It was a criminal case. The lawyer had drafted the appeal, and he had taken 4 grounds. And over there, oral arguments are limited to 40 minutes each. So you have to read the case, from page 1 onwards up to the last page. So all of us on the bench had read the case. We'd read the grounds of appeal. We'd read all the judgments and all that. And I thought that ground number 1 was pretty good. He had taken only 4 grounds. Ground number 1 was pretty solid. And ground number 2, 3, 4 were okay. When the lawyer appeared, he said that I'm not pressing ground number 1, 2, and 4. I was a little surprised because I thought ground number 1 was pretty solid. He said, I'm only pressing ground number 3. And he gave the reason why he's not pressing ground number 1, 2, and 4. He said, these are the judgments that are, against me. Whereas in ground number 3, this is what I have to say. And he finished his submissions in 10 minutes. 40 minutes is allotted to him. He finished in 10 minutes, just pointed out that one judgment. This is the ground that I've taken. This is the judgment that I'm relying upon. And the counsel for the state is represented by the Attorney General. The counsel for the Attorney General said, I have nothing to say. So the case was over in 15 minutes, right? That is being not only an officer of the court, but an officer of or a representative of the society in a court. So I think these are things that, we have to learn from other jurisdictions. We have to learn from what is happening around the world. And then my last point, which is that we need to have this outreach. Yes, our lawyers are doing very well. Yes, our economy is doing very well. And as Mohit said, it's going to go on increasing. Work is going to go on increasing. But what is the contribution that we are making outside India? That is important. Again, in Fiji, you have good lawyers. They've appeared before me. But I can tell you very confidently that Indian lawyers are much, much better than the Fiji lawyers. What do? They get lawyers from New Zealand. They get lawyers from Australia to come and argue complex cases. We had a case about the sanctions that the United States has imposed on Russia. And a case was filed by one of the Russian oligarchs. They got a lawyer from Australia and lawyers from the United States had come. How many of us in India actually represent clients in neighboring countries? Forget about Pakistan, Bangladesh, Nepal, Sri Lanka. We are not in a position to go out and represent clients, even though we are far superior in our presentation of arguments, in our understanding of the law, and in placing a case before the court. But we are not invited outside on behalf of clients to present a case. We do have some excellent researchers who have done excellent work and are continuing to do excellent work, writing very good articles, writing books, showing the talent of our legal profession to the outside world. But yet there is this little bit that is missing. I got a call from the deputy prosecutor of the International Criminal Court. She asked me, she said that, can you recommend somebody from India, preferably, or if not from India, from the Pacific region, to be a lawyer with the International Criminal Court? So I told her, I said that, India is not a signatory to the International Criminal Court. So I'm not sure whether you would like somebody. She said, yes, I know India is not a signatory to the International Criminal Court, to the Rome Statute, but that doesn't matter. I would like to encourage lawyers from India. I would like to encourage lawyers from the Pacific region, Indo-Pacific region, South Asia, to expose themselves, because we are just flooded with European lawyers. We are flooded with American lawyers. We don't have anybody from this region. Can you recommend somebody? So I said, let me think about it. I'll talk to some people. There's no name that's coming, on the top of my head, but give me some time. So she said, fine. And I asked a lot of, judges. I asked a lot of lawyer friends. Can you think of somebody? And 2 or 3 months, this kind of an exercise went on, and I was not given a single name. Ultimately, one of my law researchers who is now doing a thesis in Germany, she told me that, yes, there is some person whom I can recommend. And an Indian, some young girl, I suggested her name to the deputy prosecutor. I don't know whether she got appointed eventually or not, but that talent is there, but we are not in a position to exploit it. We have award winners over here, extremely talented lawyers. We have award winners elsewhere. We have extremely talented lawyers elsewhere also. Why is it that we are not in a position to exploit it? Is it because we are bogged down with too many cases? 50 million? Is it because our judges have 100, 200 cases? Is it because our lawyers are doing 10 cases a day or 15 cases a day? What is it? What is it that is missing? And we are not able to, showcase our talent to the outside world. I think we need to think about that. We need to have this outreach and tell the world that, listen, we might be doing very well in terms of economy. We might be doing very well in terms of our legal profession. But it's time that you recognized us. I think that is something which I would request all of you from the legal fraternity to have that outreach, to tell the world that, listen, we have the talent. We have good judges. We have good lawyers. We have good judgments, long they may be. But please showcase our talent to the rest of the world. And by doing that, I think you will be doing a great service to our country. Thank you very much, and all the best to all of you.
To facilitate Justice Lokur, I would like to invite Dr. Anurag Batra, Chairman and Editor-in-Chief, BW Businessworld and Exchange for Media, and Ms. Garima Ahuja, Business Head, BW Legal World. And now, ladies and gentlemen, to deliver the keynote address, please put your hands together for Dr. Lalit Bhasin, Managing Partner, Bhasin and Company.
Honorable Justice Lokur, Honorable Justice Ansari, Mr. Lakshmi Narayanan, my colleagues from the profession, whether external lawyers or in-house lawyers. I don't know why Dr. Anurag Batra had chosen me as the jury chair, because I don't belong to that generation, where we can effectively judge the young aspirants, to get these awards. They should have someone like Mr. Mohit Saraf or Ms. Pooja Sehgal Mehtani, to chair that. Therefore, because our philosophies, our views are quite divergent, I believe in the old school of law. That is why during my remarks, I said that we believe in, as a heritage, consensual form of administration of justice, because this system had been imposed on us. Earlier, we had panchayats, the Zilla Parishads. Even during the Mughal times, you see, there were qazis who used to settle the matters. There was no adversarial system. This was brought in by British, this 3-4 tier system of starting from the lowest courts and then going, you see, right up to the Privy Council or House of Lords and all that. Therefore, as Justice Lokur rightly pointed out, that, I don't know, you said 5 million or 50 million? 50 million. Yeah. I think in crores only, you see. Yeah. 5 crore cases pending. What is the future of litigation in this country? The system has already broken down so far as the citizens are concerned. You have high-profile cases being decided, very well, decide them. What about the justice to the citizens of this country? Our constitution in the preamble says to secure to the citizens of our country, and the very first thing is justice, social, economic, and political. And here, we only talk about law. We don't talk about justice. I think justice has been given a back seat so far as our system of delivery is concerned for the citizens of this country. That is why I propagate settlement of disputes. As Justice Krishna here had said way back in 1981, that a victory in litigation may bring you some superficial sense of victory, but a settlement is the most satisfying form, you see, of resolving a dispute. So that settlement, samjhauta, consensual form, I think that has to be brought in again in our system of administration of justice. And that can start with the law schools and a great responsibility on our general counsel and in-house counsel, that before they anticipate some dispute, you see, going to an adversarial form, going to a court or arbitration, they should try to get the dispute resolved by talking to their counterparts in the other corporate bodies. That is the way out. Therefore, as chairman of the Chartered Institute of Arbitrators, I have made it my mission that so long as I am the chairman, I will encourage mediation. We will train good mediators because this is headquartered in London. We'll get good trainers, you see, to have good mediators. Our judges can be excellent mediators, possibly better than being arbitrators, because they have that background with them, you see. They have seen this fate of litigation. So they're best equipped, you see, to do that. And again, as I say, responsibility on the general counsel and in-house counsel. And of course, we who are the external counsel, we the law firms, should develop that sort of a mindset which is required and not look for litigation. Yeah, litigation does give us a lot of money, lot of work, but then it is not good for the country, for the economy of the country. We should think, you see, beyond. As Justice Lokur said, think of the society. You have to give to the society, you see what the society has given to you, the status, the position, the confidence, you see, which Mr. Mohit Saraf said, it's a respectable profession, of course, but society gives us that. So we also have to give it to the society. So that is my message to all of you. Now, as jury chair, as I said, what was the criteria laid down? Criteria was not laid down by me. It was evolved by our jury members, in the jury we had some of the most distinguished members, you see, of the profession, both external as well as the general counsel. And of course, we had Honorable Justice Deepak Verma also as a part of the jury.
and we had Miss Vani Mehta, Mr. Jatin Jalandawala, Mr. Rajendra Mishra, and of course, Miss Pooja Sehgal Mehtani sitting there, Mr. Nikhil Guliani, Mr. Kaushik Mukherjee, and Miss Roop Lamba. So the test which I applied for myself, and I can share with you that it was a learning experience for me. How it was a learning experience? I was, of course, asking questions, but learning experience was first the exchange with my co-panelists. That itself was learning experience. What do you think? What do you think? What are your views? What are your views? So that exchange of views with the top general counsel and external counsel was a big learning experience for me personally. But also importantly, I wanted to learn from those who were being interviewed by us. Because the test by which I applied was, what am I going to learn from them, rather than, you see, just merely asking them questions. So my questions were formulated in a way that their answers would, you see, enlarge my vision, because they are the present generation, the new generation with new ideas. And I learned a lot speaking for myself, and I'm sure my other jury members also would have done the same, learned the same way. So I have great hope, you see, for the award winners, but that is not the end of the road for you. It is just the beginning of the journey. There'll be many more achievements for you to come. Therefore, don't think that after giving this award, that it is like a lifetime achievement award, you won't get more awards. Even in lifetime achievement award, you see, one gets more. Someone gave me a lifetime achievement award, and I say, I'll come again after 5 years to claim this award again from you. So I think that was a wonderful exercise. My compliments to Dr. Anurag Batra and Garima for organizing this great event, and the interviews were really fantastic. Yeah, Justice Lokur said it was a very taxing job. Taxing, yes, physically. We sat on a Sunday, all the jury members, from about 10 in the morning till I think 7:30 in the evening, interviewing about 87 candidates in a fully transparent manner. Voting was cast. Who will get the award? Who will be number 2? Whether there'll be joint awardees. So all these decisions were taken. So my compliments to the winners, whosoever they are, and please keep the hope of getting more and more awards from Businessworld and from other organizations. Thank you very much.
Thank you, Dr. Bhasin. We would like to take a moment and thank a very special personality for taking out time from his schedule and gracing the occasion. Requesting Justice Iqbal Ahmed Ansari to kindly join us on the stage, and Dr. Anurag Batra to present a small token of appreciation to him. Ladies and gentlemen, let's bring up a very enthusiastic cheer for this moment.
I'm grateful to him that he agreed to come. I didn't know he was not so well, and he went through some medical thing, and in spite of that, he sat through. He's here, he'll give away awards. So my gratitude. He said, I don't want to make a speech. So that's why we are not requesting him. So thank you, shukriya. I know, sir, you're a meticulous man. You called him Justice Qureshi, but maybe in his last life, but it's Justice Iqbal Ahmed Ansari. So just want to say that, so that when you next meet him, you are able to have a conversation. So thank you so much. And, you know, I think we do a lot in this community. We do a lot of initiatives, but I think today I'm going back very happy listening to Mr. Saraf's presentation, listening to Justice Lokur, what do you give back to society? Listening to somebody who started in 1970 and is still active, sir. I wasn't born. You became an IAS in 1970, right? And you're still active. I know how many you're chairman of Shriram Transport Finance Corporation, Rallygear Board. As I said, I did my research on you. So I think you all are, when I grow up, I'm confused, Justice Lokur. When I grow up, I want to be like you or I want to be like sir. But on a serious note, I think it made me think about a few things. And I hope we can improve as a product. And I believe life is about abundance. There is enough. Every media company should do well. We should do our job better. If media needs to do its job better, I think we can do our job better. Our country will do better. And economic disparity matters. As I gave you the boat example, 600 people, but the news died down in 2 days. For 5 days, we were focused on those 5 people. And those lives are equally important. There was an 18-year-old boy in that, apart from the 4 men. But I think economic disparity, the kind that is being created by technology, in terms of wealth being created and people being poor, is very worrisome because it may lead to civil wars. It may lead to pent-up emotions of, I think in legal world also, sometimes the system is such that delays, all that, they help a certain society and it creates economic disparity. Not that they are gaming the system, but the system has become like that. So I think we will need to think deeper about these things. We can only write. We can only give you a platform, the lawmakers. But as the president of the US said, democracy doesn't become democracy by itself. It's for the citizens to make it democracy. No issue gets big because on its own, civil society leaders, media, and common person has to really become an activist and be at it, or a group of people, a community. So I think with Justice Lokur's wise words, I've seen him on TV. I've always thought he speaks his mind with gracefulness. He speaks his mind. He says what he needs to say, but with gracefulness. So I'm happy he's there. Mr. Lalit Bhasin, there's a surprise for you tonight. And definitely I want to be like you when I grow up. I may not grow up, that's another story. But again, if people in the profession listen to what you have to say, I take notes every time you're speaking. I'm taking 1 or 2 points writing. And Mr. Saraf, again, the way you brought out the points on how economy and legal services go together. But what is worrisome is the 5 crore cases. The cost, the human cost, forget the financial cost. Not everything is about money. We don't have to measure everything in money. We don't have to vary in 3 trillion, 10 trillion. I mean, what is the quality of our lives? What is the happiness? What is the quality of relationships? There's a lot to be improved. So I won't stand between that. That's the topic. But I think I am going back very, very invigorated, enthused about the positives and some tasks in my mind as a media product, as an editorial product to take up. And yes, simplicity matters. I think the most beautiful things in life are simple, sir. They're simple, and that's why they're eternal. And that's why they stay for so long. They stay useful not just in, functional terms, but in metaphorical terms. So I think in everything that we bring simplicity in our laws, in our implementation, the complexity helps a certain kind of people. So I think we'll, as an editorial product, we'll take up your suggestions from where you left on, and we can only do what we can do. But I think whatever we do makes a difference. And every media company does good work. Every company in legal publishing should grow. Life is about abundance. There's a lot in the universe. So just want to say that. I think we'll do the first set of awards. Back to you, Saibjeet. Saibjeet doing since this, we started at 11 a.m. Please give Saibjeet a big round of applause. And Garima, Garima last year had 2 people working with her doing this. This year she's done it alone. So please give Garima a big round of applause. Once the awards are over, we are all rushed. And again, it was just Garima's idea to invite Justice Lokur, and I was just saying that what a fantastic idea. Your words of wisdom experience and the examples you gave. I'm sure it will stick in minds of young people and they'll do their job to the society apart from contributing to the growth of their law firms. So thank you so much. Back to you, Saib.
Thank you, Dr. Batra. Ladies and gentlemen, moving forward from the compelling discussions that we witnessed today towards the evening celebrations, I welcome you all to the Global Legal Leaders Awards 2022 to 23. We are gathered here to celebrate and honor the top law firms and legal leaders of legal industry. We would like to extend our gratitude to our esteemed jury. Let's quickly take a look at what they have to say.
It was a great learning experience for me to be a jury of such eminent and distinguished members of the legal profession. The jury members contributed significantly to the selection of the eventual award winners. It was also a learning experience for me for interacting with the participants, those who were shortlisted and those who were eventually declared as winners. Our questions were answered by such great clarity and knowledge by the participants that I really consider that it was a learning experience for me to have participated in this Global Leaders Award function. My message to the winners is that is not the end of the road. It is just the beginning. There will be many more achievements for you in store if you keep on performing your duty, your responsibilities, your commitment to the profession in the right way. Many more awards to follow. All the best to you. Thank you.
Good evening and a very warm welcome to all of you. I'm delighted to be a part of the jury panel for these awards. We went through each of the nominations in a very fair and transparent manner and selected the winners. My heartiest congratulations to all the winners today.
Truly a great experience to be on the jury. Thanks, BW Legal World, for providing me this opportunity. I very proudly say that it was hectic because it was comprehensive, it was extensive, and it was detailed. Each and every entry was evaluated from a multifold perspective. So it took time because we were maintaining objectivity throughout. It was definitely a great learning experience as well to learn from the different perspectives of the fellow esteemed jury members, and also to get to know the vastness of work that's being done in the legal arena. I hope we did our best. being objective, being thorough, and we did justice to all the presentations that were made. All the very best to all the nominees. Being nominated in itself is a great recognition, and many congratulations to all the winners. Truly deserved, and keep up the good work.
It was a truly remarkable experience adjudicating for these awards. I thank BW profusely for this opportunity. The panel was replete with highly talented lawyers, a judge, and GCs from diverse fields. Some of the awards were keenly contested, with nominations from the best in the field. My message to the nominees would be to keep up the good work and remember that everyone is a winner, no matter what the jury has finally come up with, but everybody is a winner. Thank you.
My experience as a jury member for Businessworld was absolutely phenomenal. The fine selection of law firms across the country was a great topic of discussion.
Such a kind audience. Thank you very much. I would once again like to extend our deepest gratitude to our knowledge partner, Lexorbis Law Firm, our event partners, joytravels.com, Fandom, Beanley Coffee, Just Bath AI, The Thick Shake Factory, Reality, Exchange for Media, IWMBuzz.com, Impact and Pitch. Today's award ceremony is being streamed live across all BW Businessworld platforms, including our social media channel, www.bwlegalworld.in. Join the celebration of the evening by using the hashtag BWLegalGLLS and BWGLLS. And before we start with the much anticipated segment, ladies and gentlemen, I would like to request all the winners to kindly get down from the left side of the stage to pose for their pictures for the magazine. And now let's quickly get started. But before that, I need to check the energy in the room. Can we clap and see the energy and the enthusiasm around here? Amazing. To present the first set of awards, I would like to invite Dr. Anurag Batra, Chairman and Editor-in-Chief, BW Businessworld and Founder, Exchange for Media. Please welcome Shri S. Lakshmi Narayanan, Secretary to Government of India, Ministry of Home Affairs, retired. Join me as I welcome Justice Madan B. Lokur, Judge, Supreme Court of Fiji, former Judge, Supreme Court of India. And please welcome Dr. Lalit Bhasin, Managing Partner, Bhasin and Company. And the first category is Litigation Law Firm of the Year. And the award in this category goes to please welcome Karan Jawala and Company. Let's give it up for Miss Meghna Mishra, partner. Well, big thank you to three people clapping in between. Sure.
Hi, good evening, everyone. It's a great privilege to be here, and I'm really feeling very pleased to receive this award, and hope to get many more in the years ahead. Thank you so much.
Moving on to the next category, Competition Law Firm of the Year. And the winner is Let's give it up for Chanyog and Mahajan. Let's welcome Karan Singh Chanyog and Diksha Manchanda, partner. Ladies and gentlemen, I do understand that you all belong to a serious profession, but it is an evening of celebrations. We can spare a few laughs, a few applauses. Thank you.
Today, there's another reason to thank myself for choosing competition as a practice area, because I think as the evening goes on, it's going to get difficult to find new ways to say thank you. But thanks to the esteemed jury, we deeply, deeply value this. And I'm standing in here for a team of very motivated, very skilled, very articulate lawyers who've been at the forefront of some very interesting and important developments in competition law. And we all thoroughly love what we do. But when this comes along, it's such a beautiful cherry on the cake. And it just motivates us to keep going ahead. And thank you to BW Legal World for organizing us. Thanks all. I hope you have a great evening ahead. Hope to celebrate with some of you later.
Well, I thought the speeches will be done by Diksha, but to the jury, Justice Lukur, Mr. and Mrs. Basin, who I think I saw earlier somewhere. Yes, sorry, there's spotlight of BW, Garima, Dr. Batra, Justice Ansari. Very good evening. I just wanted to narrate one thing happened about 5 or 6 years ago. Mr. Rajiv Luthra had gone to meet a very large Indian group. And where he was in that meeting and he was discussing about what legal services that they could help him, he could provide to them. But their general counsel said, yes, we have a lot of competition law cases. So he said, oh, you have a great team, etc., so on and so forth. But so he said, who do you use right now? And he said, Chandok and Mahajan. So I said, oh, you're in much safer hands. And then the general counsel called me and said that, this is what your former boss said about you. And that was the magnanimity of Mr. Luthra. And so this one is for you, boss. Thank you.
Quickly on to the next category. Winner is we also have the privilege of having Mr. Vaibhav and Mr. Akshay here with us.
Thank you very much for giving us this award. I think I'm even more honored to receive this award from this distinguished. I think more important is that we've been as a new firm, we've been there for only 20 months and we've closed deal more than 43 billion US dollars. So I think it's a great thing and thank you very much. And thank you, sir. And thank you, sir, for your simplicity. We have to try to make M&A deals more simple, but we make it very complicated. Thank you.
I would like to thank Dr. Lalit Bhasin for joining us. Thank you very much. And would like to request Justice Ansari to kindly join us on the stage to present the next set of awards. Before I move forward, I would like to request all the winners to kindly stay back till the end of the ceremony for a group picture for the magazine. And the next category is ADR Law Firm of the Year. And the winner is once again, let's give it up for Saraf and partners. Let's welcome Mr. Mohit Saraf, Mr. Vaibhav, and Mr. Akshay.
Good evening, everyone. First of all, many thanks to Businessworld and Dr. Batra. Many thanks to Honorable Justice Lokur, Justice Ansari, and the other members of the jury for having acknowledged and recognized our effort thus far. We, as Mrs. Saraf pointed it out, we've made a very quick sort of growth story for ourselves in the last 20 months. And just when you specifically talk about ADR, the firm started with a very small practice, but today we are looking at almost about 70 lawyers who are just doing disputes practice with about 9 partners. So the firm's sort of growing manifold, and we'd like to just thank everybody which is part of the whole firm and the team that's focused on working on sort of high-profile disputes and strategic disputes. And also I'd like to specifically acknowledge the role of all the clients that have reposed a lot of faith in us. And so we're just, reinvigorated with more and more courage to keep on performing with the same degree of passion. Thank you very much.
I'll just add one line that I was basically a corporate law all my life. But when we started the firm, I told Vaibhav and all my partners that this firm, 50% of the revenue and growth will come from litigation and arbitration. And that time we were 3 partners and 7 of us. I think this has been the most phenomenal growth of any practice area. And I believe that unlike what we have to do, we have to grow the economy and the dispute will happen and a lot of changes have to happen. So this is a practice which will grow phenomenally well. I hope the law system improves, that disputes get resolved, and therefore economy grows. But this is actually a huge potential. And this is an area where nothing can be cut and paste. That's an important thing. And I think what is important, what you said, that we have to learn to make simple, impactful petition than repeating the same thing 200 times. Thank you.
Quickly on to the next category, Intellectual Property Law Firm of the Year. And the winner is Intel Advocate. We have Dr. Vishal Tripathi, Associate Partner, accepting the award. Ladies and gentlemen, let's bring up a very enthusiastic cheer for the winner.
Award is basically a synchronized team first and good leadership. Thank you so much.
With this, we are now moving on to the next category, Banking and Financial Services Law, Firm of the Year. And the winner is Let's give it up for SNG and Partners, welcoming Somajit Mitra.
Good evening, everyone. It's been an honor listening to everyone. And thank you, BW Businessworld team. Thank you both as well. And thank you to the esteemed jury members for honoring us. Thank you so much.
I would like to thank Justice Ansari for joining us on the stage. And to present the next set of awards, I would like to invite Mr. Amar Kumar Singh, General Counsel, Senior VP Legal and Communications. Same category, the category of banking and financial services law firm of the year, and another award in this category goes to let's give it up for Saraf and Partners.
For this recognition. Thank you.
On the banking side, we actually help banks give loan, and then we help clients take them to IBC and recover loan. And so we actually do a start to finish job. So we are a full service from that point.
We shouldn't be talking about this. I'm very touchy about haircuts. If you get what I'm saying, you know. But there's a dinner and drinks, but only for the people who clap for the winner. There are cameras there. Can you clap for Saraf and Partners? Thank you.
Dax Law Firm of the Year. Ladies and gentlemen, the winner in this category is let's give it up for Nitya Tax Associates, and we have Asmin Mangla. Let's give it up for Asmin Mangla.
Yeah, good evening, everyone.
So it gives me an immense pleasure to take this award on behalf of my firm. So with GST growing every day, I think it's interesting times for tax world and the tax lawyers. And at Nitya, we just ensure that we stick to our basics. One is doing our work with 100% integrity. And second is that every day we are able to add value to our clients. And third, that we are able to create a happy and healthy environment for our team members. So yeah, many more to come. Thanks.
The next category is General Corporate Law Firm of the Year. And the winner in this category is Let's give it up for Luthra and Luthra Law Offices, India. We have Shinoj Koshi, partner, accepting the award.
Okay. In keeping with the theme of this evening, I would keep it simple. First of all, thank you to BW Legal and the members of the jury for recognizing our efforts. And a big thank you to all our clients. But I would like to dedicate this award to Mr. Luthra and every single partner of ours who works dedicatedly to make sure that we create value for our clients, keep it simple, and keep the transaction cost low so that we are enablers of the growth of this economy. And the externalities of this growth will actually lead to contributions to the society. So that's our effort here.
With the same, I would like to thank Mr. Amar Kumar Sundaram for joining us on the stage. Thank you. And to present the next set of awards, please welcome Ms. Neena Gupta, Senior Partner, Bhasin and Company. The next category is the Real Estate Law Firm of the Year. And the winner in this category is a big round of applause for Law Assist. Let's welcome Purnima Rangnath, founder and managing partner.
And at the outset, I thank BW Legal and the entire jury for considering for the award. Firstly, I come from Bangalore. I find most of you here are from Delhi, Bombay, and other places. So I think this is a great honor that a Bangalore law firm has been awarded like this. And then I really attribute the whole thing to all my colleagues in my firm and to all the young professionals who came to Bangalore to make it their home and then made the real estate boom in Bangalore and made us come to this position where we are worthy of this award. Thank you once again.
Category Financial Regulatory Law Firm of the Year. And the winner in this category is Let's give it up for Red Street Law Advisors. We have Mr. Sumit Agarwal accepting the award.
Thank you, BW Legal. Thank you, esteemed jury and esteemed gathering. We are a bunch of lawyers who started a couple of years back. We were the regulatory officers from SEBI, stock exchanges, PFRDA, and IRDA when we started this financial regulatory practice. At our firm, our core is that we try and put the balance between the regulator and the regulated, and we represent both the financial regulators as well as the regulated entities. And in last couple of years, we've achieved a lot, and we also look forward to achieve further. And we are grateful that this esteemed jury, as well as the BW Legal, recognized the tireless efforts of our team. Thank you very much.
I would like to invite Ms. Garima Ahuja on the stage to present the next award. Ladies and gentlemen, every award in its sense of the category is important, unparalleled. But the next award, well, you can say that I like to view the climax before the ending of the movie. This award is being presented to a personality who has more than 5 decades of experience, recognized internationally. He received prestigious awards for his exceptional service to the legal profession and contribution to the rule of law. Holding various significant positions in the Bar Association of India, Chartered Institute of Arbitrators, Committee of Legal Services and Business Sectors, his expertise extends from chairing esteemed organizations to being a respected member of international arbitration bodies. Ladies and gentlemen, I must request everyone to give a standing ovation as we deliver the Lifetime Achievement Award to Dr. Lalit Bhasin. A louder round of applause. Come on, everybody, let's give it up.
I have received many awards, some lifetime achievement also. But this award has a special place. You see, although at my home, in my office, there is no place now. And my wife, Nina, keeps on complaining, you're getting so many awards, where would I keep them? But then she places them, you see, in the gallery of awards that we have. But I can assure you that this particular award is not a part of the jury selection. Am I right, Pooja? Yeah. This has come as a surprise and it will have a very special place, you see, in my heart, not just in my home. And I thank the Dr. Anurag Batra and Garima for giving me this recognition. Thank you.
But I must say, this is not the last. After 5 years also, we will call you. And may God give you long life and healthy life. And may you...
And I'm looking for a bigger office now.
I think Justice Lokur wants to go. So we'd say, and Sir, or you also. So thank you so much. Please give Justice Lokur. He's given his time, attention. He's added to the content by his very thoughtful words and very encouraging. Thank you so much. We're grateful beyond words. And as I committed, I'll make sure a copy of that book comes to you. In fact, both, if you haven't read the first one also. Both are lovely. You can just, thank you. Please give Justice Madan Lokur a big round. And thank you so much. I'll come and see you. I'll come and know it's basic. Also give our guest of honor a big round of applause. Again, he's made time, said the right things, gave examples. Sir, I'm right next to you.
Dr. Batra.
And to present the next set of awards, I would like to invite Ms. Pooja Sehgal Mehtani, General Counsel and Company Secretary, Sun Life. Restructuring and Insolvency Law Firm of the Year. And the winner in this category is Let's give it up for Chandyok and Mahajan. We have Karan Singh and Mahima Singh accepting this award.
Good evening, ladies and gentlemen. On behalf of the entire restructuring and insolvency team at Chandyok and Mahajan, I would like to express my deepest gratitude to the distinguished members of the jury and the BW Legal World team for this incredible honor. I would also like to thank our clients for the trust and the faith that they've reposed in our work and our abilities. We are immensely grateful for the love, the support, the best wishes that we receive from our families, our friends, and our colleagues in the legal fraternity. Last but not the least, I would like to give a big shout out to the incredible team led by Ms. Pooja Mahajan for their tireless efforts and unwavering determination to provide quality, innovative, and integrated legal services to our clients. I would just like to conclude by saying that this award means a lot. And it is truly humbling. It's a truly humbling recognition to our hard work and commitment, and only strengthens our resolve to keep outperforming ourselves and do even better. Thanks a lot once again, and have a very good evening, everyone. Thank you.
And to present the next set of awards, I would like to request Dr. Lalit Bhasin to kindly join us on the stage. And the next category is Technology, Media and Telecommunications Law Firm of the Year. And the winner is ladies and gentlemen, let's give it up for TMT Law Practice. So we have Mr. Abhishek Malhotra accepting the award.
So when I started this firm in 2008, the only thing that was very popular as TMT was TMT Saria. But thankfully, I'm very happy to note that 15 years hence, it is not just recognized as an individual specific practice area, but that we've been able to be the flag bearers of that. Thank you very much to BW World for this. And thank you so much to the jury for recognizing us. And thanks a lot to our clients as also the team. Thank you very much.
I just want to say that in 2000, I founded Exchange for Media. So for me, TMT, I understand what is TMT. And I can tell you that I met you for the first time, but I know because of my work in that area, which is my first company, I do know about your firm. So congratulations. And I also want to say tomorrow is the second edition of our BW Legal World Law School rankings. And that's again here. We start at 11:30 a.m. Garima does events on Saturdays, and lawyers are only free on Saturday, Sunday. We have an exciting lineup for those of you. And in the evening, we have our law school rankings. 9 July is our GC 100, which is our biggest event. And I'm sure we'll invite Mr. Bhasin, and hopefully he'll be able to take some time. Of course, Ms. Mehtani is speaking at the event, and you have another 64 GCs as of now to confirm. This is at the Meridian. So I just want to, attention is a very big currency and sometimes it's missing. So I'm just saying that so that it stays in your mind. Back to you, Sahibji.
Well, as I remember Dr. Bhasin mentioning in his Jury Speaks video that this is not the end, this is just the beginning. And in a sense of that, tomorrow we host the Future of Legal Education Summit. All the winners around here are invited to educate and be a part of the future. With this, we are now moving on to the next category, Startups and Investments Law Firm of the Year. And the winner is let's give it up for Let's Start Partners. We have Miss Anisha Patnaik, founder, accepting the award. Ladies and gentlemen, let's give the ladies a huge round of applause.
Thank you so much, BW. Thank you so much to the jury.
8 years back when I decided to start Start, and I said I'll focus on startups, everyone told me I've lost it because startups back then were not a buzzword. So I was told I'm committing a career suicide. And so it's an immense honor that on the 8th anniversary of Start, we get this award. It's a huge validation of the fact that we are doing something right. So thank you so much.
And with the same, I would like to thank Ms. Pooja Sehgal-Mehtiani for joining us on the stage. And to present the next set of awards, ladies and gentlemen, please welcome Shri Pramod Dubey, Senior Advocate. All right, we're getting up with the categories now. The next category is Most Innovative Lawyer of the Year. And the award goes to Ms. Radhika. Heartiest congratulations to her. Unfortunately, she is not here with us, but we do have a very special virtual message from her. Let's quickly cue it.
This is Radhika.
Allow me a moment, please. Ladies and gentlemen, it seems like we're experiencing a slight technical glitch. We shall play the video in the later parts. Quickly moving on to the next category, Best IP Lawyer. Well, it is important. She did win the award and did send a message. Quickly on to the next one. The next category is Best IP Lawyer of the Year. And the winner is heartiest congratulations to Shivarti Bajaj, founding managing partner, RSD Bajaj Global Law Firm.
Thank you, everyone. The eminent jury, which I can vouch for, was very strict. BW, Dr. Batra, and of course, my team at RSD, Varun, and my parents. Having watching the IPR realm for the past 15 years, receiving this is an interesting acknowledgement of the same. But I feel with the advent of the new age economy and the creator economy, including pharma, biotech, etc., we are in for very interesting times and judgments in this field, and I look forward to contributing more. Thank you.
Quickly on to the next category, Best Tech Lawyer of the Year. And the winner in this category is Ladies and gentlemen, let's give it up for Mr. Vaibhav Kakkar, Senior Partner, Seraph and Partners.
Thank you so much. Thank you, Businessworld, and thank you to the esteemed jury. Just want to acknowledge the faith reposed by a number of clients in us. Technology is one area where law is always catching up. There are amendments happening every few weeks. The regulators are trying to plug regulatory arbitrage and regulatory gaps every now and then. So as lawyers, it's tough, but at the same time, it's extremely exciting. We've done some very interesting work, particularly in the space of fintech, as well as gaming sector. Awards like these, give us the fillip and the confidence to keep at it. So this is one goes to the entire team that supported me in this endeavor. Thank you very much.
Well, this is quite the competitive category. So we have 2 winners in this category. And the next winner for the Best Tech Lawyer of the Year is once again, let's give it up for Ms. Shivati Bajaj, Founding Managing Partner, RST Global Law Firm. Ladies and gentlemen, we are headed towards the end of the evening. A few awards to go. I must encourage everyone to give a huge round of applause.
Thank you everyone once again. For the sake of brevity, I will just thank my very wonderful team, clients, and of course Varun for his 2 AM it's an honor to receive this from a very eminent jury, and the Q&As were tough, I must admit, and I look forward to contributing and working more in this very upcoming age of information and technology. And thank you everyone once again.
Moving on to the next category, the Best Real Estate Lawyer of the Year. And the winner in this category is let's welcome Sooms Devan, the Managing Partner, Lex Fabius.
Hi, everyone. Thanks a lot. Thanks, jury. Thanks, Business World. It's an amazing honor for us and a great validation. I'd like to dedicate this award to our clients and my team at Lex Fabios, without whom it would not have been possible. Thanks, everyone.
My life as an entrepreneur started with a lawyer giving me a 70 lakh check. He promised 70, he's only given me 68 in 2000. And yes, I started my journey with a lawyer giving me 70 lakhs. That's the truth. He promised 70, gave me only 68. I showed up at his birthday 15 days back and said, "Uspe ab kitna ho gaya?" But Sumesh is again one of few people I met, maybe 98. He's been a friend of mine, and He's very close friends with my family. And, over the years, I've worked with him. Though I have no role, Mr. Bhasin decided. I was not on the jury. So I just feel happy for Sumesh and, yes, whoever the jury members decided, that's for you. So it feels good when somebody who, I've known him for almost 25 years, one of the few people in the room. So happy to see Sumesh doing so well. Congratulations, Sumesh.
And with the same, I would like to thank Mr. Dubey for joining us on the stage. And to present the next set of awards, I would like to invite Mr. Shashank Bajpayee, Advocate, Supreme Court, Managing Partner, Vardharma Chambers. Well, I would like to address the elephant in the room. Yes, we are headed towards the end of the ceremony. Only a few awards to go. Let's keep up the energy. And the next category is quite an important category. The category is Emerging Law Firm of the Year. And the winner in this category is ladies and gentlemen, the Emerging Law Firm of the Year is RSD Bajaj Global Law Firm. Please welcome Mr. Varun Bajaj and Ms. Shivarthi Bajaj, Founding Managing Partners.
So I think sir has not only given me an award, he's given me a tip also that you go global. And I think that's the vision. Shwarti and me, I see ourselves not as lawyers, but as entrepreneurs. In a time when we both are first generational lawyers coming from a defense background, had nothing to do with the legal industry. 15 years, we created this firm after working with top firms like Amarchand and Remfry. And I believe in what Mohit sir said, India's time is here. And I think this is the time. Our story is truly India's story, that you can come from no background in this market and create a space for yourself. I think we have just started. There are a lot of variations which are going to kick in, but I think India's time is here and we will like to ride that growth. Just to end it, I like to end it with one quote, that आंधियों की जहां आंधियों ने जहां हिम्मत की है बिजली गिराने की, हमने भी वही ठानी है आशिया बनाने की. So thanks a lot to all the young guys who want to disrupt. We are creating a young team. We are open to any recruitment.
You see, what prevailed with the jury was not just the recognized and established law firms, but we wanted to give encouragement and recognize the young law firms, the emerging law firms, the new law firms led by comparatively young people, full of energy and initiative. And I really wish that you should go global, commensurate with your name. You see, do that, go global. Thank you. And जो आपने बोला, उसके आगे मैं भी बोल दूं. तेरा हाथ हाथ में आ गया कि चिराग राह में जल गए, हमें सहल हो गई मंजिलें कि हवा के रुख भी बदल गए.
I think I've got my tip of the day. Thank you, sir. Thank you, everyone.
Although I'm not allowed to have any categories. The next category is a Woman Lawyer of the Year. Ladies and gentlemen, the winner in this category is Let's give it up for Miss Asmi Mangla, Associate Partner, Nitya Tax Associates.
For creating and running this platform year on year, recognizing and appreciating talents like us. And I think I was fortunate enough to be able to start my professional journey at the same time when India's biggest tax reform was taking birth around 2016-17. So I was able to get the opportunities to grow in double, you can say double speed. And since childhood, I have been following film fair, so I will not leave the stage before giving thanks to the relevant people because of whom I'm here. So of course, my parents who are trying to capture me, even though I've told them that everything is getting recorded. And my teachers, my seniors who have shaped me so that I can stand here and receive this award. Thank you so much. Thank you, everyone.
Believe me, we all have practiced this in the shower or sitting on the sofa waiting for to board a flight or somewhere or the other place. Congratulations to you. You deserve it. Let's give the lady a huge round of applause. Come on, everyone. Fortunately enough, we have another winner in this category, and the Woman Lawyer of the Year is... Let's give it up for Anisha Patnaik. We have Mr. Anisha Patnaik, founder, Legstart Partners.
Thank you so much once again to BW, the jury. A huge thank you to each and every member of Legstart and their family and all our clients who actually impose their faith in me. Thank you so much, everyone.
With the same, I would like to thank Mr. Bajpayee for joining us on the stage. Dr. Batra, Dr. Vaseem, we have 2 more awards to go. And to present those awards, I would like to invite Mr. Tarun Nangia, Associate Editor, NewsX. With a round of applause, of course. Come on, everybody. Woman Lawyer of the Year is quite the tough category, not 1, not 2, but we have 3 winners in this category, and another winner is... Heartiest congratulations to Purnima Ranganath, founder and managing partner, Law Assist.
Ellarigu namaskara from Bangalore. So, at the outset, I thank BW Legal and the entire jury for considering me for this award. I also thank my parents, Mr. Rangnath Rao and Uma, for joining me to National Law School when it was not even clear whether it would be set up, 1988, I should say. Then I like to thank Professor Madhav Menon, who instilled in me that law is not merely a profession, but a passion to be followed. And till date, even after 30 years, it keeps me running. I also thank my husband, Dr. Satish Chandra, my daughter, Vaishnavi, my colleagues in the firm, and all the clients for the last 20-25 years who stood by me and helped me to render my services. Thanks to one and all. Thank you.
And to present the last award for the evening, please welcome Ms. Karima Ahuja. All right. The final category, Managing Partner of the Year. And the award in this category goes to well, let me remind you that there is only one winner in this category. And the managing partner of the year 2022 to 2023 is Manisha Singh, partner Lexovis.
Now because it's the last one. Thanks to everyone for the patience and joining in till the end. And thanks, it's a very unique award because as you know, this business world is all about the major corporate practices, and IP continues to be in its own way a very niche area of practice. We started in 1997. We are almost 300 people with working only on brands and innovation. And I always say that from the typewriter to the AI, now is the time. And have a lovely rest of the evening. And thank you very much. Thanks to the jury always. Thank you, sir. Thanks, Tarun. Thank you very much.
Before I thank our presenters and ask them to settle down and have a merry time with the audience, we do have one more thing before I can thank you. The category of Most Innovative Lawyer of the Year. And the winner is well, heartiest congratulations to Radhika and Ludhat, the partner, Shardul Amarchand Mangaldas and Company. Well, here we have Garima ji, particular to every detail. Let's quickly take a look at the virtual message by Radhika.
This is Radhika Dudhat from Shardul Amarchand Mangaldas. I'd like to thank BW legal team, its jury, to have awarded me with the award of the Most Innovative Lawyer of the Year. I am most grateful for the same, and I look forward to continuing to contribute to the clients in a meaningful way. Thank you.
And with the same, ladies and gentlemen, we come to the end of a very productive and a very celebratory day. Heartiest congratulations to everyone. Big thank you to our partners, to our associates, to the jury, and to the participants. With the same, requesting all the winners to kindly join us on the stage with their trophies and trophies only for a group picture. also requesting the respected jury to kindly join us on the stage for the group picture. Respected jury and all the winners with their trophies on the stage for a group picture. And to double the celebrations, kindly join us for dinner and drinks. Post this, so with the same, this is your hostess, Sahib Jeet Kaur, on behalf of BW Legal Single Time. Well, a group picture implies that it would require everybody in the group.